Yes.
Let's do it. Okay, it is October 10th at 9. Meeting to order. Online, can everybody hear us online okay? Give the thumbs up, Darlene, if you can hear us. All right. So we have an exciting, very exciting meeting today for many different reasons. I think today's materials and what we're going to be discussing highlight the really the complexity of what we do on this committee. The comments that come back, that things that may be abundantly clear to some of us may not be as clear to others. And what's in a lawyer's brain may not be in the practical boots on the ground broker's brain and how it actually works. And so I'm particularly excited to go through some of that today as we go through the materials. But first, it's really exciting because we have some new members. And this is, since the last meeting, we've had 2 new broker members that were appointed and 2 new attorney members. So I thought today, like usual, we can start with introductions and to go around the room to start with our new members that we have here in the room. Candy Loonsman, if you can introduce yourself and give a little bit of your background.
Sure. Candy Linsman. I am new broker member from Gatesville, Texas. Claim to fame is TDCJ and Fort Hood. So we're right in the middle there. So I am broker member, independent broker, small brokerage, and very excited to be here with you guys. Hope to be able to contribute.
And you've been on ESAC?
Yes, I was on ESAC I was in the middle of my second term and then jumped over to broker lawyer with you guys. So, yeah.
Awesome. So we're very excited
to have
to have
one or the other?
Well, I chose to do one.
Okay.
We have so much fun on this committee. I don't need y'all anymore. No, we're excited to have you and everything you bring to the table. And then online, we have Kristen Porter, who's appointed on the attorney side by the state president. Kristen, if you can introduce yourself to everybody.
Hi, I'm Kristen. I work in New Braunfels. I do a lot of residential real estate, a lot of on the developer side, but also on just my client side. And I had hoped to be there with y'all today in person, and my car decided to overheat yesterday. So hopefully I'll get to meet y'all all in person next go round.
Definitely look forward to that and appreciate you making today. It'll be exciting to work with you. Heard a lot of good things about your practice and what you can bring to the table. So we also have a new attorney member, Kenneth Vowles out of Laredo. He's actually in a State Bar Forms Committee meeting this morning, and so he'll likely join us this afternoon by video. So we'll wait to do a full introduction of him until then. And then our 4th new member and oldest member, or longest serving member, not oldest, longest serving member. Ron, why don't you introduce yourself?
Yeah, Ron Walker, oldest looking member here. Glad to
Which committee will do it to you?
glad to be back around. Yoda.
So, and of course, everybody knows Ron's co-chair on the broker side, and is now serving in his 19th year. Yeah.
Wow.
Well, excited. So let's go around the table. Melissa, we can just introduce ourselves.
Sure. Melissa Haley. I am from the Dallas area and I am a broker member.
Diane McCoy, I'm Houston, and I'm a broker member.
Tony Malley, and I am an attorney member out of Beaumont.
Christy Tatum Jansen, broker member out of the Waxahachie area.
Mary Miner, broker member out of the Austin Leander area.
Late Rizal, attorney member, Austin.
I'm Brian Watts, attorney member, Dallas, Texas, with First American Title.
And Darlene?
Darlene Fairchild, I'm the public member. I'm from College Station.
For all of our new watchers, we have 6 lawyers, 6 brokers, and 1 public member. And the public member is appointed by the governor. And I'm John George out of Friendswood, south of Houston, attorney member. And with that, let's go with our guest here today.
Tracy George.
Good morning, Corey Connor. I'm with Texas Realtors.
I'm Linda Watts. I'm just a +1.
The power and brains behind Mr. Watts here.
Keeps me honest.
Don't talk to her.
I'm Lena Sims. I'm a broker over in Houston for All City Real Estate.
Awesome. Welcome.
Aaron Day, Texas Land Title Association.
Chelsea Buckholz, Executive Director for TREC. Vanessa Burgess, Deputy Executive Director for TREC.
Abby Lee, General Counsel for TREC.
Bernie Ramirez, and I'm Assistant General Counsel for TREC.
And I love having everybody do their own introductions because I've seen how much the titles have been butchered lately. So we can all give our right titles.
Yes.
But no.
If anyone's wondering, who's in the corner, Sierra handles a lot of our social media and communications along with Summer Mandel. She's documenting this today.
She was on the videos, right?
Yeah, she's
She's the video. Okay.
All the new social media that TREC is pushing out there is been fantastic. And Sarah has a new video series called From the Case Files, which really ties into some of our work and how we try to draft things there. But she's highlighting actual cases from enforcement and doing summaries of those in a very professional video that's being produced. So it's going to be awesome. The first one, I think, the introduction videos out there. Yeah. So that's been great. And also for a quick plug, the new legal updates instructor training has started. And the whole team has done an excellent job drafting. We've had our first actual session in San Antonio.
It was big. It was large.
I think we had 760 something.
We're full, I think 60 something, yeah, maybe 65.
If you're interested in teaching legal update, all but 2 of the classes have sold out. So there's only 2 last I checked that still have availability. So if you haven't signed up yet, it'd be good to sign up quickly for that. And that's been a lot of fun. And I think that's all the updates I have. There's a lot of staff for everybody that's watching behind the scenes that helps make all this work. And we, even though we don't mention them by name, we were very appreciative of all the efforts that they do for us. I do have one more plug. So 3 awards, the Rello Awards, were awarded for TREC as well. We had the Investigator of the Year was awarded to Jenna Hall. Very exciting. She actually attended our legal update training and provided some good guidance in how TREC actually looks at some of these things and her investigative efforts. So no, you can't hide from anything. We had really good investigators back there that makes it important for you to follow the rules. They also had the Video Series Award for the 75 years of TREC. So those videos that they've been putting out to show the history, long history of TREC. Those are really good videos that if you haven't watched would be really good too. And then the third award was for course development for the 2025-2026 broker responsibility course. So they had three big awards that I think Jennifer Wheeler went to accepted here recently from Arella. But it's been an exciting year on that front. So with that, we'll jump right into the agenda. Agenda item number 2, opening remarks. Actually, agenda item number 3, public comment on non-agenda items. Do we have any public comment on non-agenda items? Nope. Okay, so we'll move right on to agenda item number 4, report by BLC working groups. And I thought we could start with the closure working group. If there's any.
No, nothing from, except for the, what we'll talk later on the agenda items.
I think same for the backup and the buyer's reps, I think ties in all to the other materials. So I don't believe any other working groups met. So if not, we'll move forward to agenda item number 5. Agenda item number 5. The materials for this meeting weren't numbered. So as we discuss them and call out numbers, maybe call out numbers of the PDFs. There I have printed versions, so I might be a little handicapped when going back and forth. We are going to start on what is page.
It's page 2 for the Sledge Law Group letter.
And this ties into Brian Sledge, the Sledge Law Group, wrote a letter to the committee. For background, Brian Sledge is one of the driving forces behind the water language that we have, and he provides a water disclosure language that we have now. And he provides a little bit of a history of how long that has been worked on. This has been an effort for, I think, upwards of 5 years. That was originally brought to the table by Charles Porter, or suggested by Charles Porter. And it's been worked and reworked and analyzed, and I was excited to see it go out there for public comment. And what Brian writes in on behalf of his law firm and the clients that he represents, including the Opportunity GCD, the Prairie Lands Groundwater Conservation District, the Benbrook Water Authority, they're writing in support of the changes. They think the changes are help provide clarity when there's lack of clarity in deeds and leases, when the lack of clarity in TCQ enforcement actions. He believes the language is that a lot of people are simply just unaware of the legal rights and obligations of water rights. And that some properties, especially this will help highlight when properties can't get water in certain circumstances. So he highlights his history there and why he's in support of it. And ultimately about striking the proper balance by providing simple language and a checklist for disclosure in the vast majority of real estate transactions. Anybody have any comments on Brian's letter? I will say, just personally, he put a lot of time outside of these meetings into this. I know to the group, to Ron and me as chairs and as individually, and he's actually shown up to conferences to speak on this and has really been invested. We have another letter from Texas Water Association.
Page 4 on the PDF.
Page 4 in the PDF, if you're following along. The Texas Water Association is a nonprofit policy association advocating for the Texas water industry. They represent a broad scope from river authorities, municipalities, groundwater conservation districts, and all different types of organizations and water users as well. They write in favor of the changes. They highlight the concern with the population is outgrowing our ability to get new water supplies. And so in addition to the confusion today, they're seeing more confusion tomorrow, especially as water becomes more and more scarce. So they think the form changes can help trigger an investigation into buyers that may not be thinking about water rights and potentially solve and mitigate future legal disputes. So they write in favor of the.
I'll just comment, two AI data centers use more water than San Antonio will at once. So it's not, I'm being snide, but it's not really just the people and the growing population. It's these enormous data centers that are literally sucking water out of everything.
And that's only going to.
Yeah, they keep building new ones. To get 100 jobs, then your whole city's not going to have any water.
Good point. And so they're in support. We'll get into the details of the language because we have a lot of comments that come on that. We'll go forward there, but they are in support of the changes. And we get to the fun part of our meetings. We appreciate all the feedback we get. We're moving into what will be page 5. Five on the PDF of all the comments that were sent in. We can't do this without the comments. There are a lot today that are duplicative, I think, with how it was put into the system. And so they make a comment on one form and the same comment applies to other forms. So I try to do my best when we go through these to cancel out those duplicates. So we'll jump right into Denise Aske. Is that how you pronounce that? And please forgive me. I'm sad.
Vicky French.
Vicky. Oh, I had the wrong set of. I have number 7 in front of me. Thank you for keeping me straight.
I was confused. I was like, did I?
Yeah, we have a separate set of. Number 5. Now page number. My mind was there. It is. It's separate. Okay, so Vicky French, and Vicky French made lots of comments with us today. This is one comment there that we'll have is looking at the water disclosure language in the new paragraph 7. We've added what amounts to a couple inches of information to the paragraph itself, and it's a general comment about it being too long and confusing. I think when we get into some of the more detailed ones, we can go into the actual language, but we have several that have indicated it's too long and confusing. From Kelly Packer, she writes in about paragraph 12. And this was one, she believes that the words not to exceed will bring ambiguity into the compensation paragraph, and that it makes it that it should be a definite certain amount. This is where I think the magic of our committee comes in. In looking at this from the lawyer side and the history side, I didn't see this coming. I didn't anticipate this at all. And when I looked at it at first, I'm like, wow, that I can see the confusion. And from the legal perspective, I think it's, I'll get into reasons why we did what we did, but I think it's legally solid, but clearly there's confusion on the ground. And what we're faced with is we made a change that we thought would clarify it, and it confused others, but how many are still confused by the original language? And so how do we draft language that will be the least confusing of all, and where do we draw that line? And I'm not sure we really focused on that not to exceed language last time. I believe looking at this other language. And to set the stage, paragraph 12A1B is an amount that the seller can contribute towards the buyer's broker fees. But we set a cap. We wanted to set a cap to address the law that is out there saying that a buyer's agent cannot accept more than what is in their buyer's rep, which is from the NAR model policy, MLS policy rules, which the vast majority of agents, a good percentage of agents in Texas have to follow, right? So in trying to streamline and make the agreement simple and understandable, we try to set a cap, and the language before was confusing with that buyer has agreed to pay at the end. Now we added that not to exceed language to try to simplify it, which was borrowed from C. That not to exceed was always in 12A1C, and it never was brought up, and I think that as being an issue. So I think when we drafted this last time, we didn't consider that, right? And really didn't think about it.
You want me to pull these up?
Yeah, if you can pull that up, that'd be very good.
And I was going to mention, Amber has actually re-uploaded the document and added page number. So if you do have it online, you could click on the link again and it will have page number. Sorry about that.
So we'll pull the language up on the screen. And as we're thinking about this, I'm going to tee it around the room. This I really see as not so much a legal issue. I think the legal opinions too, but the language is drafted in a way I think that is legally tight to accomplish our goal of allowing a seller to contribute a certain amount and having it be capped by an amount that the buyers agree to their agent. But it's not being interpreted like that in the field. At least with these comments, about half our comments are on this being confusing. Now,
The question I have is, okay, the new law, they're going to have, not farm and ranch, or is it everybody that has a buyer's rep agreement starting in January?
So we have two different things. We had the NAR one that we were trying to address before.
That was right.
And now with Senate Bill 1968, you have a residential real estate requirement, which is a single family home.
So it's not affecting, that's what I'm saying. It's not affecting her in farm and ranch. But
it could, right? So you could have a single family home and farm and ranch. So that's not a bright line, but so it possibly could.
I'm just wondering if you have the buyer's rep, then there's not, I don't know if the not to exceeds an issue. I'm wondering if some people are not going to have those.
Well, it becomes an issue with the X amount is in the buyer's rep. Let's say you have 10 in the buyer's rep, but then in here you put 15, right? In the contract you put 15. The buyer's agent can't accept that 15.
Right.
They
right.
are capped by that.
I agree
10.
with that.
So that's the language we're trying to craft around, is to make sure that even if more is stated in the contract, they won't collect more than what's in their buyer's rep at the end of the day.
And she's saying she doesn't like the not to exceed. I don't get it.
I think what I read in the comments was the vast majority of people felt like this was going to leave their compensation up to interpretation all the way through the contract, not just at the beginning when they're negotiating the deal, that they're like, oh, well, now I still I still have my compensation that my buyer is responsible for. And you're giving the seller an out to change that number, even though the buyer has requested that. So I understand like not to exceed where we came from, but I think that the concern is from the comments was it leaves it to negotiation further along in the contract. That was the sense that I got.
And you know, as
Our argument about it. Yeah, absolutely.
and as a broker, I think that's okay. Because I sit there and I go, a lot of them just expect a certain pay and they've done nothing. And we've all had the other side of doing nothing. So I think it's more negotiation on the agent side to understand we have to put a good offer together to get what we want.
Mhm.
You know what I'm saying? So I don't know.
I don't think the contract is the place for the negotiations at that point. That should be outside of it. I totally agree with Melissa said. I think we were concentrating on how to make the clarity that the intention of 12(1)B was to talk about the broker compensation, buyer compensation, and miss that. I mean, when I saw it, I was shocked and I was in the room. And the idea of not to exceed is opening it up to negotiation in the field. And what we were trying to do is to make it clearer for the buyer and the seller and what they were being offered, a figure, as it had been before, an amount, a percentage or of the sales price to be applied to. C is talking about something is going to be changing because of closing costs. Here we were trying to help the agent in the field have a clarity on what was the seller being asked by the buyer to contribute toward that buyer broker compensation period.
But it is negotiable. That's what this is our whole thing.
Contract.
In the contract, it is negotiable. If I say the house is, I offer 50,000 below list, right? And I want 20,000 in closing costs. And oh, by the way, I want whatever in paragraph 12, right? I, as an agent, yes, I'm doing what my client wants me to do, but I'm knowing that the net is not gonna.
I think all that's background that happens before the offer is submitted or after. We need to be clearer.
I think
So you go-
it's two things. So
Go,
the
Brenda, you first, next.
seller doesn't have any visibility on the buyer rep agreement. And so if we put something that allows for flexibility, they're not going to see it anyway, right? And the responsibility of not collecting more than they're permitted to collect sits on the buyer's agent only. It's not really a contract matter. The contract's buyer seller who's going to pay what.
Yeah. Well, and this gives the seller clarity on the amount, like this is the amount or,
Yeah. Chrissy, so yeah.
Is nicely up. I'm going to say, so I had some other people come to me and give me comments. They didn't send in comments in the agenda, but had mentioned something prior to these coming out. So to see even more comments underscored that it's not understood. And I agree. I wasn't thinking about the not to exceed. And contract negotiations are done. And then once they're done, the contract documents what was negotiated, and that is it. And if a change is further negotiated, then that's what we have amendments for that document that.
Right.
And there would be a place to renegotiate that. I do think the not to exceed and the manner that it's being interpreted is going to create issues. And it does, the intent was that we clarify that it is the seller paying X amount or percentage to buyer brokerage fees that they have. And I think it needs to be that set amount. And that's what I'm hearing in addition to what was in here from people who've come to me and said, hey, that's concerning on the interpretation because it should be this amount that the seller is paying, period. And if it's renegotiated, we'll do that through an amendment, not leaving it open.
What's the difference, and we've got Candy here, what's the difference now versus that an amount not to exceed that was in C for a long time? And is it, I notice the focus here and everybody then starts looking at it. I think that's what it is.
That's what I was going to. So in C, closing costs change. So let's say we have $10,000. If the buyer only needs $8,500, that seller is only on the table for $8,500. So it's that not to exceed 10, we're only paying the $8,500. What I think people, just reading this, what our fear is let's say we have this contract and it's 10% and it says not to exceed 10. The fear that you're saying it's legally sound, but our thought is 2 days before closing, the seller says, you know what, I only want to do 5. And it says not to exceed, so it doesn't exceed 10.
Exactly.
Brian?
Well, this is consistent with how we've been doing it in the contracts before, and we've never had any problems with it. But as I read it carefully, I think the sentences are structured backwards. And let me give you an example. Let's say under the old way, we say seller pay buyer expenses not to exceed $100. And the seller says, okay, here's $50. Well, wait a second, my expense, no, it says I am only obligated to pay not to exceed, and $50 does not exceed. And so therefore I am not in breach of the contract by only offering you $50, right? But if you flip the sentence over and you just say seller will pay buyer expenses not to exceed $100, then the seller's agreeing to pay buyer expenses up to $100. And so if we take 1B, we would say seller agrees to pay brokerage fees owed by buyer to buyer's broker not to exceed X. Doesn't that eliminate the ambiguity?
No, I think
I think it legally helps make it clear. I'm not sure. Well, I'll leave it. I won't speak for the.
the practice wasn't not to exceed. If we look at what B has always been, it was a definite amount. C, yes, for decades has been not to exceed because it was an unknown series of potential costs. B is a known. It comes from the buyer rep agreement, and then the buyer is asking for help in paying that amount. If you look at what B had been before, it wasn't an unknown. It was a specific, and the buyer either said yes, seller either said yes or no.
Yeah.
They've got to stand separate. They worked separately.
Just as an interjection, real quick, are you broker? Are y'all? I mean, clearly from the comments, something's happened, but are y'all using? Are buyers always asking for sellers to contribute to expenses that this paragraph's really being used that much?
Yeah.
Yeah.
And with the changes coming out, with
You serious?
Yes.
so with Texas Realtors, we can preview this. Texas Realtors has suggested, and it looks like it will go through to remove 5A from the listing agreement. That then will effectively remove broker to broker, not as a practice to still be allowed, but not authorized or in the standard forms. Not encouraged. That's a good way to put it. So with that being removed, the vast majority of negotiations for payment of buyer broker fees between the parties is going to be in paragraph 12.
So kind of back to like my 4 meetings ago, here we got to do promulgated forms to save a trade association, these people's fees splits.
No, it's assuming they didn't even exist. What language should we have in there to begin with? I guess would be the way I would phrase that. They're changing what they do. And I think we've already made some divergence from doing that, like removing 10 and stuff before they even suggested that change. So I'm not sure those, I know in other areas certainly, but not, I don't think this one.
And for whatever reason, we kept the ratification fee in the page in the farm and ranch contract to show buyer-seller involvement in the transaction, but it only lives in the farm and ranch. And we'll probably talk about that in the year to come. But right now, with everything that in buyer rep agreements for decades, it is always said that the buyer's agent would go first to the seller, then to the buyer for that compensation. So when changes did take place, to be able to look to the seller in the contract, that was the place where it ended up living. And now with all the changes that all license holders now, all over 230,000 are going to go through, the consumer and the agent needs their life to be made more simple. And we have a responsibility to them, in my opinion, to clarify that and bring it back to the way it was before.
I have oh, go, bro.
Well, I think a lot of the industry essentially is they're putting in the dollar amount that they're owed or the percentage amount that they're owed. And so they want to see those equal, right, from their buyer rep agreement to this amount. So I think the vast majority of these is that's going to be, they're going to just say, I get this percentage because that's what I put in my buyer rep agreement.
Absolutely.
So I think they want to lock that down, and there's an assurance to them that locks it down. If that's what's happening in the majority of transactions, I think that's fine. Remove the not to exceed. If in fact there is a differential, then that's between the buyer agent and the seller. And then of course the title company is going to have to say, you've got to justify this expense to the full amount. Otherwise,
Well, could that buyer agent legally collect that additional amount?
From the buyer.
If
Well,
it's on their
Unless the
Well,
buyer agrees to it.
so you're going what are you going to do at closing? You're going to do according to the contract. You're going to show a payment.
No,
that
that's
amount.
right. That's what
So
I'm
the
going
buyer's
to do.
broker, right.
But if I'm the buyer's broker, can I accept that if I don't have an agreement with my buyer?
That's
that
the
I'm
problem.
entitled to?
That's where we're going to have that. And I think you just leave it up to for them to deal with the problem.
Yeah, well, and it's whether right now it's legally permissible, except NAR's rule for the realtor license holders that are bound by the association rule. It will become a rule in Texas January 1st on at least residential real estate. It's different language, and so everybody knows that the language in the new Senate Bill 1968, which would be 1101, 562, and 563, does not match up to the current requirement from NAR. So they will be different. They're similar but different. It's same concept.
Mhm.
And so then it's a matter of, is it enforceable versus just a breach of the occupation code rules giving rise to it.
Now, here's
enforcement action.
Here's what I think is going to happen in that situation, frankly, is
They're gonna amend their buyer rep.
you're right. They're going to amend the buyer rep, or they're going to go in and say, and the brokers will probably work with each other fine, is, hey, I put the wrong amount in, so we want this to be apply over to this other concession for the seller to take this other way. Or, sorry, we'll have to give it back to the seller. I think they'll work it out, but I think it's their problem, not here. Now, if we want to add a representation in here, I don't think it's necessary, but we could add a representation that the buyer broker is representing that this amount wouldn't be there, but he's not a party to the contract or would be
No, I
exceeding.
like it that you have the buyer and the seller in there, not us
Right.
as brokers.
So I don't see a problem, but I do like Brian's suggestion with regard to C and flipping the
Flip it.
sentence.
But you can do with D as well. It still works.
Right, but I don't know. To me, I think if the not to exceed language is causing the problems in the industry and the confusion, just go ahead and put a certain dollar amount and see how it works out.
And the one thing we don't have on this committee is a magic wand to have the perfect language to satisfy every concern and how everybody thinks. And with what I'm hearing today is that not to exceed is going to cause more problems than if we were to take it out and have a definite number that people would collect more than they should. It sounds like that's the lesser evil of having it definite and seeing people may still make mistakes, collect more than they should, but there's some procedures with title and others that may catch it, and that may cause less problems than the confusion caused by having that in there.
I think it also falls into the 5% rule because most agents are not going to write something in that violates their restrictions.
Yeah.
Now, I have one other question, sidebar question, or is it a substantive change here that we're making, or
If you're just talking about removing the.
not to exceed?
No, reverting back to currently.
So while we're on this, do we want to now look at what that wording would be, taking out that not to exceed? I think the wording is very much there already. An amount, if we go back to what it used to be, the $ percentage of sales price to be applied toward the brokerage fees owed by buyer to buyer's broker. And so that should, we've got it there, just taking out that not to exceed and putting back the following amount.
I personally agree with that because we were addressing the problem of the confusion of the old language to be applied to broker fees that buyer has agreed to pay. There was a lot of confusion on that.
C,
Yep.
C, yeah.
Yeah, and so if we can do what you just said, take out not to exceed, but leave in
All the rest.
all the other changes,
I'm gonna pull the,
would that be
I think that's
fine?
Yay.
so I'm gonna make sure we're gonna get this correct.
And a corollary question, if we decide not to accept or take out certain changes we made and keep the others, can the commission then approve that form, or does that have to go back through publication and comment?
So our position for a while has been if you're removing language so that it's essentially going back to sort of status quo in many ways, that even though it may be a change from what you've initially proposed, it's not a substantive change requiring proposal. So
Okay.
yes, the
Awesome.
answer is that they could adopt at the November meeting.
Perfect.
So
That helps.
I just deleted everything and went straight to this box. It doesn't look really good to have a box up front here, but I guess you could do that. Because it reads, seller shall pay the following expenses. And then B would just be a dollar amount or percentage amount.
And I guess you could say the amount of, if you just want to put some,
Or yeah, I guess you
you just don't like the box, the amount of.
I guess amount equal to, or the amount.
Well, what we
I
had,
wouldn't say equal
what
to.
we had before,
Yeah.
yeah, what we had before was the following,
The,
the following amount, checkbox,
Oh,
because that would be what we had before.
I didn't like that, that's why I changed it.
Mm.
I didn't like the following, because I'm looking at the next paragraph.
Yeah,
You can make changes in response to comments received or discussions here. The test is the change that you make in response to those comments so significant that it really needs to go back out for public comment? So you can tinker.
Awesome. Okay, so that
I'll tell
opens
you
up
when it's-
to Brian's idea for C, maybe of looking at.
And then you would
okay,
say,
so let's focus on B. What happens when we put in $10,000 and it's only $7,000?
We
well,
won't.
that's what I'm saying, is it's not likely it's gonna happen, but number two, if it does, that's a problem. But
Oh, I see what you're saying, yeah, it comes
No,
up
that's
to
a
$8,500 and you put in 10, and somebody's gonna say, I want my 1,500 back.
That's a
Well,
contract
you
problem.
do 10.
And it's
Well,
the lesser of the
that's what
evils,
I'm
right?
saying.
So we're looking at these different evils, and that's an enforcement issue, right? So fiduciary duty to your client, you should have it, documented right.
I get it, John, but I mean, they're right, like, nobody seems to ever be able to calculate what the expenses will actually be until the title company's like, here it is, you're like, oh, I got it wrong. Like, I would have thought it was 500 more, 600 less. So you're right.
I think it'll be a learning experience for the few that do it. But other-
It's going to be a learning, it's going to be a learning.
Very optimistic. I'm very
It's going to be a
optimistic.
learning experience given by the 12 smartest people of the county. Because it's going to, you create an ambiguity of the contract.
Oh, I see, yeah.
I don't know how it's ambiguity.
It says the seller will pay $10,000 to be applied to the broker's fee.
Oh, but that's owed by the.
But it's only,
by-
but it's only $7,000.
Right.
What happens to that other three? Who
Exactly.
pays it?
Well,
Does the seller pay it?
the seller's obligated to pay it.
They're obligated to
Who
pay.
gets it?
That's the question.
that's the seller and
So
I
the
think the title company gets it.
Exactly.
Require the FinCEN report, right? I'll set those fees.
What do you do? You're going to require the broker to come in and say, and the seller to acknowledge, I owe you $10,000. Now, what happens between them? Do you even ask the question?
No, we're going to
Well,
collect.
I'm just telling you, how do you put, they may not have a contract.
I know, so that's
How do
why
you put that on your closing statement though? Like if there's an excess going to the buyer's agent, you're just gonna like,
I don't know.
I mean,
That's
technically under the
why I said
contract,
It should be the following amount blank instead of to be
well, Brian, you'd have to give it to the
Not-
buyer and then the buyer's agent would
up
want it.
to the brokerage fees or not to exceed. the
Do
brokerage
brokerages
fee
not
owed by
provide
the buyer to buy the
CDAs?
broker.
Christy has a comment.
So I see the concern. I'm curious what y'all are experiencing. We're having more and more title companies ask for copies of our buyer rep. But if something is off, then I can see an amendment to contract being done or an amendment to the buyer rep being done to make one or the other match
To make sure
the numbers.
Right.
But we are seeing now more than we had title companies asking for a copy of our buyer rep agreement. I'm not
Yes,
sure if
we are
y'all are
too in
doing the same
Houston.
thing. And so I think that, and plus we do have CDAs where we're double checking things on our end. That doesn't, now I know we're probably, especially the bigger brokers are probably checking that a lot more through our compliance systems. But I think that, I don't know if y'all are asking from the title world, if y'all are asking, but I know that's what we're experiencing that would help with a lot of that.
Yeah, and the background on that, Texas Department of Insurance, when they audit title companies, we show them that they get the settlement statement, and the escrow accounting rules of TDI say you must have support for every disbursement on the settlement statement. And they've started asking, oh, you have this for commissions. Show me what you have in your file to back up you putting that amount on your settlement statement. And that's why the title companies are starting to ask for it more.
Mm-hmm.
So do you want to add maybe an admonition here that this amount should not or may not exceed the amount that's owed?
Not to exceed the brokerage fees owed by buyer to buyer's broker.
When I originally tried to draft some clarification language to this and then started down this road in our July meeting or June meeting, I had the tagline, I don't think it's good today, but something at the end of, but in no event more than the buyer has agreed to pay under a separate agreement with buyer's broker, to address that issue of, you were putting this, but it cannot exceed that, which is, I think that's wordy for what we're trying to do here, but
or the lesser of this amount or the amount payable for buyer.
And I think where he's saying put not to exceed works.
Yeah.
Apply toward the brokerage fee not to exceed what the buyer and the broker have agreed on. I mean,
I can take out to be applied toward. Just say not to exceed the brokerage fee.
Are we getting into the brokerage business, the brokerage's business when this contract is between the buyer and the seller?
Well, that's why I say
that.
to be applied toward. I don't care how you apply it. I'm agreeing to pay you X dollars, not to exceed the amount you agreed to pay your broker.
This is more, I think we need to keep it simple. We are going to then add another sentence that undoes the good that we're about to do.
but it says that right now, doesn't it? Is B written
Yes,
the way
it's
it
the
is
way
right
it
now,
was.
except you took out not to.
These are dollars on a settlement statement. You don't have to say to be applied towards. You just say seller's going to give the buyer X dollars, not to exceed the amount that of the commission going to the buyer's broker.
Well, the problem
It'll show on the settlement statement.
Well, I think
the money just washes back.
We put that there specifically because it was a lender question on concessions. So they didn't have a problem with this concession exceeding the normal 6% limit that they have, and that this would be considered separately.
Right.
So I think that has to be in there, that it is being applied to the buyer broker's fees.
Yeah. And I'm going to add one more thing. While it's getting less and less, at least in our experience, there are still some contracts where we do still have a compensation agreement between brokers because the seller may be offering 1% up front towards BAC. So we have a compensation agreement between brokers, and then there may be another amount negotiated in the contract in 12A1B on top of the compensation agreement between brokers. We are still having, it's getting less, but we are still having some of those situations. And you still have both amounts, some coming straight from the listing agreement, which will change as that modification is done. And then some being negotiated at the point of contract. And we're providing the compensation agreement between brokers to the title company. We have this contract and then the buyer rep agreement, which would be the sum total of the two.
So
I am leaning.
less is
Yes.
we make
Agreed.
No.
So let's have Ron type something out here, and then maybe we give an opinion to go around on what our opinion is and whether we less or more.
First, because we're the ones that are having the issues. I understand the title company's concerns, but let's not make it about the title company. Let's make it about the boots in the ground, the agents that's out there.
And I think you're like with teeing off, once it gets up there is whether we need any explanation at all, right? Let's just cut it off, and that's where my mind is going. So I think you'll be happy to hear that side. Or do we try to add more language that may or may be construed a different way or confuse things more? And I think the benefit to adding it is it could help some situations. The benefit to not adding it is definite, and let it be an enforcement issue. Let it see if it's a big issue that arises. I'm not hearing that it's been a big issue. That's one thing, and I haven't heard today that I've seen somebody try to collect more. Now I've seen it at early on. I haven't seen it as much lately, but we'll go around the room to talk about that.
Let me make one thing clear. This is not a title company issue. The title company will close based upon the settlement statement provided by the parties. And they both sign.
That's
the concern I have is that you are creating an ambiguity in the contract as to what the obligations of the parties are. And when you have an ambiguity in the contract, that would either mean you have no contract, or when I made the comment about the 12 smartest people of the county making the decision, it goes to the jury to interpret what that contract means. And one of our goals is to have a contract that is certain, that is unambiguous on its face. And we may be creating an ambiguity unless we are making it clear that we can't have that example I gave of the seller agreeing to pay $10,000, but the broker's fee being $7,000. That creates an ambiguity. There may not be a contract, and that's a seller-buyer issue. That is not a title company issue.
But remember,
and I'll wait. We get the
different way it's been the last year.
Well, and I understand Brian's point that he's making on the legal side. It's almost what to do with the excess. You know, if we go down there, it's if you look at down line of it, if there's any excess, it will be X, right? Of spinning it back around be another way to potentially address it. I think if it's put in the contract, I want to make clear, I don't think this cap is right now an enforceable thing in terms of the legality of a contract, because it's right now an occupations rule. It's what agents can't collect more than, and if they breach it, it's a license issue. Under the NAR, it's an association issue. I'm not sure it goes down to the party's contract, but it does leave the ambiguity of what happens with the excess on that point, and how big of a problem is that to fix, or can we? So, the language on screen, Diane, I know you wanted to go around to the brokers first. Let's start with the brokers.
I want to read it better first. Hang on. I'm not ready.
The question about what was added, is that now making it a requirement for a written buyer rep agreement to be provided to all parties, buyer and seller and title company? Because that is a proprietary document between the buyer and that buyer broker.
Well, you may have to provide it to the title company.
I think you have to provide it anyways. If you're the seller, like I need proof. Why am I paying this?
We have nothing else.
I haven't sent any.
That's been a big concern about not sending that. I think that in confidentiality discussions we've had in the past months, people not doing it.
I agree that you don't want to give it, but if you're like, I got to pay your brokerage fees. Well, if you don't want to share it, how's anybody going to verify with the title company?
Here's the invoice. Here's the CDA. And if you our duties as agents, we can't treat anybody unfairly, or and our fiduciary duties extend to the other side. So that would be a license issue for sure.
And that's why I put this here as a written agreement, because the CDA would satisfy that here.
So a CDA would be evidence.
Yeah, it's a separate agreement.
I'm worried that will be used as a thing of saying you have to give it.
Yeah, have to give me the buyer rep agreement, because that's really what that says, is evidenced by a written agreement between the buyer and the buyer's broker.
Yeah, that's not a CDA.
My CDA is not signed by my buyer.
Every title company is going to
see that.
Yeah.
And to be clear, a title company does not have to have the buyer agreement. They have to have a written backup.
Yeah.
Okay, an invoice.
Yeah.
That satisfies the TDI requirements.
And some title companies are absolutely requesting it. Some lenders are absolutely requesting it. It's not required by law. That's internal guidelines, because especially for title, they can accept other documents, but that's not how it's construed, or the internal policies of various title companies and lenders.
And that's a right that they could do to the broker. This is going to raise another whole problem. Misinterpretation. Do I have to give it? I think it should be taken out.
Yeah.
In definite reference to the respect of the person who wrote it, who usually saves our butt all the time. This time, I'm disagreeing.
No, I think.
So what if you take it out, so that just means that,
Keep it simple.
what if you take it out, that just means somewhere along the line, and that may be okay, but the Brian team or the John team has to say, all right, now I need something from y'all.
Yeah, we've been
Okay.
doing it
And that's
for
what
a
they-
year.
Okay.
Yeah.
But
And a CDA has been fine, not a buyer rep agreement.
Okay.
so the confusion side, I'm going to go back to the legal side now, because in addressing Brian's concern about leaving it open to what happens to that excess. And is that okay to leave open?
Make it so that there cannot be an accident.
Assuming there is.
Is there another language or other
It be
language?
applied toward and not more than the brokerage fee owed by buyer to buyer broker.
No.
Well, let's have a kind of a brainstorming session at first. There's some other language that may spur something that's.
The question I have here is, and it's coming, and it's happened because I've seen offers. Even though they ask, what is the contribution from the seller, and we basically say what it is, right? Some are not happy with that contribution, right? So they want to put more in paragraph B because they've raised the price of the house or something to get more of the money. I've seen it even show up in C now. And I like the fact that it's not going to be buyer's expenses, but you know what I'm saying? It's even, I've had 2 offers. It's shown up either in B or in C because they don't like what the seller has said they are contributing. And I don't know how we do that. And that's the only time I see them really going over what the rep agreement says is because, I don't know. I mean,
Is this a 5% issue too?
yeah,
Are we making a mountain out of a molehill with
Right.
something that's worked for a year and we're just trying not to change it? I'm confused.
So I believe it gets back to what Diane, you said, and Leitra, you mentioned that the cases that probably go over the amount of what's in the buyer rep are so low that I think it does follow the 5% rule. I think the majority of the time there is the documentation. I do believe for the most part people use CDAs. When someone wants to buy a rep on top of that, then we do that. But we're checking to make sure on our end from the brokerage side that we're clear that agents are not charging more than what they have already in. If there's a change, a lot of times it's amending the buyer rep down, if not as much as
Right.
being offered.
correct.
Rarely up, but most of the time amending it to go down to match what the compensation is.
So maybe to help move us forward in this is I'm hearing a pretty good push to the change of taking out an amount not to exceed, leaving it definite without the additional language. I would like to just give a minute or two thought time on alternative language to throw out there that may not be accepted, but just to talk it through and then put it up there, then we can start moving on. So we're not circling around. I think that's where we stand. But I want to give the opportunity to Darlene or Kristen. I know it's kind of hard when you're online. If you had any input, give you an opportunity to jump in.
I think we should I like what we originally said, just taking out not to exceed and leaving the language simple and straightforward, if that works legally. The more we add, I think that raises questions and open to interpretation.
And the question I have, and I'm just trying to think it through, is if the buyer's broker's fees were $7,000 and the seller paid $10,000, does that affect the lender depending on who that extra $3,000 goes to? So if we don't address it, does it create any kind of fraud against the lender?
Well, that's a lawyer answer. fraud against a lender.
Yeah.
That's
That's over all of our heads here.
I don't think it's fraud, but
Do we need to get into that?
it is problematic from a complete
Remember,
closing statement to the lender.
I'm questioning too, how many times does it happen where more than what the agreement is between the buyer and the buyer's broker is in an error on the agent's side to have put it in there? That's where you were mentioning that goes to a TREC complaint or a buyer seller call their attorney kind of thing.
Or an NAR
And
complaint.
yeah, I mean, an
The only other
important
thing you
thing,
can do-
yes, but to the 5% again.
The only other thing you can do is an education issue here.
That's right. That's really what it's getting
And
down to.
focus in on this or put in some admonition in here. But if you put in an admonition that says, don't put more than what is owed to you, then
That's already in
you're going to
another.
raise the question again about the excess. So, and I think there's going to be the same objection. So I think if we just go with this, see where it goes, see and come back and see if there's a problem with this.
May I suggest that we, if we don't have agreement, stay with the language that we have already agreed to in prior meetings. I'll just tell you, nobody in this room, but I've seen plenty of times where the seller credit has been used or attempted to be used by a buyer's agent to funnel money back to their buyer, period. And that not to exceed language has been important language to enforce and say, no, you're only allowed to use it up to the amount of the actual expense. Now, that could be buyer expense, that can be broker fees, I don't care whatever. But people have in the past tried to use paragraph 12 on more than one occasion to be able to funnel money back to their buyers. And I think the not to exceed or not more than, or some language like that is appropriate. If
There's a
the suggestion I had doesn't work for people, then I suggest that we stay with the language that we have right now under paragraph 1B and C.
And Diane, I'll come to you next. I forgot to introduce, and I see Commissioner Renee Harvey Lowe is with us again today, and she always attends every one of these meetings and sits through. And I believe I saw you go off mute there for a minute. I didn't know if you had a comment you would like to make.
No, I was just agreeing with Darlene about the not to exceed in the language of the contract.
Thank you. And
Thank you.
Diane.
The difference I see between B and C is there is a contract between the buyer and the buyer's agent that substantiates the amount in B. There isn't between C. It is an unknown list of buyer's expenses that are going to be asked for at some point in the transaction. They live differently. It's perfectly appropriate to have not to exceed because it's an unknown in C. B is unknown.
That's a good point.
Yes, yes.
And my fear with sticking to the language we had at the last meeting is half her comments are saying this is confusing. And I fear interjecting that because that's not what's in the contract being used right now. It's just our proposal.
I like how he has it written right there, taken off the colon and the and just a period at buyer's broker. Just
The one other comment to throw in here, since we're looking at the actual language, later on, somebody makes a comment about moving the check one box only and saying to be consistent with how we use it elsewhere, that it should be moved up in front of the check boxes. Mm-hmm. Not that was, it is consistent to do it that way.
So I guess it goes in front of the colon.
think you typically have it after the punctuation.
So definitely after a period. Sure.
I'll just put 2 colons. How about that?
It's in 22 is before the colon.
7B is after.
Ooh, we need to go all the way around.
Yeah.
These anal things here.
Yeah, we can make a note to make it consistent. Yeah, that's.
Which way you like it? You like it this way? With
We say make similar changes where else it. I'm fine with that.
Now, Brian, you were suggesting a change to C that I liked. So it'd be blank dollars. And then you were suggesting moving this to the not to exceed language here.
Not to exceed, or I mean, I think simpler languages, but not more than.
That's not currently a change there's no change to that section.
So that was all the way back for public comment.
It depends on what you want to do, but.
Yeah, well, we added some language in C, right?
Other
Yeah,
than brokerage fees, we added that.
Yeah.
I like to see how it was written.
Yeah. And that was to try to avoid that double dipping being alleged.
Okay.
And that one is the unknown expense, right? We don't know. We don't always have an exact amount of what that would be. So it kind of makes sense to be not to exceed.
So the committee decided to change the proposed 12A1B.
Yeah.
You don't need to change C at all.
Right. So you could leave this alone. I just like the change that you had, which was to say buyer's expenses in an amount not to exceed blank dollars. That's why I like that one.
Yeah, I personally like that.
So I would.
Does everybody understand that change?
No.
Maybe if you show what it would look like.
Yeah, let me just copy it down here.
So it helps clarify the same. We do have some comments in here too on C. We should look at C for the same reason.
So I was.
And Brian's suggestion takes care of that by saying they're going to pay buyer's expenses, but then in the amount not to exceed.
You talking about flipping it around?
Yeah.
Yeah, I like it better that way.
They hit not to exceed in everything. The home warranty.
So C would be that.
They just don't like not to exceed.
That's kind of nice. That's a good modern change.
I like that because it also calls out buyer's expenses better,
Right.
which is a defined term.
It's the thing we were trying to do, the other than brokerage fees. And that does happen, by the way, just happened on
I
Friday.
think that's okay.
So then if we do that, it goes out to public comment again.
No, I think that's okay.
That's okay.
Oh, that's okay?
I like that.
Yeah, I do too.
So is everybody comfortable with the B and the new C?
I'll read it 10 times in the minutes.
And Brian, your comment will probably keep me up at night and make me think about how to make it even better. So I'll look at that.
We need to come up with another nightmare for Brian to worry about.
We'll probably have some coming up. We're not done yet.
It's not there yet.
There were also some comments about, I think, spreading this out a little bit or
Yeah,
making
right.
it easier to read. I don't know if.
Yeah, several of them. They ran together too much.
And is that because of the formatting of how we did the changes here, or was that something that we can actually accomplish? Normally we look at staff to make it format right, but is there any particular direction that you would have other than just how we normally format these?
Well, I think the formatting should be consistent. So if we're going to add spaces between paragraphs or subparagraphs, we should do that throughout. So,
And we don't.
Yeah, I don't think
Yeah.
it was. Sometimes when you make red lines, it squunches it up a little bit.
This may help just by moving that line.
Yeah, I think it may help just by moving the line, like Diane said, because before the lines were kind of all on top of each other.
That's
And,
true.
and now they're just the wording and where we put the blanks is giving it a little bit more space, maybe.
All right.
So then we're going to take out the word and in your colon, right? We're just leaving be the same with just not to exceed.
So
Well, we
B.
still need the and, because they may also
Yeah.
choose to put something in C.
so there's actually, yeah. So there's,
Oh, the and goes to the C. Okay.
there's an A, B, and C. So I did put A in.
Okay.
All right. Well, I think that's a good resolution.
Okay.
There's a lot.
Nothing's
in there.
perfect, but it highlights again the public comments on how it can bring to light an issue we didn't anticipate before. The next one that's a similar issue, we can kind of address most of the comments in one discussion, is page 10. There's quite a few comments saying they don't like taking it out. They think it will cause confusion. There's some point out that it's still an acceptable practice, still in the listing agreement, which the cooperative compensation section. And others like it. Others saying this may create a confusion when it was different between what was in 10 and what was ultimately in the cooperative compensation agreement, or 2402. To step back, I guess, to tee this up, with page 10 was the disclosure of the cooperative compensation amount that was broker to broker agreement. It was never enforceable. We agreed at one point in the past to take it out. After public comment, we put it back in because everybody said we wanted it there. But we added an explanation saying it's not an enforceable agreement. Now with in light, especially of 5A potentially going away and cooperative compensation getting less and less likely, it adds to the reasons, I think, to go ahead and completely remove it.
I agree. Yes.
And when it's used incorrectly, it's problematic, because the example you gave where some of the compensations on this form, some of the compensations in the contract, and then they're putting it down there because they're just like, I'm putting it everywhere. I just don't want to miss it.
Exactly.
And so it's being done incorrectly so many times that it is problematic.
So not hearing any, I guess, Darlene or Kristen, any alternative thoughts? Page 10 removal? Oh, you're on mute.
I know. We're talking about taking this paragraph, the disclosure.
Yes.
On the
about
screen?
taking that out. Correct. There
I'll
seems to
go
be
with
general
the-
consensus here that taking it out is a good idea.
I
over
agree.
the comment.
Yeah, I agree.
Yeah, I like removing it.
We tried that how many years ago?
We had a commissioner that said no.
They came out. Keep in mind that this will require additional communication with the title company to provide that information.
There always should have been.
Unless it's all in
right?
paragraph 12.
Right.
They'll do it
Yeah,
together.
unless it's all in paragraph 12. If it's all in 12, we're good. That's where I want to go. I think we just need to go to paragraph 12.
Heading that way.
When I teach it, I tell people do it that way.
Let's keep moving forward in the comments here. We have Craig Manuel that his comment was repeated several times. He likes the removal of page 10 to eliminate confusion. He will like our new change we just did to 12. He didn't like the old one that we had tried. He thinks it should be a hard and fast agreement, and that we should do the same change for C. And of course, we've done at least. Ben says, I'm so bad with names. Mr. Ben, in paragraph 12, thinks it's not clear, not to exceed language issue. Lori Westbury Kennedy, page 10 should include ratification of fee, or we should leave it in.
No.
So this is a little separate thing. We didn't discuss this ratification of fee concept. And at least historically, we've tried to limit when agents sign anywhere on the contract, just to prevent potential disputes or making parties in some way. But it is a new comment. I personally don't believe we should add a ratification to introduce the potential issues that could come of it, but any other alternative thoughts?
Well, we had ratification years ago. It was ratification, what, 8 years ago?
It's still in the Farm and Ranch.
It's
Probably still in the Fair Ranch, but in residential, we had it. It was at least 8 years ago.
I've been on committee 8 or 9 years, and it is off when I.
It was right on the top, ratification and broker information. It was right on the very. Maybe it was longer than that.
We don't need that.
I wouldn't do
Brought
it.
that to brokers,
No.
we're like, no.
Yeah.
I would like to place on the future agenda items, perhaps getting some input from the farm and ranch guys in light of the changes that we're doing residential. That seems to me this is going to be logical now with our changes in 12, that this is not really going to be necessary.
I agree with that.
I think it would be problematic to go now, but I would wait. I'd want to get some input from them.
It would be good to add to that as well the potential conflict when you have an amount in 12. Then you also have an amount in the commission agreement at the end of the farm ranch.
I can get that off. Well, I'm on that committee, but yeah.
Maybe we can tee that up for
You get some
discussion in between in the subcommittee and eliciting feedback for next time. And I would throw out there too, I'm still have a part of me that wants the farm and ranch type language in all the contracts. And I think there was at least some flavor more than we historically had to do that. So I would also throw that as a third item to discuss and evaluate.
2 members of that working group are SJ and Amy, so we may need some.
Oh, they dropped.
Now you can decide what to do.
Yeah.
I was originally on that committee. They've been meeting with
You're still in. You lost.
You're the chairman.
You are the
Oh. You know, I said if you want to move up, take out the bottom.
So who's on the committee right now?
For what?
We got Tony.
Tony and SJ, wasn't it?
Yeah.
Mary.
Yeah, I think that's what
I think it was Tony, me, and SJ.
And Amy.
Huh?
And Amy.
Amy.
Okay.
And Amy. Okay, so it's Tony.
Let me first ask, does anybody have a desire to be on that committee? The Farm and Ranch Committee.
Candy.
I can,
She wants to.
Look at you jumping in.
In the rural world.
Christy.
yes, if someone's needed, absolutely, I can do that.
All right, so that's 4.
Oh, did you jump in too?
All right, so we have 4. Kristen, I'm not completely familiar with your background. Do you have any desire to be on the Farm and Ranch working group, or is that an area of expertise for you?
Yeah, I'm actually originally from Gonzales. That's all I know. But I will do whatever y'all need me to do. I'm new, so y'all just stick me where nobody else wants to go.
Do you mind adding Kristen to the group?
Well, then it would be at least 2 lawyers on the thing.
I kind of like it, just one lawyer.
All right. We'll add you to that subcommittee, Kristen. And typically, when they meet, it's coordinated to have group meetings in between our bigger meetings. Those have now become a little more formalized. It's 5 total. Okay, so we're good there. Yeah, and we have to keep the one thing in Ken's not on here, but just as a procedural matter, we can talk about more is the open meetings requirement of not having a walking quorum potentially made by discussing it outside the formal meeting times between members. And so that's with the subcommittees, it allows us to meet as a group and maintain the requirements for the open meeting.
Right.
All right. So jump forward there. Amber Brown writes in about paragraph 12, believes similarly that it's more confusing and thinks paragraph C was a good change to clarify that, and doesn't think we should modify because of, confusion of the same. So reads a lot more confusing. She does appreciate the verbiage in C that makes it clear the dollar amount is inserted there, not for broker's fees. The next one, legal from Amy Henry. Legal holidays capitalized in one instance, but left lowercase in another. Should this be capitalized in both cases? And as I read that, we have legal holiday in 3 or 4 places. It's capitalized in all but one. But the one place it's not capitalized is part of the definition. It's saying what a legal holiday is. And so I'm not sure we need to make any change there. We do have a case, very interesting case about that impacts definitions in this. We'll get to later, and also another comment about what's included in legal holidays. We'll reserve that till later. Amber Brown writes in that she general comment about the backup language. Appreciates the consistency throughout the forms and the backup contract addendum. Diane and I met and discussed some language for the receipt of the fee. Maybe this is a good time. We don't have too many comments to bring up. And so what we're tasked with to tee this up is with our new backup addendum, we now have the ability to do staged, earnest, and option money, where when the contract is executed, you pay the original earnest and option money per paragraph 5 of the contract. Then in the backup addendum, you can agree that at some later date when you go into first place, the first place contract, that you pay an additional amount for option money and for earnest money. You don't have to use those, but you can. And the problem we had is we don't have a receipt for the additional option fee. And what we tried to look at, there was debate in our past meetings, do we put that all in the backup addendum and put the receipt there? The concern was, well, we have to look to 2 different places, the contract, the backup addendum, or then we said, okay, what if we put it in the contract? Well, if we put it in the contract, are we also going to introduce this concept of additional option money that people may start writing stuff in and get confused on why is this receipt for additional option fee there? So we took looked at 3 different ways to do this. And ultimately 3, maybe we start with 3, which is, I think, what we decided at the end, even I didn't put this in order, is to add in the contract itself the additional option fee receipt. So it's all in one place. It's all in one form. You don't have to go look for the addendum in the contract receipt pages. But add a parenthetical, and you skip the top part about the amendment. The add a parenthetical, use only for payments made under paragraph A2 of the addendum for backup contract or paragraph 7 of the amendment. Now, we have another suggestion with the amendment to make this all come around to be tight. But having a parenthetical like that to keep it all in one place. If we end up not doing our amendment change, then we can just take out that amendment part.
Can I ask about the parenthetical? Why would you limit it to any 1 or 2?
That's the only place additional option fee should be paid.
Right. I know, but it's a receipt. So what I'm asking is, let's assume I got an attorney drafted addendum and it calls for additional option fee coming in. So why would I not just allow that additional option fee receipt box to be used for any purpose when an additional option fee is being given?
And so the thought of having the parenthetical was really centered around not creating confusion or introducing a concept that people might try to utilize in the contract. When they see that additional option fee, we see a lot of special provisions already being drafted about pay another fee or do this in the contract itself. And so by having that, it provides the direction that really what its intended purpose is. Now, if an attorney's drafting a form, my thought is, well, they'll be able to draft around that too. But that was the reason it was in there. It's not to all of a sudden have, hey, you can get an additional option fee somehow in the contract itself, or to contradict what was in the amendment right now. Because the amendment says, at least as it currently stands, you pay to the seller in that has paid language. I'll go and throw out the concept that we thought for the amendment as well. The amendment has language right now that says that buyer has paid to the seller X amount. And historically, we've been very strong on keeping it that way. So because it's past tense, it's normally nominal, but we've seen, and I think I'll recognize that it's becoming more than nominal and in practice more and more. But it has paid. So that way there's no confusion that the seller's acknowledging having received it. Now, we know a lot of times they haven't, right? And how that legally impacts them at the end of the day is something the court will decide later. But can make the process consistent? And it's their ability to make it consistent with these changes. To go back an idea we've gone over several times, but to have it go to the title, the escrow agent again, and have it receipted all in the same place. And now that we're seeing higher, more than nominal amounts, and having it go to title will solve a problem of them having to track down these amendments and to know whether it applies or not to the amounts due at closing. And so we just tweaked the language to say buyer shall deliver an additional option fee of blank to escrow agent on or before the deadline, and then kept the same language for the extension of the unrestricted right to terminate the contract on or before 5 p.m. On the selected date. The rest of the language about whether it's applied or not is carried over from the old language.
Well, we have one problem in that language itself, and I'm okay with that. But my recollection on the old case law dealing with options is that the option fee itself, or at least part of it, to support it must be tendered at the time that the option fee is to begin. Otherwise, you have no option. So if you go back to paragraph 5 of the contract, it reads, for nominal consideration, the receipt of which seller acknowledges, and buyer's agreement to pay the option fee. So what's happened then is the nominal consideration is tendered immediately. That allows the option fee the option period to start effectively, and then you collect the money later. So here we don't have the tendering of anything. We just have a promise to pay within a certain period of time. So I think we need to add that similar language saying that there is nominal consideration passing plus an agreement to pay or a promise to pay.
I like that. And another idea just came to head just to get out of my head into the world. I'm not sure I agree with this, but came of having a deadline of no later than the end of the last option period. Because if this is supposed to be an extension, not a whole new one. And so then if you have language that's solid to say it has to be paid before the expiration of the old one, which would also be 5 p.m. on a date that
Case law disagrees with you because it says an extension is a whole new option.
Okay.
Because you're paying for it separately.
I do like the fact that, so we know it's tendered, because how many people say we're going to extend the option in the second set of money never makes it into title.
So we had the nominal language.
We haven't had cases in this for years, so it's very possible court may look at it differently. But if we're going to stick to the language of the old cases, then I think we need to add something in there like that.
Mm-hmm.
So
That's why we have attorneys.
so you could, if you wanted to do it, you could start off and say for nominal consideration, something like which seller acknowledges receipt, and
If we're looking at making a change to the amendment on the language, is that something that can't go through this?
It would be a totally
separate
separate thing. Yeah, and the yes on that.
something like this. That would work, I think.
Why wouldn't we just use the exact wording from paragraph 5B?
For nominal consideration.
For nominal consideration, the receipt of which seller acknowledges and buyer agreement to pay the option fee within the time required seller. I mean, it's already in there.
That's what is in the backup addendum. I'm not exactly sure. What is it we're drafting?
This is the amendment.
The amendment.
By the way, have we signed off that it's a good idea to do this?
Yeah,
change?
that's a.
Because I don't agree with that at all. The current amendment works. We're creating, this amendment would create an additional item for people to stub their toes on. And let me just give you the Texas Supreme Court case on which it's currently based is the Jopich case. And what it basically says is when you have an option to extend, to provide for a certain amount of time, it facilitates contracts to not have to say or have the burden of proof that $10 was actually paid or not. And instead, when you have a relatively short period of time for an option, And that's what we typically have with amendments. We're extending for 3 days, for a week. That what the courts say that the fact that the parties are doing this to facilitate getting the contract done and closed is itself consideration for granting the option. And so therefore the court says, if you put into a contract that the parties acknowledge the receipt of consideration, we're not going to look past that. We're going to say, yes, the consideration was paid, and no one is going to question the validity of the option by saying, oh, you didn't pay me that $10 that you should have paid me. And so it really has worked in the marketplace that, at 10 at night or 4:59, the parties enter into an amendment to extend the option period. And that keeping the contract alive is the consideration itself, and that's sufficient. And if we put something in here, we're going to be just creating another thing for people to do. And it's in the overwhelming majority of cases where it's just a short-term extension of the option, there really isn't a benefit there. People aren't extending things and saying, I want that $10. Okay? If it is something that is significant, if they say, I'll give you an extension, but I want $50,000. Okay? They can draft that.
Where's the line? I mean, I 100% agree with what you want. Let's say it's what you're saying. But let's say that it's unimproved property and they want more time for environmental phase 1, phase 2, or they want 2 weeks. Is the court, because we don't know what the court's going to do or which appellate court's going to pick it up. Should you put money on that one?
I don't have a problem with that. I don't have a problem with that.
13 days?
I don't have a problem with that. And so I probably would say that if it is of a material nature, either in the amount of money or the length of time, that's where you would use the amendment special provisions and spell it out. But in the plain vanilla extension that we see on residential deals, where they're extending for 3 days, a week, maybe even 2 weeks, the consideration, the way I look at it, the consideration of the seller giving me an extension is I'm not sending him a termination notice.
Sure.
Yeah, and I'm not sure I agree with I think the courts have looked beyond the nominal consideration passing to look for something more. So from my understanding, it's not as black and white of just because you say nominal and it passes. I know we have the Joppich case, but if we look at some of the other cases that have interpreted in different ways, and I haven't cited today, I think there is a concern there that if it's just nominal and nothing else has paid, kind of Tony's line a little bit of where is that line? And the concern that was raised, and this is a broker question, of how often are you seeing this be more than nominal? In some of our past meetings, and why we started having this discussion here, was we're seeing more and more become actual payments and significant payments and longer extensions that we're getting out of the typical, let's say we can't make a decision right now, so let's just do it for a day. And so that's what bred it. But what are y'all seeing as brokers?
The nominal, I haven't seen major amounts unless attorneys are involved and they're drafting something else. And because it says that the seller gets it, it usually ends up being $10, and it's $10 handed by the agent or the buyer to the seller at that time. And then they have to give the title company knowledge that it actually happened. So there's nothing to document that it actually happened. And agents are trained in Legal 1 that in order to have any extension of an option, there needs to be consideration and a time or a date. And that's education, and that's what we try to get them to do, not have a conversation and say, oh, it's okay. No, it's not okay because you're not protected. So we've got to stick with that because we're not attorneys and we're trying to be sure we follow what we're being trained. And I'm hearing attorneys saying, oh, well, maybe it happens that way. Well, we can't let our agents do that.
if I'm ever asked that question, do I have to pay the $10 to get the option? I say, legally, no, but pay the darn $10.
Right.
Don't create the argument. So, and I think we're sort of spending the same thing there is, you want to make it as simple as possible to somebody. Is there $10? Pay the $10.
And it's not happening on that addendum.
On the flip side, and think about this. If we do something, is it going to be a self-fulfilling prophecy? That all of a sudden we're creating situations and people are going to say, oh, now we got to get, we're making a bigger deal of it. Right now, the way the amendment's worded, it works.
So what if we, to look at the issue further, we teed this up because it came up with the additional option fee of putting this to the side for consideration at the next meeting. So I'm going to look at the case law that's in my head of past that. And we can go back up to option 1, which doesn't involve the amendment at all, but we can consider that. This is a new concept that, I'll say new, we've talked about it at previous meetings, but the sticking with what was actually on the backup addendum itself would be adding the additional option fee receipt directly to the contract with just that limited parenthetical. Or the option 2 was if we added both to the backup addendum, we would need additional earnest money and additional option fee. The problem if we added both to the backup addendum is then now all of a sudden we have 2 different places with additional option or earnest money.
We have 2 receipts.
And so we would need to, what we would say if we put it all in the backup addendum is parenthetical that's not to be used if it's for payments made under the, not for use payments made. It actually would cite to the paragraph 5A of the contract is what that should.
Instead of this.
Correct, yeah, under paragraph 5A.
Because you were saying one thing in the.
But we think that parenthetical, as we're discussing this, would be a simple way to prevent confusion.
Well, on the backup addendum, it's likely not going to be $10.
No.
Right? It's likely going to be a significantly more, higher amount.
Right.
And having some sort of timeline to pay it makes sense because, on the addendum, it says they've already received it, right? And to your point, they might just be like, here's a $5 bill. Or, I see people sending it on Venmo. They're like, I got to get it to Venmo before 5 p.m. What's your Venmo? Just whatever. But it's already, it's a small amount and it's already being delivered, has been received by the seller. They're figuring out a way to get it to the seller. And there is a receipt if they're doing it on like a Venmo or a PayPal or Zelle or.
And in the backup right now, we have it going to the escrow agent as the new language that we've written it in. And this is bringing it full circle to give a receipt actually in the contract itself.
And it makes sense because on the backup, it's not just $10 and it's not just for one day. It's a whole different, it's a whole different deal. And it should go because there probably is additional earnest money and option, all of which in the beginning part of the contract in paragraph 5 are going to the escrow agent.
Mm-hmm.
Well, if you use it in the backup addendum, it's all there together in the backup addendum. So it makes sense for me to, at least my thought is that it makes sense to just place it in the backup addendum and not in the contract. Because I guess the title company is not receiving, well, yeah, I guess you are receiving it, right? Okay.
And the counter to that in our past meetings was keeping it in one place, then you're not having to guess which one to look at to see all the receipts.
Right.
And if it's taken out of the amendment and put into the contract so that $10 or $100 or whatever doesn't just get handed between buyer and seller, it's all in the contract. Title company knows it. It's all in one place. I think that's where all of it in one place, that being the contract, is where it got to be into the contract.
Yeah. I like having one receipt page. I like putting it on the last page of the contract, not on the backup addendum. But just saying, this is only for the backup. I like that better for now. And then later, if we change the amendment later, we can change this again. But
let me interject too. The contracts are out for proposal. This is completely new. So I do think this would be a substantive change.
And we can send this up separately for public comment, right? Would the ones go through and then for a future change, have this go up separately?
Yeah, so we could do that depending on how quickly you want to move. The changes that you've got proposed now, if you want to recommend those for adoption, those could be adopted, and then you could immediately have that change proposed.
And I'm not sure we'll have enough to that point of all the confusion and making sure that we don't change, because as much as anybody that's listening today, we try not to make changes every time.
And that makes the case for this. Because then you can get a receipt into play earlier by just changing the backup addendum, which will be easier than changing 10 different contract forms.
But we still wouldn't do that today, right?
No, right. Deferring this to a later time, I agree. But if we're going to wait 2 or 3 years to revise the contract forms again, which is what we generally average.
Like to do.
Right.
Doesn't seem to be moving.
Yeah, 7 or 8 years.
Lately, it's not moving that direction.
Address quicker than that this go around.
But still, it's going to be a year. It's going to be a minimum of a year, or maybe longer.
Back on the addendum for backup for proposal now and repropose it.
So I would say that you could, but the backup addendum you could repropose immediately just for this purpose.
Yeah.
I don't think anyone would really care too much. So from a practical side, I think it makes sense to go into the addendum if you want to proceed earlier. If you wait 2 or 3 years, then you can wait.
Brokers?
I think we had really good comments that people really liked the backup addendum. I think they want to see it now, as opposed to waiting and adding it and not getting it back through for months.
Then I would say we do this in the backup addendum, but we can't do it today. We have to do it at our next meeting.
Yeah.
Take the win.
Yeah, and receiving, I mean, it's still possible. For all kinds of crazy reasons we didn't receive it. No.
Yeah.
So?
Well, we're deferring anyway.
Yeah.
Either
Well, we're
way.
keeping what we
Have.
did,
Oh, yeah,
right?
yeah.
Okay.
Okay.
Yeah, and then we can just decide later where to put it.
So for clarity, what are we doing?
So we had a good discussion that everybody, it seems like there's a general consensus of the format of the receipt with the parenthetical explaining how to use it. The location is up in the air, whether the contract or the addendum. But for today's purposes, we're not adding it so as not to delay the contract. And then when we come back at the next meeting, we'll continue the debate after thought on, do we put it in the contract that may make it take longer? Or do we put it in backup addendum to get it out there?
And then submit that. And can a separate form move forward and be changed all by itself? Get approval and come back to us in 6 months or 4 months?
A separate form?
Well, like if
You
the
mean
back of the
addendum?
addendum has the boxes added to that, as opposed to the contract, for Ron's purpose, rather than waiting potentially 2 years, that the backup addendum itself have the receipt boxes on it so that the consumer and the agents can start using it.
Yes, then we can send up individual forms. We don't have to tie to the contracts or a package, so we can definitely do that. Okay, go on to the next one here. Let's see, Vicky French again says thank you in regards to the temporary residential lease, and I assume that's we're removing the floodplain notice. We have. And thank you for sending in thank yous and good comments. We like getting those occasionally. Richard Farrelly, temporary lease doesn't like the floodplain notice, so you should be happy that it's being removed. I think I was a little confused by the comment, but I think he wants it removed, so that's a good thing. Another one for Vicky French saying thank you again. And we have Jeremy Crit. Doesn't like 12. which we fixed. He points to paragraph 7 about new home warranties. There may be worth pulling that up on the screen, but it seems to be the same. It's not to exceed. He said it's now looking at it's just as confusing as the other parts of it.
That's been that way forever.
He's saying the not to exceed makes sense in home warranty, but not at all.
Yeah, I think he's just agreeing with what
Just agreeing.
Yeah.
He wants page 10.
Which goes into the justification for C, keeping it in C the same way. That's right.
Mm-hmm.
Cooperative compensation was to keep page 10. He, I don't believe, had news that Texas Realtors is likely removing 5A, the cooperative compensation, from the listing agreement. We've discussed that. Let's see, going to Beverly Schultz, doesn't like the paragraph 12 change. We fixed. Richard again likes the paragraph 12 modifications we did. Like consider the extra spacing, and then consider adding bolding the word as it in between the. I didn't necessarily understand. Also, please bold the word seller and buyer to emphasize who the parties and responsibilities are.
It's a repeat of above. They want us to bold seller and bold buyer.
Yeah.
I think just here's what they're talking about. This right here.
Yeah, seller shall pay, and then buyer shall pay.
It's kind of a weird formatting.
Yeah. Point well taken, but be hard for formatting purposes. Vicky French again. Same comment on 7 being too long. Going to Pam, Miss Pam. So all obligations of the parties for payment of broker's fees are contained in a separate written agreement.
I like this.
This is actually a good one. So this is on paragraph 8, a good comment. This, in paragraph 8, as you see on the screen, it has this statement: all obligations of the parties for payment of broker's fees are contained in separate written agreements. And if you look at the strict language of the phrase there, that's not accurate. There's not an agreement between the parties and their actual agents in the agreement, but there is a broker fees agreement within the contract itself. So as drafted, it's not proper.
To strike that? What do you think?
I think that's
Or paragraph 12.
Okay.
If we strike it, do we have to redo it?
Yeah.
It's something that I think needs to be changed, but it practically may be something we have to do on the
What
next
if we
round.
change the word
I don't
contain?
know if that's an inaccurate statement.
What if we change the words contain and put supported?
Obligation of the party for payment of broker's fees. If you take out that phrase, that's 12. Because an obligation of.
But the seller is agreeing to advance money to be applied to broker's fee, but the agreement for payment of a broker fee is not in this agreement, except for maybe the farm and ranch. The agreement of a seller to pay his broker, the agreement of the buyer to pay his broker, that's in a separate.
And I agree with that, but it doesn't say that. It says parties for payment of broker's fees.
Yes,
it doesn't say with.
Paragraph 12 is the seller agreeing to pay money to be applied to.
Yeah, to the buyer to apply to the fees
So I don't
that they
think,
owe.
I think that's still a true
I
statement.
think we can distinguish it like what you're talking about. I wonder whether or not we could change "are contained in" and just simply say "are supported by separate written agreements." And I don't know if that would be substantive.
I think you're getting a little closer.
Or for payment of their broker's fees.
But that's.
My agreement to pay my broker is in a separate agreement.
Could you change contained to just found? All obligations of the parties for payment of broker's fees are found in? Is that what we're trying to do? Get them to go someplace else to look for it?
We could just,
Before we had it in 12, before the change in 12, there was absolutely nothing outside the farm and ranch that was regarding the payment of fees as far as the obligation. We had a notification at the end, informational notification. So that was an absolutely accurate statement at that point. Once we introduced 12, there's the argument that this is too broad because 12 is under the argument a obligation for payment of broker's fees.
Because the word all,
Subject.
that,
I think it'd still be substantive, but all obligations of the parties for payments of their brokers are contained in separate written agreements because it's their fee and it isn't a separate agreement.
Because it is a buyer's obligation. So the buyer has the buyer's rep.
Yeah.
And then the seller has the listing. And the seller is just agreeing to take
Give
care
the
of
money
buyer's obligation.
to the buyer. Yeah. Because that's what it is. They're giving money to the buyer so the buyer can pay their fees.
What would we do, step back for a minute, if we weren't burdened by the fact that a substantive change would be made? What language would we want in there? And then to see if that can match up to something that's non-substantive. Do we, I think, looking
I
at
like
their.
putting that word there, because it is just their broker, their agreement. We're just,
yeah,
would
but-
that change
but
everything?
It's the obligation for payment, which is the problem.
But
Ryan's gonna have something really good. I think he's writing something out here. When he does, it normally comes out really good.
I'm on the same wavelength that Melissa is. The 12, when I'm thinking it through, is it's not the seller's paying the buyer for the buyer to apply it to their brokerage fees. It's not, and the obligation for the buyer is in their buyer rep.
Right.
So I'm not understanding the difficulty of the paragraph unless we do add their broker's fees. I'm not seeing the problem.
Brian
with
has
it.
a.
This contract does not contain the agreements of the parties to pay compensation to their brokers.
It's going to be substantive.
Well, this is a future one that we can look at and see what we.
Wait.
Well,
so
the
say it
easy
again.
thing is strike it. That's really what you do.
No, Brian.
Take it out.
Do you mind saying that one more time? So they can.
This contract does not contain the agreements of the parties to pay compensation to their brokers.
oh, but
Well-
12 is talking about that.
No, 12 is just contributing.
I don't
That's
mind that,
paying
Brian,
for
but
it. We're gonna
you
be
just strike it. I mean,
cutting
to me, you don't need
splitting
it.
hairs.
Yeah. Just strike it.
And renumber or put,
No,
Isn't it the case that the whole genesis of that sentence anyway was because we had the ratification of fees stuff
Correct.
at the end? And now that we're taking that away, the justification is this is surplus language.
Exactly. So that's why I like the change to delete it. Right. But
in the meantime.
Yeah.
if you want to be a little more precise, I think we can live with this.
It is, but I don't want to discourage anyone from, making the change you need to make. It just means it might take a little bit longer. But doesn't
How
mean you
much
shouldn't make a
longer?
change that you feel needs to be made. The timing will just be different.
If
Yeah,
we're
so
going to
that
make a
takes it
change.
beyond January 1st.
Well, and how,
It's gonna go
how much
through
of an
next
issue
year.
has this been? It's not a big enough issue to delay the contract.
This is
We can go next round and change things.
It can go on this year later. It's not.
Yes, I think
Is
it's.
the word, adding the word their substantive? Payment of their broker's fees.
I don't think that that's substantive.
Their own broker's
Yeah.
fee?
I mean, that's,
Well-
if we wanted to.
I mean,
I wouldn't be
Would that
opposed
change-
to it.
Would that go back to comment if we put in?
No, that's what I was saying, that word, generally.
I would say the sense of this committee is that paragraph 12 doesn't violate this. But for future conditions, this is surplusage language. And to the extent we can ever make the contract shorter, we should be applauded.
Yeah.
Really, what you want to do is you want to say here, obligations of the parties to pay their broker
Yes.
are contained in separate written agreements.
Mhm.
But
Really?
I don't know now, that's not, I don't know if that's too many changes.
Mhm.
So,
Leave it as is. I don't think that there's a problem next time around. Let's delete it.
Okay.
Yeah. I'm in favor of that.
Keep it super stuff.
Unsolved problem.
Even if it will be 3 or 4
Solve
years, I
problem.
don't think it will be.
That's why we love you.
We've changed this contract a lot
How
in
does
2 years.
everybody feel about taking a 10-minute break before we continue on?
Sure.
Good?
Yeah.
Sure.
Okay.
Let's, wait, it's 10:51. We'll come back at 1 past 11. 11:01.
Aaron.
Okay, it's 11:00. Well, I just turned 11:02. We're back on the record here. We're going to call an audible. Fortunately, we have a few guests that are experts in their field and have made comments and suggestions and represent a lot of stakeholders. So first, want to turn it over to discuss the issue first. There's new requirements, reporting requirements related to FinCEN that are going to impact the real estate practice, especially title companies, and the TLTA has been really behind this. So I'd like to turn over to Karen if you'd like to introduce yourself. And
You okay if I sit right there? Well, I don't need teachers.
No, I mean, you want to take it? Yeah, absolutely.
Take the head of the table.
We appreciate you being here today.
Hey, sit with that. I got you a cup of coffee. Here's your gum.
And
be your new chairman. Okay, well, thank you for having us today, and thank you for your consideration of this proposal we brought to y'all in the comment letter that y'all should have. And basically, this is.
Can you introduce yourself for everybody? Too?
Yes, Aaron Day with the Texas Land Association. So government affairs with TLTA, and we've been working for years on this issue. Actually, fighting it for years. But let me give you just a very brief, high level what this is about, and then I'll discuss our proposal. So FinCEN, and I'll try to not use colorful language. I get pretty emotional about this issue sometimes. I'll try to keep it as clinical as possible. But FinCEN is a part of the Treasury Department. It's the Financial Crimes Unit. Okay, and so money laundering is their largest concern. And you might recall the Corporate Transparency Act and Beneficial Ownership Program dealing with LLCs. Okay, that is this rhymes with that. It's the same type of effort of let's look behind entities and find out who the people are in these entities. Now, the distinction here is that was a bill, and it was part of the National Defense Authorization Act. The Transparency Act was attached to that. So we had a recent statute for that program, which people, once they kind of realized what was passed, I joke that, the Congress has been like, oh, we had no idea there was gambling going on here. And it's like, here's your vote, sir. If y'all remember Casablanca. But they did wake up with that hangover, and they've scaled that piece back quite a bit, limiting it just to foreign entities. However, this rule has been trudging ahead, and it is based on the 1970 to 73 range Bank Secrecy Act. So it's rulemaking authority that they're deriving from the 1970s Act. So there's some questions there about how strong their ability to present those rules are from a legal and constitutional perspective. That's being challenged in the courts. Three different lawsuits currently challenging that. However, though that cavalry, if it comes, will come fairly late, as you can imagine, since it's going through that process. Even with an injunctive relief, there's question marks of where it would extend. FinCEN did, and I haven't gotten into the details of what it does yet, but procedurally, since I mentioned those lawsuits, let me go ahead and mention that the rules are adopted in December 1, but they have pushed implementation of those rules to March. Okay, so we're going to have a little bit more breathing room collectively here to address this and amend the contract as well.
You said March. I'm sorry.
March. And so, but back to the policy piece. What this rule requires is for a residential property. That's the first checkbox. Second checkbox is a cash transaction, i.e. it didn't go through a mortgage. Okay, now you can have hard money lenders, but if it didn't go through a mortgage that already has any money laundering requirements, okay, it doesn't go through that path, so cash or cash equivalent. And third, the purchaser, the transferee, is a entity, okay, so as opposed to a person. And there are certain trusts that are family trusts for estate planning purposes that are excluded, but trusts are also included. So there's a little bit of a distinction there. Now, what they want to know, if all those criteria have been met, They want to know everything, basically, the personal information of those folks involved. They want if it's a family ranch LLC purchasing this property, they want the 8-year-old's social security number. That might be a member of that LLC. Okay, so it's very extensive, very complicated, frankly, very invasive. And so that due diligence that's going to take to go through all that and find the 8-year-old social security number is going to have a cost associated with it. Okay. And now the title industry is bringing this forward, but the responsibility is really shared by a lot of different parties, potentially. It's kind of a joint and severally liable basket of people that are deputized by the federal government. If they don't do this, they can go to jail or be fined. Okay, so it's just sort of, we're just victims of circumstance collectively here. We got tapped on the shoulder, and the Fed said, I need this surveillance information, and you need to give it to me or you're in trouble. And so lawyers, if you're so I say it's a cascading responsibility. We have but it's most likely going to end up with the escrow officer of the title company, but it's who files the deed, who closes the transaction, who drafts the deed, so it includes attorneys. Okay, it could just be a simple drafting attorney if this is taking place in the law office and outside of title, for example. And it could be an attorney having to deal with render their confidential information of their clients to the federal government. And we view the fact that these transactions might be taking place as confidential in so many ways, and so should attorneys. However, the federal government has said we're not concerned about your privileges and relative to your clients. And we want that information. We want that information. I'll back up for a minute, and I'll try to say this as clinically as possible, but this is their reason why they want to do this. They have basically what I've described 3 pillars of their public policy. They first started this conversation about 3 years ago with a proposal for potential rulemaking is a way to say it. There's a technical term for it, but it's basically, we're thinking about doing this, give us comments. And at that stage, and the copy hasn't really changed that much in terms of why they say they were doing this, but they were saying, we have a problem with Russian oligarchs, and they're laundering their money through residential properties. And in order to enforce international sanctions, given the Ukraine conflict, we need to monitor all the Russian oligarchs. Okay. Number 2, we would like to be harmonious with Europe's surveillance standards, financial surveillance standards. And number 3, those Russian oligarchs are the reason why first-time home buyers can't afford to be in their homes, because they're bidding up their properties. Okay. And that was their talking point then, and their talking points haven't changed. Actually, in front of Congress, she still said that third point, that this is the reason why we're facing problems and affordability is because of these Russian oligarchs. However, it's no longer the Russian oligarchs. Now it's the cartels as the focus. And there's a similar element, a program rather, called the GTOs, and some of y'all may be familiar with that. If you're in certain counties, there was under emergency powers, FinCEN has been having these geographically targeted orders where they pick certain counties, certain properties of a certain size, if a cash transaction requiring basically this type of information to be rendered. But that was very limited in scope and territory. And they've been operating under that emergency power since 2016. They've just been renewing it every 6 months or whatever expiration is. So I'm giving you all a lot of background, but I want y'all to just appreciate, why we're doing this. So when your clients are asking, where is this coming from? This is what it's basically. This is now a national a no price distinction if it's residential meets those criteria. So they have implemented this program. Their estimates on cost are $500 per transaction. That's what the government says that it's going to cost for the private sector to do this due diligence and render this information to them and fill it out. Yes, sir.
Keep in mind that it's $500 only on those transactions that need to be reported.
Correct.
And that's probably going to be 5 to 8 percent of the.
I think that's a good estimation. We've been seeing a lot more cash transactions across the state, but are they cash transactions plus entities? So that's the thing. So don't think in terms of every cash transaction. It's cash transaction plus
Cash entity, and you said, no, residential, so does that mean house or does that mean land for building a residential?
1 to 4 family, and I think it does have some language with the intent for residential, which is giving us a lot of heartburn, and we're still don't know what the guidance is.
Don't try to hide it. Russian oligarchs in Gatesville, Texas.
Residential farm and ranch.
So would that mean that a grandparents who are setting up a trust to buy this property for their grandchildren, they're an entity, they're paying cash, are they going to be investigated?
I believe so. If it's for a state, there are some exceptions in the trust context that I'm not an expert on, and I don't want to be wrong. Okay, but red light, flashing red light. Make sure it's the proper type, but not one of the excluded trusts. They say for family purposes, but I think it's really intra-family estate planning that they exclude this reporting. I think if you're for that purpose, you're creating the trust and buying a stranger's property for the family and for the yes, that information would need to be.
So there will be an anticipated $500 charge that will be charged on the buyer's side on all transactions.
Well,
they fall into these criteria.
That's to be worked out amongst the parties, and that's part of our recommendation.
Where's that $500 being paid to? Is it the title companies that are actually doing the search? Are they hiring a third party to do it for them? How does that work?
We anticipate all the above. Okay, and that's going to get tricky and probably evolve into third party because that may be cleaner for the title companies from an audit perspective from TDI. Because if we do a work charge, that it's going to be we don't know yet. Yeah, exactly. So how we're going to charge how we're able to, and the way TDI agrees, and we have a lot of taxonomy issues with this particular situation because if it's a third party, it's pretty clean and clear from the department's perspective. If you're doing the work and then charging as the title agent, that gets a little bit more complicated, and that may become more like an escrow. A separate escrow price that's unregulated, and maybe for the smaller one-off company, it may make sense to do it that way. It may be treated that way, but maybe the majority of companies, the vendors will be so available.
That's my thought. Goes to like tax certificates, right? If title companies that then have their own separate tax certificate company and keep the revenue effectively in-house. But you're looking at where the money flows, and for us to address in our forms, he has language proposed for the materials. I'm sorry, I don't have the page number. It's in the agenda item 6. 101 of how much we intend that to be. If it's the ability for title companies to then have more revenue, or we're seeing it wide fluctuations.
This can't be a revenue center for title companies, and the department is going to be very clear about that. If we have a work charge which they disfavor, so they like to see it show up in an escrow, and it'd be like we can't discriminate amongst individuals within a class of type of transaction, not even type of person. We can't do that. We can't. But type of transactions, we can have different escrow fees, and they just need to be consistent for all parties. So that's the extent of regulation there. So I anticipate, maybe, perhaps, don't know yet, a different type of escrow fee for these type of things if it's an in-house work, but they're going to have to demonstrate that work charge was associated with real world costs, which may or may not happen.
And the way we've been looking at it, we know that they stated $500 a file. It's going to be much less than that.
I'm getting a lot of optimism that it'll be less.
That to me is actually shocking. That'd be less. Just with the amount of work, I'm not sure what would go behind this to do it, but to me that seemed my first reaction was that's low.
And you're going to have to get information from both the seller and the buyer.
Yeah, I was agree with you, John. I think it'd be more expensive.
And take on the liability of doing the work as opposed to hiring a third party.
On an 8-year-old Social Security number.
Yeah, and it's like we estimate it's going to be over 100 separate data points that are going to have to be obtained and then input into the system, and then send it out. And the smaller title companies, I mean, their eyeballs are going in opposite directions, just thinking about how to do it and what the manpower is. And it really, as you said, there's going to be vendors that are going to come up with go to this website, click this box, fill this information in. And it's going to be a far more efficient system, but it's still pretty complicated.
So that has to emerge?
Yeah.
Is the burden on the title company to report this, or is the burden on the buyer or the seller?
It's on the title company.
So so your proposal is.
Or the attorney that drafted the deed. I mean, there's cascading. Yeah.
So your proposal is somehow or another incorporate into a real property agreement where the buyers and sellers are using a promulgated form from the state to complete their transaction. You want to interject something that helps the title company into their deal.
Well, I would phrase it as the earliest that the parties know that this is an issue, the better. Okay, so first is the education piece, because not everybody wants to give this information over. So that's a potential conflict of transactions that we would like to see resolved first. I'm sure everybody around this table would like to see resolved as early as possible. Hey, buyer, hey, seller, you're about to have to give all of your information to the federal government. Okay, so know that that's the case. So as a seller, you may want to reconsider, right? If that's something that's of value to you or concern. And so that conflict potentially needs to be resolved just by virtue, we're even going to do this dance, okay? The second potential conflict is, are we going to get this our homework turned in time so this transaction can go forward? Because this is a de facto choke point of the government stopping these transactions from happening if no party's willing to close it. Because
I can see lots of breach of contracts. You didn't turn your stuff in. I turned in my homework. You didn't turn your homework.
So there's that piece of it, and then there's
I did. I thought I did. You didn't give the 8-year-old.
So let's look at his
That's what
the language.
I'm reading his language.
Yeah.
well, and just the third point is, of course, the food banks.
Yeah.
What's the thought on the seller? I understand the buyer, I understand, but why is the seller having to get this?
They don't say, I'll editorialize and say in Europe, they don't have financial privacy the way we have in America. And all the people that show up to lobby for this in DC are from these NGOs that are made up of NGOs that are paid for by European governments. So this is very much, let's close the privacy loophole that America presents to the Western world that is trying to use economic sanctions. They have economic sanctions against people nowadays, individuals, not just countries.
Did I hear that the seller gets the information?
So the seller also has to provide.
Oh, to provide it. Okay.
Situational awareness is the old Poindexter phrase of like, it's just knowing everything about everything on this.
And then when do you, like, I'm reading the language.
Mm-hmm.
If you want to read it or post it, but it's.
Yeah, if we can have that on the screen.
When do you, I mean, it's a good, appreciate the suggestion. It's a good start. But we got to put in there, when do you have to turn it in? First 10 days, 8 days? I mean, so that you don't have breach of contract lawsuits hitting you all the time. Like, oh, your people didn't turn it in until the day before closing.
Well, almost my view when I read this was it's almost like the 1031 language that we have. If it gives notice and we say it's not a reason to delay closing and that the parties should probably work together. I'd like the language. I have some things I would remove from it, but to me it's notice and then telling everybody you're going to have to comply and reasonably work with the title company or whoever, however we phrase it, and closing won't be delayed because of it, or it can't be delayed. It's kind of the pillars.
The distinction, though, with 1031, we had this long 6-hour battle last time SJ was here. 1031, she wanted it.
Her spirit's still here.
She is. Remember this, 1031, you actually don't have to have that notice language in there because there's no requirement for the buyer to really cooperate and do it.
That's true.
See, I'm getting Brian nodding, so I know I'm right. So, there's no requirement that you do anything. Apparently here, there's some kind of like
that's a good point
consequence if you don't do it. Like the other was just nice. Hey, look, we're going to be doing this.
Well, keep in mind, you get to the closing table and the title company says, can't close the deal because you didn't get us all the information. What do you mean? I don't want to give that information. Say, I don't care. You don't have to give me the information, but I'm telling you, as a settlement agent, I could go to jail if I don't get that information and report it to the government. So I'm not going to close the deal until you get me the information. And this is a hard stop. And I think that was a main impetus to this provision, is just like we have in paragraph 20 currently about whether you're a foreign person or not.
Yeah.
Yeah, this, by golly, this is important. If this, again, we're praying that the federal court actions, one of which is in Texas, will be the cavalry that comes to the rescue. But if not, we have to have something that the parties understand that it is their responsibility to do this, or the deal is not going to close.
Let me ask a question here on one. We have the same timing issue, right? This is obviously a substantive change, so we're going to have the same question here about timing. So in the next question I have though is, what would you do if this didn't happen? Would you, as title companies, put in a provision as you receded the contracts and saying notice, and then you make this a notice that says we're going to have to gather this information. If you're coming to our title company and using our services, then you agree that we're going to be asking for this. You understand we're going to be asking for this information and that you're going to need to comply. And then is that your sort of backup here if this doesn't get into the contract forms timely? I'm not saying
there's 30 forms everybody signs.
Yeah, I was about to say. I mean, there's
arbitration. This.
No, but I'm talking.
Put it in capital letters and bold.
Escrowing.
Oh, you're talking about at the beginning.
Yeah.
Well, is there anything that says it has to be in the contract, that it couldn't be, as he's suggesting, a separate title company form?
I would have suggest the who pays part becomes something, since you're deciding all that in the contract.
In titles, yeah, titles not parties to the contract regardless. So I think what we can do to preempt the issues, right, to stop the issues before they become one. And this is a particular issue that I look a little different of. If you send everything else up, and this could be a supplemental thing to, if we want to address it before March 1st, can be, approve everything else. And here's almost like an emergency thing for consideration that we do a one-off. I don't view that as an immediate contract change, as opposed to we would almost be getting ahead of the anticipated legal change in January if it was approved.
Well, I'm looking at by the time we adopt these forms, meet again, draft this up, submit it to the commission, sit it out there for public comment, and adopt it. We're well past March.
Unless we did it today, right, and sent it up to the commission for consideration, for publication, for comment.
Well, the problem is you can't put it in paragraph 20. Now, if you do this as a separate addendum,
That's what
sure.
I was thinking.
What my thought, and this is what I was trying to clarify earlier, is we send the whole package up, right, with all the other changes without this. And then separately say for public comment for the next round of changes, we would like to look at adding this to 20, right, to then be pushed through as a secondary change.
Why couldn't we do it?
A separate commission.
The goal is to get this adopted. Really, the only way to do that, unless you're looking at an emergency rulemaking, you have to look at that statutory language again, is you would, which is not great, if you want to do it in the contract form, you would essentially recommend this for adoption. That has to go into effect, which is problematic because we tend to push the dates out to give people or time, to get adjusted to contract form. So you'd have an effective date. I think we're talking about January 1st. And then once that is effective, then you can go back into the register and reopen a rule.
So you can't essentially have a
A long way.
and proposal and.
Okay, so that cancels out my thought there of that. That makes sense.
The only other approach is
Separate.
the commission would have to not adopt these forms,
Yeah. So
add this to it, republish.
you could that would be another option. You could pull them back, repropose at the November meeting. That's an option. Yet the third option is a separate form and fire.
What, do we know what percentage of
residential property is purchased by entities in the state.
I think he was saying earlier, like 3 to 5.
We heard.
Well, it's a small number. I mean, for
Yes.
those people, it is a
Yes.
big deal, but it is a small number of transactions.
Could we do, just like we do with the HOA, have a separate form clarifying all this?
That's what
But
the option.
Well, that would be a fact.
Yeah, the challenge with the secondary form is that the buyer changes mid-transaction. So they'll go under contract as buyer late resolve. I, say to title, hey, I'm going to do it in my LLC, and that changes the substance of the transaction.
And how are they going to, if you do it as a separate form, how is the broker going to know to do this? Because it starts off with, we may change language, but if this is subject to the Vincent, which I don't know what's subject. No, no one knows. Oh, we got to use that addendum because it's Vincent. How did you know?
Yeah.
I don't know. I mean, how are no disrespect, but I've been to a lot of title companies. I don't think a lot of them are going to know, especially some of the smaller ones. You need to be doing this. So you turn the contract in, you got all the beautiful language that we've spent the time on. And then, 2 days before, we need that so-and-so language. What do you need? I don't know. How does that work?
Leave it to.
Well, I don't mind working on the language. I think the question is going to be is to me, it's a timing issue. And so that's why I'm asking what's your backup plan here in the meantime. It seems to me that a quick backup plan, even if we push the form out, would be that the title companies can grab that at the time of escrowing. And they can actually get it signed at the time of escrow.
And that'll make more sense, Ron, because I think the people are going to need, the parties are going to need the title company to tell them if it's even needed. Once you drop it off, look at the parties on this. We're going to need.
Well, that's why I'm thinking that because it could be a title company could come in and say, we don't know yet if your transaction falls under here, but if it does, then you agree to this.
Yeah. And I'm going to make an important distinction that probably most people don't care about. There's a difference between the title company and the escrow agent. That's true. How many independent agents do we have in Texas now, Aaron?
Yeah, 600.
600.
Just
okay. I will venture that over 500 of them very well have no idea what's going on now. They don't have a plan yet. We're trying to be proactive and we're going to be ready. But we're a big company. I fear for the smaller agents. This is going to be, for the smaller agents to have a uniform warning to send out to parties. That's going to, hope it's going to be okay. I mean, the thing about this clause is it's going to be in a promulgated form that goes out to everybody. And that's going to hopefully provide notice to people about it. It's going to spur education to real estate agents when we start discussing the new forms, and the people teaching the class will say, aha, see this. This is something that is important.
And that's why I think
this provides visibility.
Right. That's why I think an addendum for the time being can work, because what's going to happen March 1st, one or two people get burned or get into problems, and then that word starts to spread. And all of a sudden this form starts showing up more commonly, and the title companies are talking it up as well. I do think that addendum gets attached in a lot of situations. If you want to do an addendum right now, just to have something there and look at the next round of forms.
It worries me on the consumer side. We're focusing a lot on, title and logistics and payment, but this disclosure of information and how intrusive it is in it being unknown, right? It's to me, a big concern to keep on level with the other stuff is the consumer not wanting to comply and blowing up deals because of it, or not realizing it in advance in a not so much a title company handling it, but as a true, I have to disclose all that information. I don't want to. I did an LLC to be private. I didn't want to have XYZ out there. And maybe that's just a general education thing that we'll will come. But at least on the first wave, I see that as being a huge issue for consumers and a cause for controversy outside.
I guess
It
that's
already-
some kind of education. You're not necessarily telling the other party all of your entities. You're telling the government. And when you file it with the Secretary of State, you already told the government anyways.
But not your social and all this other.
It's hard to tell how they're social anyway.
Arguably, that's what you have your option for. You don't want to be detailed.
That's right. And it's like FERC on steroids almost. Certain information that one side has to give. They don't want to. Well, you can't close the deal.
It's a definite challenge even in our counties that have had the GTO orders because you have to give copies of ID, any information of anyone, social, corporate entity docs. That's the whole thing.
So going to Ron's idea for the addendum, that sounds to me like would be the.
I don't know. I mean, it's an idea. I don't know if it will get us traction. And really, we're talking about a few months that we'd have to go without.
Yeah, you might be 6 months late from the effective date.
For an addendum, are we talking about just for title companies to use, or we create an addendum?
Both.
Okay, because then how logistically when and if and do we include an addendum? Because do we just do it on every single transaction that has an entity on it, just as notice? Or, because I'm trying to think logistically as an addendum, how that works versus being in paragraph 20.
If I get burned once, I'm putting it on every transaction because it says if this is subject to.
The question is, you were talking about the pay issue, right? It's not really the title company handling it that end. Who pays this $500? So that's where I see the addendum is if we're coming there, we're talking about who's agreeing to pay the fee, right? I wouldn't even know where to look though. I mean, if I have an investor and he has an entity, where do I even look to see if that's something that's needed?
Well, let's say I'm a buyer and I want to find a loophole to get out of the contract. And there's no obligation that I provide this information. So
I agree.
Give me this information. No.
And from the seller's perspective,
So the deal's not going to
some
close.
sellers may not want to sell to entities if they know this
Mhm.
and aren't assured that the buyer is going to provide what they need to provide.
Oh, it'll panic some people like, well,
And they may not
this
want to
is
get there.
required.
You're
Why are
gonna
these
get some
people, what's wrong with
farmers and
these people? What are they doing?
Yeah.
Or do you want a headache if you have competing offers?
Right. Oh, yeah.
It makes some buyers less.
Foreign persons
attractive.
purchasing in
Do you-
legal.
And I know this is
Then you have
impossible to
fair housing
predict.
with them.
How open of a possibility is this to be challenged in a way to delay March 1st?
Well, we fired off they only did the delay as a result of a question at the last financial services hearing in the House. And we were a little crestfallen that they still adopted the rule. They just delayed the implementation. So we don't know. I mean, it's hard to say. The fact it's also been very disappointing that the amount of questions they have, that form has over 104 questions, and and by the way, they're questions that if you don't it's a fillable form and you can't proceed if you don't have it in. You can't say the information wasn't rendered. It's just kind of like out of those 105 slots, if you can't put something in there, and you can't just put dummy stuff in there because now you're lying to the government, right? So that's not going forward unless all 104 to 105 cells are filled out on that form. And by the way, apologies for bringing y'all this so relatively late to your process. We've been trying to delay the rule. Also, that we've been that they haven't got that form out, so we had a lot. They still haven't adopted the form officially. I mean, we've seen versions of it. We've made comments on it, but it's still officially they don't have that form in place for a rule that they anticipated in December 1. So this thing is not. It's not like this is all resolved and we're just not bringing it to you. I will say though, we're getting pretty far down the path of okay, we got to start training our people and we can't just keep fighting the fight. And it was and we had our first webinar on this like a month ago, maybe. And it was at that point where everybody was saying, oh, wait a minute, guys, we're going to need this in the track form. We need these parties to know who pays, that they need to turn in their homework, and that this is even an issue.
And in all fairness, Brian has brought this up to this. It's not the first time we're hearing it today. So Brian has done a good job of, we don't know anything, I'm putting it out there and waiting for direction. So I don't want that to be lost. I appreciate you and Brian bringing it to our attention. And there's still so much unknown. I mean, it's hard for this committee to draft something in anticipation, but at the same time, seeing it coming, how can we get ahead of it as much as we can?
It seems to me the logical thing to do here is to draft something ready to go that we're acceptable to, then drop it at the earliest possible time. And then by that time, we'll start to see the result coming by March 1st, because it's not going to get to the commission for adoption. And even if they push it out for comment and something happens in between, they can always hold, the commission themselves can always hold it off and delay it.
So do we,
And anything we do, I mean, the 3 key points for us, as I see it, are number one, we want to have visibility to the industry so that people know that it's out there. Second of all, we need to ensure the enforceability of contracts. We cannot give people, as Mary pointed out, the opportunity to refuse to give information, which could make it so that I'm not in breach of the contract, but the contract's not going to close. So we want to ensure enforceability. And then we need that there are costs involved and we need to address it. It made sense to us, but doesn't have to be that way. But it made sense to us that this is all buyer driven because the buyer is buying as an entity. And so the cost of compliance would be a buyer expense. It doesn't have to be that way. You could say these are escrow fees and split them evenly between seller and buyer. To me, that doesn't make sense because it's only going to be 5 to 8% of the transactions. So we don't necessarily need to be charging anything on the majority of the transactions. And it'd be fair that the cost be allocated to those transactions rather than spread out generally. And then escrow fees under our contracts, it says 50-50. And so is it fair to say the seller has to pay 50% of this cost when it's the buyer because of the status of the buyer and how they're purchasing the property that is creating this cost?
How much more limited is the seller information that they have to provide versus the buyer?
It's much more. It's basic information, I think, that basically they need to know, get an idea of who the seller is. And I'm speculating. It may be that they just want to identify the seller such that they can be sure that there's no interaction between the seller and the buyer.
Well, in the seller piece, I can't speak to that. That's a good question. But if it's an entity, it may have the complexity of all the parties in the entity. I don't know. One thing we did talk about, well, what if it is an internal work, say a small agent that doesn't do this very often, doesn't have the relationship with the vendor and all that infrastructure in place. If it does become a separate escrow fee, I think at that point, just the complexity of that, you just kind of don't, just let those happen. Whereas the bulk of these we anticipate to be 50-50, where the bulk of these are going to probably have a third party vendor where it's really clean and clear and that's not.
Ron, are you thinking of forming a subcommittee to draft this in between now and the next meeting, or trying to?
Sure, I think that's fine. The other question is, we could probably come up with a draft this afternoon if you wanted to do that. I'd like to get through the rest of the contract forms, but then take this up as soon as possible, just to have it ready to go. But then my other question is can you make this a buyer obligation under the commitment?
The Schedule C requirement. Company requires that buyer provide. But again, that's not binding upon them.
No, but it's binding to get the policy, but then now he's got to He's got to say, I'm not going to give that information, and then the contract terminates.
I don't think it alleviates the breach concern.
There is an obligation in paragraph 9 to deliver all sorts of different types of documents that are reasonably required to close the sale. Now, I don't know if that stretches into there, but it would be nice to look at saying, maybe expanding paragraph 9 also to say anything that's mandated by law to provide something like that.
Got
Yeah.
Darlene's.
Okay, thank you. Darlene?
I would vote I'm all over the place with this, but I really feel like from a realtor's perspective, which I'm not, but brokers, if it's in the main contract that if it's subject to, you've agreed to it, that is easier than the addendum. And I can tell you that it changes all the time at the last minute. Suddenly we get entity docs and you've changed it from an individual to an entity the day before closing. Realtors cannot be expected to know that. You know what I'm saying? That would be my argument for in the contract, because when the things change, they already had notice of it. If that makes sense.
Yeah, I understand.
John, I think if Ron and Brian want to tackle a language, fine. I mean, I don't have any other commitments today. I just think you're going to really tack on a long day if you put that on the end. We still got a lot. We still got 5 more pages of comments, which I know many are redundant. I think the subgroup is probably the better way. Otherwise, we're going to be really rounding about the language. Does that say when? That doesn't say buyer. Are we doing a checkbox? Here, can we type that out? That's a 3-hour deal.
Well, let's see what we can do today in terms of, I think we've gone through the bulk of the main initial discussion. And then if it's like the lunch hour working on something that could, tee it up faster, and I think see how fast we get through the end. But at the same time, if we can knock it out today, the better, I think on that. But there's a lot to think about on it. So I maybe we have a few final questions on this and consider it, then knowing we're going to come back at the end to tee this back up, whether we have more questions or a draft or where we're at that time to do it.
Well, thank you for your consideration today.
Appreciate your
Yeah,
presentation.
absolutely.
Yeah, very understandable and great. Very simple way to present it to us.
Thank you very much for your
Go
time.
get them, Aaron. Knock it down.
Here's good to
Good to see the new faces. Thanks for y'all do. Important.
That's awesome. It's 11:44. We also have another Brian Sledge. It's on. Is Brian still on our video?
We also have.
Brian, are you up there?
Lunch is here. We had texted him to be teed up to present. He
is on.
Perfect.
He
shows his BS.
I think Brian is going to be more in terms of responding to any questions we have.
Okay, yeah.
Because as we go through I don't think it's really adding anything new.
Okay.
But just to respond to the questions and the comments.
And I'll leave that to you. Do you want to start tackling it now or to grab lunch and do that after? I'll give you the bad guy thing.
I don't know. If you make that call, that's going to be all right. Brian, are asking what his schedule looks like.
We have to unmute him. Staff has to, so I'm just.
Okay.
You never know.
He has his hand raised.
He has his,
Just give us a second.
and so I'll tee up while we're doing that, and whether we end up taking lunch or addressing this real quick is getting into the water disclosure question. We've received a lot of comments that we've somewhat skimmed over, that it's really long and confusing. There's been, I'll summarize some of the comments to help speed them up later. There's a couple that say this is great. It's going to help prevent issues and bring issues to the forefront.
You can come back after lunch.
You can? Okay. Yeah. So I will probably wait to that at the end. I'll get the other side real quick. There's bugs flying around saying you need to eat. And there's the other side saying this is too much, or that won't impact that many transactions, and it is going to cause more confusion. All that's balanced against the legislature or the Sunset Commission desiring this language and giving us a strong suggestion that we have it. And so we'll come back after lunch and walk through those comments. Brian is fortunate to be here again today to help us address any questions that might come up, and we'll go from there. So it's 11:46, 30-minute lunch. So we'll come back at 15 after, 12:15. Okay, we'll call the meeting back to order at 12:21. And so we left off just beginning to talk about our new water notice and the water disclosure issues. And I'll pass this conversation or this topic to Ron to handle, who was on the working group, worked very closely with the language that we currently have with the various stakeholders. So Ron, we'll leave that.
Yeah. So I just spoke with Brian, and Brian is probably online as well. So in talking with him, it seems as though probably the best thing to do for right now is to hold on the adoption of the water notice and paragraph 7A or I, whichever one you're looking at, and to give us an opportunity to pull in some additional discussion related to that, and perhaps maybe simplifying some things. So we were prepared to go forward today. We're prepared to go, but I think the better thing to do is to just take the time to make this as best and easy as we could possibly do that. So unless anyone has an objection to delaying that, then I guess let me stop there and see if anyone says, no, we have to go forward with this water issue today.
So you're just saying leave it as we put it in the proposal and not.
No, so right now, what we would do right now is to take out the water notice, ask the commission not to adopt the water notice, and not to adopt the changes in paragraph 7 that we proposed.
And we're going to have
That's the first question I have for you, but I've got a more complicated questions as we go forward from here. And then we'll come back, with a better, or hopefully a better proposal, hopefully something that's better there and easier to work with. So I just need to know whether or not anyone is objecting to that at this point. Or does anyone want to just say, no, I like this, let's go, and let's move forward?
I think we had a lot of comments where people were very concerned with the amount of information and people understanding what was going to be required. And I would be okay with postponing that to make sure that there's better clarity when we do roll it out.
I agree.
I sense fear around learning something new, and I think that's where a lot of that is stemming from. But my question is logistically, because we know it is a very needed thing, what then does that logistically look like on redoing? That's massive to our contract forms and affects all of them. If we're going to push through changes now, does that mean pushing through a whole? I'm trying to think logistic.
And there will be a second discussion point we'll bring up on the whole contracts in general and timing again after speaking with Abby and looking at kind of generally what's there that may solve itself. Okay. If assuming just sticking to the water issue right now, it's a lot, but it's a little block. So if we ended up pushing the rest through, we could pretty easily remove that new paragraph from the contract and just hold back the water notice itself. So that part would be pretty easy, but it would delay it. But there might be a bigger thing with the contracts in general to hold back to help timing for everything.
Yeah.
But delay water till when? I mean, the water issue, it's a never present problem.
No, we're talking a few months. So this, if we had our own choice of schedules because we got to mix this committee's schedule and the commission's schedule into this. So that'll drag it out, let's say 6 months at the earliest that we'd be able to adopt something new. But if we had our own preference, we'd do it in a couple months. So we're not talking about a delay or any huge delay.
But then again, that's in 6 months, the contract's changing.
Well, that's what I was about to.
Well, that's the next question. That's the next question.
Yeah.
That's the next question.
Okay.
In turn two, I would just to wait on this. This is a substantial change that is really big in terms of use, understanding, the education. If we thought paragraph 12 was confusing, everybody, this is going to be confusing. And from my understanding, there's thoughts on ways to simplify it, to get the information across just as good in terms of information, in terms of disclosure, but in a way that would be simplified that we don't have for us today.
The other pieces, which you've already jumped on, which is great. This committee is learning very well here, picking up on the procedural, the way that the commission works, is that what would happen is we could do one of two things. We can take paragraph 7I or whatever K out of here now and move forward and tell the commission just adopt the rest of the form and go forward. Alternatively, we can go to the commission, ask them to pull down the proposed forms altogether at this point, unless there's one or two that we would adopt anyway. But we would pull down the contract form and now immediately begin work on the water notice, the FinCEN paragraph 20 that we just talked about, the other provisions of paragraph 8B, and some of the other things that we talked about, the receipt notice, the receipt of the addendum for the additional earnest money. So if we delayed, told the commission, just pull it down and we'll republish as soon as we can. We'll recommend republishing. Then you wouldn't have a revision of the forms coming out in January, but you'd have them coming out a few months later with hopefully all of this stuff together. So that would be, seems to me that would be the logical thing. The only thing that holds up on that is paragraph, how important is paragraph 12A? We already have 12A1B in there already right now for the most part. So if you could live with it for a few more months, to me that's okay, but I don't know how important that is.
I think it's more important to correct the not to exceed moving forward than continuing with something they've been used to for the last year. I mean, I think people have gotten used to 12 be the way it is now. I think our conversation today was to avoid more confusion as opposed to waiting. I don't know if that would be as much of an issue for a couple of months.
And it would also allow us the opportunity to potentially address the FinCEN in a faster manner, because we wouldn't have this dual approach of sending up comments while another one was pending and looking at the meeting schedule, which we can talk about hammering some of this bigger drafting out at our next meeting, at a longer meeting, or figuring out the logistics, 2-day meeting to sit down and truly go through everything at one time to make sure we can get it to the commission. So it is, and we don't have to stay for 2 days, but if it works out that we need it, have it available. So we have a full package that's well thought out with the additional changes to this water. This is a big change with the water notice, and a very important one that I think we all generally agree needs to be done, but it is confusing. And if we can get this other stuff knocked out right and address FinCEN timely, it seems to me to make logical sense to.
So why is our language confusing?
Who do you talk to?
Well, that's what I'm saying. Like,
Yeah.
maybe I missed that memo. We're just talking about some comments and people wanting to pull it down, or
Right. So in my conversation, is Brian unmuted?
Yes,
Okay.
Sure.
Hey, Brian. So you can chime in as well. But in work with Brian, the thought process is we could make this a little slimmer and meaner. And why not just do this? Brian used the great analogy. He said, we march down, we're at the 1 yard line right now. And we're going to take a penalty and move back a little bit. So,
Okay.
yeah.
Okay.
Yeah, I appreciate it, and if you can appreciate that I've been trying to get this across the goal line for 5 years, and here I am. But I recommended to Ron. I was up today talking with after seeing some of the comments that were filed, talking with some other surface water rights lawyers. That whole issue about a water course, I just think we could, which I think will be the most difficult issue for it would be the most difficult issue for a water lawyer to answer in a lot of instances, but to have realtors out there, I think one of the comments was, we're gonna put unknown on every time, and it's gonna end up worthless. And I was thinking about the benefit we get from that question. Uh, Maybe not. There may not be enough benefit to experience the pain of going through it, and I just think there's probably a way we could simplify it. I'm talking about a, a precision surgical scalpel removal of the watercourse language and maybe just putting in a couple of extra sentences in its place, because I think that's really the confusing language that gets folks. And that's in both the water notice addendum and the disclosure paragraph 7K. And I think it's just there's a lot of instances where it's really tough to tell whether you have a watercourse. So I hate putting people in that position. And I think there's another way to get at it that's easier.
Thank you.
And I would add, at least anecdotally, we received some comments on this. There's actually a pretty extensive email that was added to materials in the supplement. But in the course of just the discussing this with agents, and as they've been reviewing it at the conference that was held in Houston, there seems to be one, just some of it's education, because it's all new stuff for a lot of and I'll probably tee this up to Brian, but the intro paragraph of when it's required and when it's not, can that be simplified in a way to make it easier to understand? And Brian actually during the break had a really good idea. Yeah, different Brian Watts had a really good idea on a simple way to keep essentially most of the same language, but have it where it catches the eye a lot easier. And so things like that, if we can address those up front, still with the idea this goes forward as quickly as we can, but let's get it right. If we can have the whole package go up at once would be great. If you wanted to share your idea on the.
I'll tell you what, you stall a little bit.
Okay.
May I ask a clarifying question? I'll stall for just a moment. I want to make sure I understand. We would pull back on sending forth any changes, get everything. Could we still, and this is a lack of knowledge piece, do we need another BLC meeting between now and when commissioners meet in November to get everything done and then push everything up in a whole new package? I don't know. I'm not trying to put more work on everyone, but.
Can they pull down and adopt and republish at the same meeting?
Well, we could repropose. So if you had changes that you wanted to work on, we could repropose those changes at the November meeting. So they were proposed at the August meeting. They're potentially up for adoption at the November meeting. We could repropose, kind of restart that clock. So it's essentially withdrawing and then reproposing.
And when is the November meeting?
November 3rd.
Ooh.
Yeah. Oh, that's tighter than us.
Yeah. It's pretty tight.
Yeah. Okay.
I think
sometimes I should.
Well, no. Think about that. In the thought that we were discussing over the lunch hour was to ensure we had enough time not to rush things through and to look at having a 2-day meeting, or at least schedule 2 days for our next one. That way, when we come, we don't run into a block, right? And where everybody's rushing out. Or schedule 2 meetings was another option of having, like another one for the next meeting. My fear is if we schedule that one, we want to make sure it's long enough, especially if we're diving into, these bigger changes. But
so we won't have any.
Yeah, I'm thinking this
is comments to go through
Well,
in January.
the other thing to think about too for November is there's a posting requirement. So it's not even truly, it would have to be done within the next week or so. Yeah. There we go.
We've all been out there telling everybody to read the red lines, the blue lines, and we've gotten everybody used to what's coming. And if all of a sudden we pull back and we're another 6 months out, because I mean, if we're saying February meeting, I mean, we're talking, 6 months out. I don't think, I mean, I know what they'll say to me because I've been hounding them that this is all coming and be ready for it. And if all of a sudden go, oh, time out. When are they going to, I don't know. I would do the water separate. I would get out the contract the way it is. Maybe you pull down the water.
We'll have one and you have the receipt.
And the receipt page for.
I would balance that to say, it's almost like a thank you for not making too many changes on the other side of come back and right on the heels. And a point that we were talking with Texas Realtors earlier, the changes that we discussed earlier, put this back out there, the 5A has not been made yet. The change to agreement 5A, it's up for proposal and it's not a sure thing. But they have a lot of changes themselves beyond that form. There's many, many forms that a lot of license holders in Texas will be getting used to for Texas Realtors that, if our form's on top of it, it may be another thank you because of that, that big round that's coming out. Not that it dictates anything what we do, but it's just a reasonable thing, Tanya.
Well, I'm more inclined to say to delay it, to do it right in total, rather than a patch. And there are questions that title has, or is what is going to happen between now and March. That in itself seems like reason to delay. We could get the other things we've talked about, like the amendment, the backup, other addendum placement, all in one. It's going to be a finished package that looks more professional coming out of this committee and Trek. So, and to the point that they say, I got enough to learn with all these other changes on these other forms, and let us really get it right so that we don't look like we can't do it right the first time, or we're in a great big hurry and we screw up.
Yeah, agree.
To be very professional in my wording.
I think that's, I concur.
So I think.
Okay. So I think my recommendation would be go through the rest of these comments and then
make all the edits.
Go ahead and take up if there's other edits that we need to do here. Are there forms in here that we should move forward with, in y'all's opinion?
There's nothing that has to move forward. The ones, so there's the backup contract, there's the lead-based paint addendum, but that's still tied to largely to the listing or the broker information page, so you don't have to do that. And there's a seller disclosure notice, but again, that's on that recommendation. So nothing that's anything you have to do.
Okay. And the flood notice is already.
Oh.
It's up.
Well, so that's already in effect. So that was kind of the other statutory change, but that was into effect 9/1. So you're not on a timeline. You could do that one.
Seems to me that one would eliminate some question. We're probably not going to get into the leases anyway, right? Except for that. That's the only reason.
Yeah.
Was there reference to the brokers or anything?
No, I don't think so.
Yeah, I don't think that was.
It's just the removal of that paragraph and that additional language on the notice itself and the use section.
Well, I'd say just go forward with those two then, for the commission to adopt those. The leases.
And the floodplain notice.
And the flood notice, right?
The requirement to provide the flood notice in the lease packs. So the law changed for leases that are basically lease packs, 9 days or less short-term leases executed with other document. You no longer have to provide that flood notice.
Right.
And so this would be allowing that change to go through to match what the law is. And none of the water stuff at this point.
We'll just need to change.
Oh, that's another.
But that's okay.
We the legal update materials have the water.
Thought you guys were.
See, it's the opposite one. Last time we were looking at how to keep it fresh with the contract changes that come out, which but that's good. That's it's like on the other end of the
treasury saying we're going to adopt a rule. Really
yeah, I think all things considered, that sounds like the most reasonable course of action. And so we have that one packet that's people aren't having to learn over and over, and we get it right.
Okay.
First.
So I don't know that we need a formal motion, but the general consensus is that the two temporary residential leases and then the notice move forward for adoption at the November meeting.
And the notice being
Which
the,
notice? The flood notice.
and that's, are we, where did we
Well,
actually
let's go to that.
Yes. So we double check, see what changed.
That was the change there is just on the use at the top, not required.
Okay.
My recollection was that you made that form just because of the law.
Yeah.
Even though it really wasn't necessary. No, we belabored that. So will that form just disappear because the only purpose was for short term?
So that's not been the recommendation at this point. The recommendation was just because it's not like it's prohibited, but it's just not required.
Right.
And so the fix that was suggested by the committee is just to add on that notice section at the top. It's not required.
Because we don't provide a lease. The only lease that the license holders have out there, unless they have their own, is the Texas Realtors one, and they have their own version of that.
The temporary lease
floodplain, of the notice of the landlord to the tenant about water and if it's flooded or we developed that floodplain notice months after, just because it was felt by a couple members of the committee, I believe, that we had a sellers and buyers temporary residential lease. It was a lease, therefore the floodplain notice was developed. So moving forward, since we don't have a lease, would the consumer be able to then use that lease on anything that they had? Because Texas Realtors has their whole total package,
Notice.
including the notice.
And the notice, for clarity too, it's a voluntary form, it's not a mandatory one, which then allows Texas Realtors to have their own version, right? So if it's mandatory, they wouldn't be able to provide one. So are you thinking that maybe we just take it out completely or
Well, I'm kind of leaving it up to the attorneys here. The purpose solely was because TREC had temporary residential leases, and one of the members felt and encouraged us all to have one, and we moved forward. Is there a use for it? It doesn't need.
it wouldn't be called for in our contracts?
I mean, it's a statutory form. It doesn't hurt to have it up. And for non-realtors who, if they use another lease form drafted by attorney or
That makes sense.
That is use that.
That's good.
And we can always keep it on the table to see if we ever want to in the future.
Right.
With pushing it through with the other change, it's a minor change, but it is a thought to have it back of our heads
Makes
too.
sense. Sounds good.
So is what we're asking is if we want to go ahead and say we'd like to send up the seller's temporary residential lease, because we've marked through paragraph 23, the buyer's temporary residential lease, marking through paragraph 23, and then the landlord floodplain and flood notice, because we made the change at the top, not required with a temporary lease.
Correct.
I mean, I think all of those are still good and valid.
Yeah.
And separate.
Standalone.
Okay.
So then those would go forward for the November meeting for adoption.
And we'll withdraw all the rest.
Okay.
Okay.
So then just for timeline, we're looking at reproposing in February, which would be a June adoption at the earliest.
For reproposing in December for the meeting.
They would look at it and.
So the next meeting is February.
Or February, sorry, for us, we would push it through, well, our next meeting is January, yeah, sorry, January.
Right, we push it through commission on
Commission.
February.
You're right. I had
Which
And then you-
they could possibly adopt at their
May meeting.
May meeting.
And then
Exactly.
earliest would probably be June.
Yeah, that we would see it.
Okay.
After adoption and then.
I'm just getting that kind of.
Yeah, it's still yeah. Brian's emailed us language to look
Okay.
at.
Did that require
Do
any
you want
kind
to
of
go through the
motion?
rest of this and
You can.
then
but I-
comments and knock that out since we're on the agenda item?
Yeah.
Or then maybe that you don't need to discuss now that we have that motion.
Yeah, most of them are related to that. We can jump through. I think there may be a couple on different.
Yeah.
There's like about paragraph 22 couple
To
of
look at,
comments
see if we
there.
need to add into the next story.
She still lost the thing.
Because of the delay in water, how do we handle that in legal now?
It had to be well. Water, I still think can be the topic. It's a matter of what we do with the notice and things like that. It's still the issue's still there. We're just making sure we get it right in the forms that we developed to push out. So I don't think it changes too much other than the form discussion. But someone will have to.
No, you're right. It's just that one. I mean, it's.
There's a lot of good information for Mary was in the class in San Antonio, but there's a lot of good water information in the updated legal update materials.
Some credit goes to you. And it's not.
Yeah.
She did the legwork. I just changed some commas, semicolons, things like that.
Yeah, it turned out really good. That's a good section. That's one that I'm teaching in the class. So good job. Okay, so we'll jump in to finish up the comments, and we'll circle back around to the language that we will look at in the water notice and potentially back to penciling. And so these comments that are repetitive, I'll skip over a little bit faster than we have. We've been moving along. Let me know if I missed anything that's different. So I think we left off with Miss Pam, on about paragraph 8. So Gabriel.
With the question with Pam, you guys made a comment that we were going to change some words.
Yep, we get to go back to that now.
We're going to mark it and go back, or we're going to do it now as we go through. I'm just
we can go. That's one we can knock out. I in my mind would go back through, but we talked about removing that altogether or adding additional language. I believe the thought was removing the language altogether.
Yeah, number 8.
So I think we can put that in the minutes.
Get us back up on the screen.
I'm just writing the minute.
Oh,
We're on the comments.
No, I thought you were typing something.
Yeah, delete 8B.
So if that brings up thing, if we delete 8B, do we need to remove A because it's only A left in the paragraph?
Correct.
And we don't need to say anywhere in the contract about the obligations of the parties to pay their brokers. Because it's not listed anywhere else, right?
No.
I mean, under like under paragraph 12, where it talks about these expenses have to be paid. We've got some wording around buyer brokers fees and stuff. I don't know. Does that mean we need to have that somewhere in the contract in some way, shape, or form, or no?
It doesn't strike me as something that would be needed because it's a separate private contract. It's almost what that language was intended.
Right, to let people know it's separate.
But then taking it out, I'm not sure it would cause any confusion on looking to the parties on private contracts for that payment. But I mean, anybody else share or think that we may need something to highlight to brokers or?
I don't think so. I don't think so. I just want to make sure it's like not a problem in the contract because we do talk about it in other places to be certain that it's not misconstrued later.
It probably will be misconstrued a little bit when we take it out. What do you mean? It's all in here now? I can almost guarantee we'll get comments like that, but I think that's probably a pretty quick education issue at the end. I would hope.
I mean, we can look at changing paragraph 8B if you like, if you prefer leaving something in and saying, it's really not a contractual clause. It's just a statement of fact.
Mm-hmm.
There was a very good phrase that we had come up at the end. I forgot exactly what it was. Not there, but we had reworded it. I forgot if it was you or Brian.
Yeah, it was
made a statement that was really.
Yeah, it was just that each party's obligation to pay their brokers contained in separate fees, separate agreements. We could do that.
Now, I think we were talking about last time was to remove it. But if anybody else has to temperature revisit that, and remember, we're coming back for another meeting. So if we did this now, we could always do something different later if we think about it, that it might be a concern. And we can see if any comments are received.
My recommendation was just to delete it for now.
Let's do that. And then we can, if there's a concern or comments received, and we can always, we're going to have an opportunity to revisit it again if needed. Okay, so the next one, so Mr. Gabriel likes 12. He likes taking out 10. Lacey Johnson has a new comment about paragraph 22. And asking we had a checkbox for form selection for broker compensation and water disclosure.
No.
There's another paragraph 22 comment about which we include or which we don't include, but I think we're broker we cannot do, and water disclosure we'll look at as we get to that language. Kimberly McLaughlin, do you have a? Okay.
Since we have some time, would we want a subcommittee to work on paragraph 22? We've talked about, reworking it.
Putting them in alphabetical order and all kinds of other things.
Various suggestions to bring back to the committee on approaches.
Some, if we can't get to it in the meeting, maybe later when we look at it, that may be a good idea to further along some discussion on it. Because there's another comment whether two of the notices are in there and which ones we talked about before. It's okay to duplicate between the title notice paragraph in 22. And we may be able to talk about that in the meeting. If not, subcommittee might be a good idea.
There may be some people who have some strong ideas about it, could bring a list to the next meeting and save us time.
Yeah.
Don't look at me.
Hey, volunteered yourselves.
My idea.
Yeah, I think.
For a volunteer.
Yeah. Yeah, I think let's revisit that at the end. I think that might be a good idea to push along some thoughts for all of us to consider there. If we go to, I think that's just 22, okay, to reorder. She has ideas on how to reorder it there as well. So paragraph 12 change from Julia. Let's see, should be in amount of, we discussed that. Kelly doesn't like, same one. Kelly, same one. Duplicate for Craig. Kristen Abney also does not like change to 12. Christy Reimers, Miss Kirsty doesn't like 12. Same for Alejandro, doesn't like 12. And does like 12 in the water disclosure. One of the few that wrote in for that. Miss Angela thinks we should move language, move the checkbox only one. She's the one that had that comment earlier, which was a very good comment. I love when we get these that pick up on other issues we don't think about. Lori Kennedy wants to leave in page 10. I was trying to figure out exactly what Stacy Gonzalez at the bottom of the page was asking for. Would it be beneficial to add a line to 12.2 for the buyer's compensation to be added?
She's saying that in the contract how much the buyer is going to pay for the buyer brokerage fees. Like we've covered what seller's going to pay towards it, but she's asking us to put what buyer's going to pay towards it in the contract.
That's in your agreement.
Yeah.
Oh, so not just looking at the buyer's rate, in the contract, or hey, buyer, you're paying this.
Yeah.
The difference, instead of having to amend the buyer rate.
And I'm pretty confident there's not a sense to do that.
That's another bag of worms.
That's a big one. Lee Williams, water disclosure wants to be added to paragraph 22, which we'll go over.
I thought it was interesting that Lee said that this might be used in most offers written.
I thought so.
Because a lot of the conversation has been that it's not going to be used quite as often. But I think it points to the geographic areas that there are some places where this is being used all the time.
Does anybody know where Lee Williams practices by chance, or what type? This is one of the few that have said that. That is a good thing to pick up on. We have Bart Stockton, who wrote in a well thought out comment here. He proposes changes to, he believes the proposed changes to paragraph 7 are going to be a mess for practitioners and the public. Feels that instead make a mini seller's disclosure similar to one added a few years ago to other contract forms, kind of like we have built into the farm. We have 4 contracts that have seller's disclosures in it: farm and ranch, the new home contracts, and the unapproved, because they're generally exempt from 5008. Not everyone, but a lot of them are. So it's another alternative thought that we've discussed in the past that we can continue to consider. But then a seller is aware, notice must be attached. Then the proposed has received or has not received, but seller shall deliver the language. This was a interesting comment. Also, it seems like there's a situation not addressed where the property could be located in a GCD, a groundwater control district, but the water notice isn't triggered unless there's a well. This will likely lead to buyers not receiving notice of the GCD until after closing when they want to drill a well. And so that's an interesting thought about the trigger points.
Well, unless the GCD has a notice to purchaser, which of course discloses other information. So,
well, the GCD would be different from the MUD district that would trigger the.
Yeah, some of the GCDs provide notice to purchasers. So that's the confusing thing about 452 or whatever it is in chapter 49 of the water code. What we really need to do is get that revised.
That is, Brian, if you're still on, we're waiting on that. That it is, for everybody knows, that's one big push. We recognize the confusion. We recognize how difficult MUD notices in these districts, how difficult they can be to find information sometimes. And there's a little hammer that's out there for the MUDs that are required to do it. If they don't, very little we can do. There's some legislative fixes for the PID districts that have happened. If the right documents aren't filed, then the obligation to provide doesn't arise, or termination right doesn't arise if you don't provide the notice. But hopefully, I'm hoping something similar will happen for MUDs or for water districts that require it. But as of yet, it hasn't. And so, Brian, if you can help out with that, that'd be great. Brian Sledge, not Brian Ross.
Brian wants to.
There was another question raised to me that I'll throw in at this point too, with the trigger points for us to have in mind later, so consumers. A situation when there's a well on another property that's servicing the property itself. There was some confusion because our first bullet point says you're not providing the notice because there's no wells in use or not in use. And so if you have a well that's servicing property on another one, it doesn't fall within that category. But if you look down below, our last one has a catch-all of it being serviced exclusively by, in that case, it wouldn't be exclusively by those entities because it's on the well. But there is confusion on that point. I've heard from a couple people. Holiday question. This was a great comment from Shannon Skerner, and I'm glad we had the opportunity to look at this a little bit further. She brings up with our new definition of legal holiday, where we're limiting it to the Texas Government Code, all of A, which is national holidays, and only one of B, the section B4, that a holiday that is missed is Juneteenth or Emancipation Day. And this has an interesting history. One, Texas tells the United States what its national holidays are. And that's why this issue arises, because Juneteenth is now a national holiday. I think as of 2020, I think is when it became a national holiday. Banks are shut down. But it never was updated in the Texas Government Code. So Juneteenth is not listed as a national holiday in Section A. Now, it is a state holiday, and this was an interesting fact I didn't know. Texas was the very first state in the nation to recognize Emancipation Day as a holiday, state holiday. And it was the only one that had it a paid state holiday until 2020, when others started doing it.
Does it
Yeah.
occur to them?
All about that.
Yeah, and so it's a fascinating history, but I think it's an oversight on us. I'm glad she brought it up. We have a chance to potentially fix it here because one, Texas was leading the nation in making it a holiday. It is a national holiday now. It's just not a national holiday listed in Section A. So I would propose that we add that section in as a holiday to recognize one, that it's national, and two, how proud Texas has been to have it as one.
Is there another part of that list that includes it?
No, so we would have to, so right now we've defined it as everything in A, which is all national under the government code. And the day after Thanksgiving is the one in B4, I think that we added. So what we would do is add B4 and
B6.
B6.
Because B6 was the day after Thanksgiving. Mm-hmm.
Okay.
Yep.
I like that, and I
don't have a
think
problem
that's
with
an
that.
easy fix when we're doing all of our other fixes. So just add the 4 and the 6.
So very good. Shannon, thank you for picking up on that. All these things warm my heart when people bring stuff like this and are actually reading what we put out. So paragraph going to Joe's comment, more space in 12, talked about. Jade O'Hara doesn't like 12.
Yeah, but if you look at what she proposed, that's basically what we proposed. For B, the amount of.
Yeah.
Vicky French again on the paragraph 7 is too long. I believe that was a repeat as well. Duplicate. Craig is duplicate. Lori, I believe, was duplicate to page 10.
I think we put that in 4 times.
Yeah.
Yeah. Lori, okay, we got it.
Same for the whole next page. It's all duplicative, and same for the next page.
See, she's on it again.
So we do have a new one with Linda Escalante.
Mm-hmm. Page 15.
Page what?
15 on the PDF.
Linda. Okay.
The seller's description.
So she says page 2, 3, and 5 need to have YN or U, and YN is applicable at the top of each page. I didn't know if I understood what was being.
I think I got what she was looking for. Is if you pull up the form at the very top where it says seller is or is not occupying the property. And if unoccupied, how long has it been? And then it says the property has the items checked below. Write yes, no, or unknown, and it's the Y, N, and U. And that's the only place it says it is right after number 1. And so they start going, but then you get onto page 2 and it's asking more questions. Are you aware of any of these things? And it has to be in each number, right? So like in number 3, yes, no, or you're not aware. And I think she's trying to just get it at the top of the page. Like anywhere you're filling it out, just do yes, no, or unknown.
She's saying like in 3 says, right, no, if you're not aware, instead of having unknown.
Yeah, it's missing unknown completely from number 3. It's missing unknown completely from number 4. And maybe that was by design. I just kind of got the sense she was just trying to put it at the top of the pages. Like anything on this page, these are your choices to put in.
Well, under 3, you're either aware or you're not aware. There's no unknown.
Mm-hmm.
So I don't understand the comment other than she just, I mean, the instructions are slightly different for each section.
Mm-hmm.
We would have to make if we put just a general one across the top, other ones would have to change. Some are check boxes or.
From the statute.
Mm-hmm.
Yeah, and that's the other thing is if it just came straight from statute, we may not be at liberty to change it.
For a little addition we made.
I know. And the Sunset Commission.
Does anybody feel like we need to make any changes based on that?
I haven't run into any issues with people using it, having problems with it.
Thank you for the comment, Linda, and we'll monitor that as we go forward. Vicky says another thanks. This is different. She said thank you before, so good thanks. I'll take all those we can get. Cindy Bass has SDN insurance question. And this is under our new section that we drafted that has the discussion about insurance amongst other things. And our question is, if you answer yes, that the property is covered by insurance, what do you then, it instructs you to go explain below. Then what are you explaining? And when we discussed this the last time, it was, well, what type of insurance? What are the amounts? Do we put bounds around it or not? I think we grappled with this on how much do we instruct them to say anything, or what do we expect them to put in there? And there is no directive, right? I think it's, if you have to explain, it's generally the type. And I mean, maybe Tony, you were saying, well, how much do I need to actually disclose and give up of my personal private information?
Sounds like something I'd say.
And same with windstorm there, and she points to that agents could pull clue reports. Hesitation doesn't go to fill in agents never touch the seller disclosure, but it's a different way to find some information. So she's really teeing up the question. I don't know if anybody had further thoughts from our past discussion on it. I don't think we went through it pretty thoroughly and didn't have a better idea on what to necessarily do. And there's not a real solution here. It's more of a question.
Yeah, and I know she said if listing agents and buyer's agents would pull clue reports, but I feel like in practice, the person that would generally be doing that is the buyer's agent saying to the buyer, hey, talk to your insurance person. You might want to look up this clue report. And I think insurance agents are going to have all kinds of different thoughts and so forth around that. But I feel like the seller just disclosing what they know, and I think just using common sense, which might be missing in the world today. But the property is presently covered by insurance. Check. Yes, the answer is yes. The answer above, yes, I have insurance. Or I have regular homeowner's insurance, or it's covered by my townhome association, or
however they choose to interpret it, really.
Yeah.
As they fill it out as the seller.
Mhm.
Is really how we left it.
Our due diligence.
Mhm.
You have it, you need to figure it out.
And you can spur the conversation. If then the buyer wants to know more, they can ask for more. It's checked yes,
or they can get the clue report.
Yeah. Okay. Let's see. Lead-based paints. So we have Bart Stockton has a concern that our lead-based paint addendum doesn't necessarily track a federal form, and which you can find if you Google the number, the 9600-040.
Yeah, I pulled it.
And the best I can tell here is that looking at our language, the paragraph D has the word as applicable in regards to, you had on the screen here. So if you look at D here, buyer's acknowledgement,
right.
check applicable boxes. That's not contained in the federal form. That parenthetical is lacking there. And so he believes this creates an impression that maybe it's not required. Maybe I can elect to do it as opposed to it being something that's mandatory.
Well, I kind of took something a little bit different away from it when I read it, because on the EPA form, it specifically has like an agent acknowledgement, right? Like the agent has informed the seller of their obligations, and the purchasing agent has informed the seller of their obligations. It's like the agents have a duty here that we likely aren't paying attention to. And I think the reason that we maybe aren't paying attention to it is because it's under paragraph E on our form. That's where it says we've done that. And we do have a place to sign on the bottom, which may be why we sign on the bottom, even though I know we try to keep the agent's names, the broker's names out of the contract. I'm assuming that the reason that was on there, those signatures at the bottom, is because we're saying we acknowledge paragraph E and that we've explained that they are required to do this. Yes. And I don't know I think that's what he's saying, is it's not so clear because.
Well, my recollection, if you have to also go to the rules, I think the HUD rules are also at play here. If I may be wrong, but I believe those HUD rules require the broker to sign the certification.
Well, it's on their form for sure.
Yeah.
On the
So
900 dash whatever it was for.
right. So I think that it does mirror both the HUD form and the EPA form that came out back in the 90s, if I recall correctly.
Mm-hmm.
So what about just taking off?
Check applicable.
Box?
Well, so I think the reason why that's there, again, I don't mind taking it out at all, but in most cases, you're not getting copies of information listed above because there is
There's
none.
nothing above. There's nothing there that you're getting a copy of.
I'm going to tell you from property management side of things, which is a little just kind of off track, but EPA is really, really all up in property managers right now and big, huge fines if you don't notify tenants. And what I have landlords that are saying, I want my house tested for lead. I've never had that
Tested
before.
for what?
Huh?
What'd you say?
I have landlord owners that are saying, I want my house tested for lead.
Wow.
I want my house tested because I need to make this repair and I have a tenant in place. If I make the repair with the tenant in place and there is lead or there's the possibility of lead, they have all of these things they have to do. Tape it off, clean it up, right? There's all the dust from the lead, right? But if I can get it tested and I can confirm there is no lead, I can just get the repair done. Handyman doing it, not like certified EPA contractor, right? So now I'm going to have, at some point in the future, sellers of properties that are going to be like, yeah, no, I know I have lead or I know I don't have lead. I think at some point, maybe long down the road, there will potentially be more information about this. I don't know, I may be wrong, but I'm starting to see it on the property management side.
And so I've struggled to make the connection with the last box when he says picking out applicable, right? And I can see, I agree with Ron on I don't have a strong feeling on it,
Right.
but it seems to make sense on how it's in there. But I could go
I'm not
either way.
To me, the checkbox on like D2 is confirmation the buyer has received it. Because if a buyer's signing that and it's checked and they don't have it, they should say, hey, stop. I don't have that.
So we
I
take
think,
out.
yeah, I think the confusion that can come up with box number one is, do I check box number one if there is no information to go? The question is, doesn't matter because you're acknowledging you received nothing. But what's the right one? So I think that's why that was added. I don't know. It's not a big deal one way or the other.
Absent a strong feeling, or by jumping in, I always say status quo goes if there's not a strong feeling on it in general. There was another comment on the next one is updating. Well, we've updated down below in the signature line the other broker to buyer's broker and seller's broker. And Yvonne Curtis had a question about does that mean she wanted clarification about an agent signing a form, and I think. I'm rereading this comment here. But when I first read it, I thought that was maybe looking at the federal form because the federal form has agent listed where we say broker and wondering what's needed to be able to sign on the broker's behalf. And I think that would be in the ICA or some other document that they would be granted authority to sign XYZ documents on behalf of the broker. But there's no indication, and I may be reading this wrong from my memory from reading it before, but it's, can I sign that, okay, for my broker, or am I sticking my nose out there a little too far by doing it? I'm not sure there's any changes we'll want to make based upon that, but
I don't think so.
John, real quick, back to Linda's comment. She's confused. That is Texas Realtors she's talking about. But notice on page 5, this track only has 4 at seller's disclosure. So she's talking about Texas Realtors seller's disclosure. She wants the boxes, because the columns bleed over to the top of the page.
okay, so this is that Y in U. Okay.
Anyway, that's what that is.
Thank you. That,
You're welcome.
How you added the first meeting?
And let me know.
Very good.
Okay, so we'll go on from there. Vicky, why is the seller and seller's agent warranted? This is on the water disclosure notice. Maybe we can go talk through this one. I would assume this is in regards to the language at the top of the notice. Her comment is, why is only the seller and seller agent warranty? This is confusing. The parentheses areas are no longer being reflected.
Oh, it's the all caps at the top.
Yeah.
That's what I would. And I'll let everybody read for a second. What I think she's at, this is not the seller, or the listing agent, any seller or their seller's agent making any kind of warranty.
Is she wanting the buyer's agent to have that same?
That's how I'm reading it.
Right,
That's
so
how-
I want the buyer's agent to have the same warranty.
But it's a seller's
But it's
disclosure.
seller's
Right. It sounds like she's trying to remove
Yeah.
buyer agent liability.
Gotcha.
Yeah, that's how I'm reading it.
And if we look over to our seller's disclosure notice itself, it's not a warranty of any kind by seller or seller's agents. So we track the same language that we've had for a long time in the SDN. Okay. Let's see, Vicki Lacey Johnson. So this is a question whether we could combine the water disclosure notice into the seller's disclosure notice itself, which I think we talked about extensively. We'll go to the supplemental materials. So this was sent yesterday.
Oh, that's an excellent.
Yeah, so this was sent about 4:20 yesterday. And it's a agenda item 5 supplement. This is regarding the water notice, which we've generally discussed this about it being confusing and that most people will answer no. And in particular, the area that Terry Covington and Dave Covington operate, there's every single property in their area, which is Bell County, is in a water conservation district, but believes that it's going to provide a lot of confusion with a lot of people incorrectly marking no to the question on there. But I think we'll discuss that language and how to clarify it and simplify it as we go forward. But they did take some time to write in there. And then Avis Wukash wrote in.
Getting older.
This is a concern that the form is being over-lawyered. And I have a big concern about that, and sees a lot of no's because the sellers won't know the answers, and that the agents cannot advise them on the answers, aka the unauthorized practice of law. So, fortunately, we're stepping back to relook at that. So I believe that's all for.
Well, and if I could say, see what we have in the contract where the water notice not required. In most instances, they're not going to have to fill out.
That's right. Especially we can make that clear up front when it's not required, so they don't ask it.
Exactly.
Sure. Yeah. Okay, so we'll go to agenda item number 6 next, unless I missed anything.
There were some other comments on the spreadsheet.
Yes, sir.
I need to finish those first.
For maybe for
I think
7.
Oh, that's for 7. Gotcha.
And my bottom here. So we've addressed the agenda item 6 in regards to the TLTA comment that we'll circle back around for the FinCEN language. That's the letter that we have there. And then, Christy, you brought up an issue. I don't know if you want to.
There was something I wanted on our radar, and I don't know if any other brokers are experiencing this, but we have had a large number of contracts terminate because without being told on our listings, they have been contingent on the lead of the buyer's property. And there's not, while we have the addendum for sale where it's required to disclose becomes a kick out, we're not seeing that disclosed and then find out later on that the lender required it to be leased with certain documents submitted and it's not happening, and then the contract terminates, upset seller, of course. But I don't know if anyone else is seeing an uptick in this, something to keep on our radar, not necessarily, but do we need to either modify at some point in time in the future the addendum for sale of other property to make it for sale or lease of other property, or an entirely different addendum that creates a contingency on the lease of the buyer's property that allows the seller to still market their property and kick it out, and also requires that disclosure and performance of the buyer. Just putting it out there, just on our radar.
It's an interesting issue, but brokers, are you?
I've had the
seeing that?
same thing, and the guy basically took the language and wrote it in a Word document and changed it to the word lease and sent it over. And I was like,
Oh, interesting. I
Yeah.
haven't had that one happen yet.
yeah.
Most
So-
of it's just been lack of disclosure, which is sellers are livid.
Mhm.
Not seeing it.
I haven't seen it myself either. I thought it was an interesting concept, definitely to monitor. And I looked at the form. If we ever did go forward with a change, I think it's possible to keep it in the same form by changing the title and just the first paragraph to make it almost an option, where you have the kick out for sale and then you have kick out for lease, and the lease language would be based upon the receipt of the proceed, or not the kick out, but the trigger point would be the receipt of the proceeds. It would be the execution of a lease or something different, but it could be pretty similar to what we have now, and I think tailored away if it does become big enough of an issue.
It becomes
I
a big
think
issue.
I think what's happening is the market shifting, and a seller puts their house on the market, it's not selling, and then they're like, fine, let's just rent that sucker out because we got to move. And now I still don't qualify unless I've got that income to offset that expense. And so it's just with the shifting of the market and where things are going, and it'll last until the market shifts again. But will we need it again in the future? Maybe.
No, it's just something to keep top of mind, and maybe something we haven't noticed as much before because they're just getting out because they didn't qualify for financing. But now with more information coming out on, oh no, they were required to lease, but they never told us up front. The seller may have never even taken the contract had they known full disclosure up front. So just something that we've had happen to us a lot, and just wanted to put out there for y'all.
Interesting. Okay, I think that's all we had for agenda item 6. We go to agenda item number 7 now. I'm starting with the spreadsheets. So I'm going to have the page number handy. Might have the page number for reference. Everybody's after all the contracts.
I don't think it was on the packet.
I guess we start with the.
Diane more about paragraph 22.
Okay, I'll start with that one.
Wait, what page?
So this is,
104.
and I think the spreadsheet's at the end of that, or maybe not. Let's see. Okay, so we'll start with Diane Moore. She writes in about paragraph 22 and says it's supposed to contain only addenda, and questions why we have 2 notices in there right now, which is the PID notice and the lead notice. And she thinks those should be removed from the paragraph and highlights them down below. And this may go to Diane's point of re-looking at that and imagining it with more thought. And I know we discussed quite at length the PID notice of why we went ahead and included it at the bottom when we originally did it, but whether that stays the same in the broader revamp of it, I don't know. But in reviewing these comments, anybody have any hard thoughts on whether it include at least those 2 particular things or not?
Well, it was putting it in 2 different places, wasn't it? Like paragraph 11 or whatever, the notices under.
Oh, yeah.
We have the notices section, I want to say 11, but I don't
12.
12? Okay. So do we need it in 2 places? Because if we're putting it under the notice, we probably don't need it.
I think when we do our redo, we need to look at 6012 because that is redundant and it doesn't help us over here. And way back when, agents were trained, if the form doesn't say addenda, it's not supposed to be in 22. That's probably years and years ago. And then it started to change as we grew with the form. So we do need to give some thought to the wording addenda because not everything that's applicable there is an addenda necessarily. I mean, not in the name of the form. I mean, it may be to the contract. So that's for the attorneys to decide the words.
It's a fair point on the legal side because the addenda, as even the contract states, are that it's part of the contract itself. And these notices aren't really part of the contract. They have to be given under the law at or before the time of execution of the contract, to use general language, but not necessarily to be part of the contract itself.
Interesting point. So then these things being checked here on 22, we look at it as being part of the total package of the agreement between parties, that contract.
Right.
You're saying that's not the case?
Well, they're by our language, they're being made part of it. And I think when we originally included the PID notice, there was the importance of including it rose above the fact that it's going to then be part of the contract itself because of this big termination right that was hanging out there. And we may have done that before we did it's either 11 or 12, I think, depending on which contract you go to, where you list it out. So I think we had that change made, and then we didn't have enough to take it out once we made the ability to list it somewhere else. But no, I don't think it properly would be an addenda to the contract, but the thought of does it hurt by calling it out.
The whole question comes, is there certain disclosures that you have to give? And if it's not separately identified in like the seller's disclosure notice or lead-based paint addendum, which is strangely enough an addendum, but it's a disclosure notice, is it better just to include all the exhibits and disclosures that you would want to be considered to be part of the contract or related to the contract? Is that a better risk reduction practice? So I think that's what you have to evaluate.
And we do have the ability to list PID now in the other parts. And then is it to be legally accurate? Or are you saying it's beneficial to have it as part of the contract itself? Let me circle back to see the.
Well, sometimes you'll see descriptions, that are exhibits as described in Exhibit A, which is hereby incorporated, made part of this contract. So now it is part of the contract. So it just depends on the style of what you want to do. If you want to put all of the title notices and PID notices and all that kind of stuff in section 6 and paragraph 6, that's fine. Take it out 22, that's fine. It's just a style issue.
I see a benefit of agents as they get to the end of the contract.
Just check.
Here's a paragraph.
Double check.
Go, oh yeah, I forgot to add that one.
Mm-hmm.
Yeah.
And in a revamp of paragraph 22, it could say addendum and then underneath it say and attached notices or something, and it could just be part of the redo.
Yeah.
And then the check boxes are still all in one spot, but there's clarity between what kind of form it is.
And some agents are thinking because they put it in 6E12, they don't have to put it in 22.
And they don't.
And the Mud District form was one of them on a transaction recently. So we're going to keep it simple.
Yeah.
One place, not two.
And I don't think they do. They don't have to do it both, but it's okay.
Yeah. And the mud notice isn't listed at the end, right? At
Right.
22. So we don't have, that's kind of a discrepancy between the PID and the mud. That's
right.
No, I think that's a good idea and a good antidote for the case where it can be missed, especially with these powerful termination rights that come along with certain of these forms. A lot in 11 or paragraph 6, a lot of those notices that are in there are actually tied to termination rights we never think about. If somebody didn't use our standard form, I forgot, it's 4 or 5 of them in there, the buyer would have a termination right just as powerful as the PID or the mud. But we baked it in. There's no need for a separate notice because it's generic language that has to be provided. You don't have to fill anything in. So we protect the consumer by going ahead and including it in the contract itself. But I think that votes, this discussion to spending more time between to come up with a proposal there. So maybe get, yeah. So you volunteered. So who's going to join Diane on the subcommittee for notices?
Express an opinion.
Is any volunteers? Any volunteers? You get to pick who you want to be on it. Yeah. That's how it works. No volunteers. You can. I think subcommittees are generally good to have 3 people on it. I know I've been a subcommittee of one and I've talked to myself a lot. And, that doesn't help.
What a brilliant suggestion.
It's interesting. So anybody, you get a pick. Let's see. So you can get
Okay, great.
one more. Everybody's looking down, like I'm looking at the next thing. Melissa?
Yeah. I think
Okay.
we've got three.
Got it. Okay.
Yeah. Brilliant
Be
mind.
Melissa, Christy, and Diane on the subcommittee.
You'll agree with that.
Yes. No attorneys either.
Whenever you just watch
It'll be so pleasant. Y'all are gonna have wine and everything.
You have that for the minutes from the
For the-
subcommittee?
Yeah. Oh, not for the subcommittee. You want me to? Put that in? Okay.
All right. So we'll go forward with that. Okay, let's see what's actual, the next thing in our materials. Veronica Cantu is the next one. Okay, so she writes in about the POA addendum. And this is a reoccurring frustration that there's really not a good fix to it, as we talked about several times, but she's concerned that it's not clear on the nature of the fees that apply when we list the buyer shall pay any and all association fees, deposits, reserves, and other charges associated with the transfer of the property, not to exceed a certain amount. And so the buyer is paying up to a capped amount. And the concern that I think we're all generally share, but it's a hard time fixing it, is, well, what's exactly included in all those fees? And so we know how much the buyer may be paying up to a cap or how much the seller might be responsible for. The problem is, and she provides an example on their second page on how she might like to see it looked. I mean, all these HOAs don't use the same terminology. And sometimes they use the same words and it means different things. And so we drafted this to say, with that associated with the fees, deposits, reserves, and other charges associated with the transfer. And then we separately said, and I think it's your language, Brian, you came up with there about regular periodic maintenance fees, assessments, or dues are different.
Yeah, the problem was that they're all over the place as to how they describe the fee. And
By
we made
design.
it real simple. We made it all inclusive, right? If it's associated with the sale of the property, it applies. And we eliminated, as I recall, we had different paragraphs. We collapsed them into it. I think what Veronica's going into, though, is a problem that I've had on several occasions that bugs the crud out of me. And that is, a declaration says the following fee is the obligation of the buyer. But the HOA addendum says buyer will pay up to this amount. And the seller says, oh, no, that's the buyer expense. It says right there in the declaration. And what they miss is a seller and a buyer can allocate costs between themselves however they want to agree contractually. And the HOA doesn't have any say in whose responsibility that should be. So, and I've had big arguments with people. And our claims guys in one instance says, Brian, you're right, but he's arguing over $750 and we're not going to hire a lawyer over this. So we're just going to pay him. Okay. So the key is, I think we need to have a sentence or something in the HOA addendum that says that the allocation of costs between seller and buyer in this addendum controls over any cost in any statement in the declaration of the contract.
Absolutely.
Yeah. I like that.
What stops the declaration from saying it controls over any contract?
But the point is, this is a contract between the seller and the buyer. The settlement statement is signed by the seller and the buyer. That is the deal. And if they agree to it,
Well, nothing.
I have the obligation, the buyer has the obligation to pay their broker under the buyer rep agreement, but the seller can agree to pay it, even though that's an obligation of the buyer.
And if I could add to that, and we must have this come up a dozen times a week, paragraph C, and the title company said the cost goes to the buyer and the seller because of just what you quoted.
Mm-hmm.
And then they get mad at the title company for stepping in, and to the definition we got from our own company attorney is that it is the contract between the buyer and the seller that rules. So this has been, ever since it was redone, the HOA addendum, lack of clarity. So I think that needs to be on our list of things to improve upon soon. And to point of some additional wording. I know Ron worked very hard at C and did some seminars on it, and they don't have the problem of understanding it. It's when they're getting the direction from the title company, who's getting it from the HOA, who's saying this is the way it's supposed to be, and they don't pay attention to the contract. To your point, to education, I know. I agree.
I like the idea of adding something about this controls. I don't necessarily like the ideas of the other stuff that she's got in here about spreading it all out, because I feel like the way we did it was it's on you to go find out how much this is going to be. And you need to know that ahead of time. And if that means you need to buy a resale certificate early, you need to do that so that you know what amount you're willing to pay based on what the fees are going to be.
Yes.
I don't think we can spread it out because they're all still called something different.
They are, and they're going to change it because as soon as it's legislated that they can't have this kind of fee, they're just going to rename it another kind of fee. That's absolutely how it's gone. When they mandated an amount for the resale certificate, they're like, oh, fine, we'll do that, and then we'll charge this extra fee. Yeah, exactly. So we don't have enough control there. I think it needs to stay the way it is, but I like the idea of saying that this is where we decide, not somebody else's document.
So look at throwing that on the screen if we want to look at. I'm hearing a big enough issue here on that may have a sentence to clarify, subject to.
See, we don't have that form up for consideration right now.
No,
Okay.
but we can, right? We're pulling back all the forms anyway.
Sure. Let me get that form.
Yeah, the problem here, they have so many different fees and.
Oh, yeah.
Well, really what we're talking about is that it doesn't matter whether or not it's payment of the fee or it is a reimbursement. I mean, that's how you essentially work around their provision that says this is a buyer expense. Okay, fine. It's a buyer expense. We're just going to reimburse you.
Yeah. So, and it's the key phrase is associated with the transfer.
Mm-hmm.
If the transfer of the property triggers the fee, then it falls under that paragraph.
And we protect the buyer by setting a cap, and the seller is the one that theoretically should have a better knowledge of what those are. And I see two separate issues really here. One is the naming of the fees, which is one issue on where to plug it in, and a second one of when there's a conflict between the declaration and the language of the contract. The catch-all was meant to address all these weird names, and that was the best I think we could do for that. It'd be hard to come up with other language, at least for now. But this other issue about a conflict, which I didn't see that written. I see that now somewhat in her comment written in. I wasn't reading down that the first time. Seems to be a fix we could do, or at least entertain doing.
Why this one too though? Because the contract already mandates how it's split up. I mean, the contract already says buyer, seller, this is who pays what. And now we have a third party who's not a party to the contract anyway saying, well, here's our invoice. We labeled it buyer fee. They still don't really have control over it.
It sounds like what I'm hearing is a pretty big issue.
Well, will that solve the problem simply by adding a statement? I don't think it solves the problem. You're still going to get the invoice.
You'll get the invoice. HOA will say that, and then the title company who we all know gets to make the ultimate decision.
And
The title company says, well, the resale certificate says this. And this seller says no, or the buyer says no. Look at paragraph C.
Right.
And then so and the parties, whoever is most favored by what the resale certificate says is, the HOA is the no, this is an agreement between the seller and the buyer. And it controls over whatever somebody else, and the escrow agent is not the deciding party.
So we want to say
The
buyer
HOA
shall pay any and all, and we really mean all.
Yeah.
And only the contract decides, not HOA, not title.
Yeah.
I mean, you can add a clause in that says,
And if it's one of my escrow officers, I want to know their name. Same, right?
I mean, you could add a statement here. If the association designates.
Real quick, before we type that all the way out, before we get lawyerly on it, what would make sense to brokers and to the clients sitting down, knowing this provision? You have an HOA that's saying, or the other side is saying, no, this is a XYZ party expense because this is what this says. What language would make sense? It's not just top of your head to accomplish that. So I'm getting the point about clear any and all and this next statement, but before we go legal, what would make sense to on the
Brian's
layman's
statement earlier was simple and concise
Yeah.
about the contract ruling, controlling.
Kind of like, when you do the relocation addendum, it talks about this controls.
Okay, I just want to make sure we're putting thoughts in heads of legal stuff before we.
It's simplistic, and the fact that it has something that someone can read in black and white that says, yeah, you're saying this, and here we are, and we're done. There's no more conversation. It's nice to be able to refer back to it.
Well, I type this up and we can play with this.
All right.
The allocation of costs between seller and buyer in this addendum controls if in the event of
Controls what?
controls in the event of any conflict with any of the subdivision information furnished. Subdivision information is the declaration and the resale certificate.
Okay, let's see. I was thinking, why don't you just say that controls over any any designation by the association as to who pays the fee or the cost. The allocation of cost between seller and buyer in this addendum controls. I'll just hold that down here. Over any designation by the association as to whether the cost is to be borne by the seller or buyer.
Well, sometimes it's not the association. Sometimes it's in the declaration itself.
Okay.
Association documents?
Well, that's the subdivision information. That's the defined term. It's the copy of the restrictions, bylaws, rules.
Well, sometimes it's just the association.
Or the reason. Subdivision information, period. Over any conflicting designation by the association or subdivision or in the subdivision. by the association or in the subdivision.
It seems long. Can I give you what's in that ERC document and then we can, it's
All
like
right.
one small sentence and then we can tweak it. I'll read it to you exactly what it says, but
Okay.
what this says is if any part of this addendum conflicts with the provision in the contract, comma, this addendum will control. So if we took a sentence like that and just said, if any part of the HOA documents conflict with with this part of our contract, the contract will control. Like just make it so much shorter.
With a provision in the subdivision.
Right. If any part of this instead of addendum, if any part of this, of any part of the, subdivision information or whatever.
Well, we don't want to say.
If any part of this addendum conflicts with the subdivision.
With the provisions in the subdivision information, the addendum will control.
No, I think it's if it goes into this paragraph, just say if this paragraph conflicts, because we don't want to say the whole addendum.
Okay.
If this paragraph conflicts with the provision in the subdivision information.
This paragraph.
This paragraph will control. That's so much simpler than all that other stuff.
I think what we should do is probably say.
Yeah, I like that. That's way more clear and crisp and small.
Does cost mean the same speed?
Do we need to be specific on allocation of cost to buyer and seller? So it doesn't look like it's to the HOA or.
What do we put, if this paragraph conflicts with any allocation provision in subdivision information, this paragraph will control?
Yeah.
Because we're talking about money going to the HOA. I'm just wondering if we need to be specific to say the buyer and seller payment. That's too many words, but it's still going to have to be explained to the practitioner.
The allocation of charges conflicts with any allocation in this.
Yeah, I like that.
Can we chop off after the adds to the allocation cost?
Yeah.
Control.
Yeah. I like that.
Does that get you there?
Yeah.
Brian, what does that do for you?
I'm gonna die a happy man now.
And while it may not solve everything, I think that will go a long way towards saying, hey, here we go.
But I think her other concern is not something we need to take up, where she was like, we didn't know there was this fee and this fee and this fee. And that's just on the seller to pull that resale certificate early to ensure that they know what those costs are going to be so that they can determine if that's the right amount of money they want to agree to in that blank.
Yep. And it's going to have to be their listing agent to tell them that. Because they're not going to know.
Absolutely.
I don't think that's
Absolutely. And are you going to keep the underlined any and all? You like the underline there? Because that's not in there now, right?
Oh, it's not underlined. That's my
That's
computer.
an English thing.
Oh, that's your, I thought you were underlining it. Sorry.
That's words saying you missed something.
Okay. Yeah. From back here, it looked underlined. Maybe I need glasses.
Should just be all.
Is the goal, we can't push this one through now. This is going to go with the larger group of changes later,
Yeah.
right?
Yeah.
Okay, just making sure.
But I think by waiting, it's nice because we're adding more stuff in, so we can all just get it done at once.
Because there's a line in the HOA addendum in the second paragraph where the buyer, if he pays for the documents, has to give a copy to the seller. That never happens. So is that an out for the seller, a buyer, if they don't make a copy and give it to the seller? I wonder why the copy to the seller is a requirement of the buyer.
You're up here on paragraph 1.
And
Two.
buyer obtains, had to give a copy of it to this. Or in the first line.
Deliver a
Oh, yeah.
copy to the seller.
Yeah, so what that's down there is that the buyer has the right to ask for it, but that hits the situation where the buyer has asked for it, but he can't get it because the HOA is not giving it to him. So what does he do?
Is that not a separate issue there? Well, the buyer, if they can't get it, they're not going to be held responsible. But that first line is read to say that the responsibility of the buyer is to pay for it, get it, and deliver a copy of the subdivision information to the seller.
Right. So that's his main obligation. And
But
then,
it doesn't happen. Why does the buyer need to get it from the HOA, make a copy of it, and give it to the seller?
well, because under both, I think under the statute, and it was amended some 10 or more years ago, that you used to have to wait for the seller to get it. And then they expanded it. I think it was the seller, the title company, the lender, and the buyer. So those are all authorized persons to receive the subdivision information. But sometimes HOAs just won't give it to people who say they're buying a property.
So if that buyer gets it and he never delivers it to the seller and the seller's got a backup and he wants to get rid of that buyer, could he not call his attorney and say, I never got it. It says he's supposed to give it to me. So he's in default.
You could claim that he did have it. And unless he says it was something beyond my control, but in the example that you gave to him just now, he did get it. So he got it. So he has to deliver it. So he'd be in default.
So is that statute that says it has to be that way and that's why it is? And we need to be sure every buyer knows to make a copy of those documents?
No. The question is, you've got your choice here. Either the seller gets it under 1 or the buyer gets it under 2.
Right.
Okay. So who do you want to go have that responsibility to get it? The statute allows the buyer to get it from the HOA.
I think what Diane's comment is, why are we putting an obligation to even give it to the seller to begin with when the buyer gets it? And where people aren't doing it.
Buyer.
I think you want to show compliance that he got it.
Where my mind goes is having evidence if you try to terminate within 3 days of getting it, having kind of somewhat of like our property approval, right? Of having notification of a copy of the appraisal or whatever it might be
How else is the seller going to know when he got it?
He could get a copy of what was sent to him from the HOA. And what I always have feared in this, and just gives an opportunity to talk about it, is the fact that it reads like an obligation of the seller, the buyer, that if not done, could give the seller the opportunity to say that you didn't do something that the contract says.
Do you see that happen
that's
very
true.
often?
I just saw it happen. That's why it became even more, the I didn't get it. And so if there is an absolute statute reason why,
So the buyer in your case did not get it.
the buyer got it.
The buyer got it.
Didn't make a copy.
He didn't deliver it to the seller.
The second, and then the seller used it as a delivery to the seller, as to say, yep, he's supposed to deliver it to me. They were waiting for something to find that the buyer didn't do right. And so I didn't get it. And the question to his agent was, doesn't that mean that I can say that?
So
he's in
more than
default?
likely, the seller is waiting till this time period passes up here. You need to go get it in 7 days after the effective date. So I would be looking at, if I'm not trying to confirm from the buyer, if the buyer doesn't deliver it to me, but I suspect he's gotten it, but I don't want to ask him, then I'm going to wait for this time period to pass and say, you didn't get it within that time period.
Does it say someplace in statute that the buyer has to do that? That's my question.
No, this is contractual. No,
So
the statute
who
only
wrote that? Why do we have, as John said, why, that I said, why, I'm questioning, why do we have that provision in there? Why that extra job of the buyer that I don't think any buyer does it, nor any agent says to their buyer, you have to do that?
Ron wrote this.
Yeah, and this is where I see you getting tripped up. I see exactly what Diane's saying. Is it a surplus language that really, I think we think about, hey, if you want to exercise that right, we're going to have notice and that you actually got it. And so it's built in there. I'm not sure what the original justification was, but is it causing a situation, and it may be a 5% thing right now, but is it causing a situation that we know is wrong? Like when everybody put escrow agent, the wrong escrow agent in there, where he unfortunately had a case where it rose to a level causes an issue. And I bet lawyers looking at this stuff are looking for every little thing and are going to pounce on it. Whether that's material or not to get rise to termination right.
That's an out.
It may not be. But it gives an argument. And so I think Diane's points, would something look to clean up if it's, surplusage to.
So you're suggesting you want to delete this.
I'm not suggesting any, I'm seeing Diane's point to think of, I see where that arose and I see where a lawyer might try to use it to say you're in default. I'm going to paragraph 15 and I'm terminating this contract.
The second sentence.
The second sentence.
Point is take out and deliver
And
to the
deliver.
seller. Just the third part of sentence
Yeah.
one, right?
Right.
Just that little piece.
So really what you would say.
To your point, Ron, it's the notice to the seller, I got it, so my 3 days click in now. Maybe that's where the two lines just need some cleaning up when we do our cleanup project.
So would it be better to say, all right, buyer, you have 10 days to go out and get the subdivision information. And within those 10 days, you can terminate.
Well, it says they have 3 days to review it after.
Let me make a counter argument real quick just to reframe with this language for why it might be good to keep it in and educate. Because if we're looking at the allocation of costs, how many sellers actually have these documents at hand, right? If they're lucky, they can go back and find the PDF file from when they bought the property, however long ago.
Yeah, it's not going to be good anymore. Yeah.
And so by having the buyer have the obligation to send it to the seller, when we look down at the allocation of cost and what controls over what and what the fees might be, it's giving that seller the right to get a copy of it so they're fully informed. Even though they should have it and be in the best position, we know they don't, but it's.
Because we don't want them to make a copy, the buyer to make a copy. I think we're getting off of.
Oh, I think a copy would be, the electronic file is how the vast majority of these are sent over. So I'm not sure I see the expense side as opposed to, here it is, here's a copy of it. Not that it has to be physical.
Yeah, especially because some of them are like 500 pages long.
Yeah. And so.
Yes, it's laborious, therefore it's one of the reasons it's never done.
Let me tee up maybe another issue real quick that may go along with this to have a look at it in whole. And I don't remember this being discussed back in our farm and ranch side, but the farm and ranch contract itself has as an addenda the POA addendum. What the farm and ranch contract does not have is the statutorily required language about property owners associations that then gives a right to every buyer under farm and ranch contract to terminate unless it's somehow provided otherwise. And the language of this addendum does not include that language. And so if you have a farm and ranch property that's located within a mandatory property owners association, our contracts don't provide what's needed, and it opens up the door pretty broadly. It goes into that thing before about once you get it out of our standard contracts, all these other termination rights were on autopilot. And so I think we need to look at that to plug that, what I see as a whole. If we're having farm and ranch to be used in situations where there's a mandatory association, this could be part of a bigger look, doing this plus looking at that.
I've got a hand raised over there too.
Yeah. Kristen?
Yes, I was just thinking you could just have it delivered to the seller upon request by the seller. That way the seller will know that the buyer has it and have the ability to look at everything without the obligation of the buyer giving it to him without realizing he's supposed to.
So that would satisfy your concern of the mandatory are being used as an out when it's not really done, but at the same time still allow them to.
Yeah, I think though, then if you're not going to deliver it, then you have to tie the termination to the number of days specified to obtain. So to keep it easy, what you basically would want to do is to say within so many days, you need to go out and obtain at your expense the subdivision information. And within that same time period, you have the right to terminate the contract for any reason. And you need to obtain that information, review it. And if you want to terminate within that time period.
And that's not changing up that at all. I think that request, this is specifically to delivery from buyer to seller.
No, but I mean, the termination right is tied to the delivery date. It's not tied to the number of days to go out and get it.
But for the buyer receiving the information.
Right.
Not from him giving it to the seller.
If I put in 10 days, but I get it in 5, and I properly follow this, then my termination right is on the 8th day, not on the 10th day. So if I'm not going to require delivery to the seller, then just tie it to the number of days that you specify in there.
We have the same concept with respect to when the buyer gets the survey. And we say, and I just pulled it up, within blank dates of the effective date, buyer may obtain a new survey. Buyer is deemed to receive the survey on the date of actual receipt or the date specified in this paragraph, whichever is earlier.
Yeah.
And so
that's what we need to do.
If you haven't received your resale certificate by the last day, you're deemed to have received it. And that's when your time period to terminate starts. Right.
Good enough for the survey, be good enough for the HOA docs.
Yep, that's good. So do we want to move in that direction?
Well, I agree with Diane. I know the buyers aren't sending it to the sellers.
Okay.
And again, as the market has shifted, depends on who's paying for it, right? Are we checking box 1 and the seller is paying? Are we checking box 2 and the buyer is paying? And
Yeah, but
we
then
had
the
a lot
seller
of
has to
buyers
send it
paying
to the
for a
buyer.
while. Huh?
Then the seller has to also buy it to the buyer, right?
Well, the buyer,
it says.
the seller, if we check box number 1, the seller does have to deliver it to the buyer, but the buyer's the one that needs the information. They're the ones buying the property and they need to know the rules before they play the game. The seller already lives there. They should already know the rules. You know what I mean?
Yeah, although, the seller would like to have it in case this buyer drops out and they'll have resales for the next buyer.
Sure.
I think it's a good fix. And if we were in isolation without doing other things to this addendum or these other big rounds of changes, I might lean towards it being at 5%, let's monitor. But if we're making these other changes, I think it's a good change and that makes it fit the practice on the ground. That'd be reasonable to do.
Well, let me get
the language from the survey.
Yeah, I just pulled that over. So let me stop sharing on this side. Let's share on the other side. So this is the language in the addendum. So if we actually use this.
But it's the after lunch one.
Yeah.
And then here we'll just cut and paste this. They shall obtain So, no, we should say is, yeah, now this is where it says we need to pull in this. Where, let's see here. Here.
That whole last sentence.
This whole thing here. So if he can't get it, then he just needs to terminate. Okay, that makes sense. Well, that makes it makes it easier to read. What do y'all think? What do you think, Diane? We're gonna make this the McCoy paragraph. So it's number 2. This is this one here. I think it works, actually.
And then leave the rest of the paragraph in there about if the buyer due to factors
No,
beyond
that
their
all
control,
comes
or all of that's coming out.
All that comes out. He just has to terminate within the time period because he's deemed to receive it on that day.
Okay.
And then he's got 3 days after that to terminate.
Well done.
And it's short.
And it's shorter.
Language.
Look at us making it shorter again.
Brian is on a roll today. Did you know that?
Don't stir him up. He's
He's got like 4 wins already.
Don't stir him up.
Let's see. That's paragraph. What is it? 1, 2.
It's paragraph A2.
Okay.
If you don't mind pulling up either the 1 to 4 contract real quick, just run down this other issue. I think since we're making POA changes, it's a good time to address. Oh, we're gonna take a break actually. Let's after that break, I'll tee up what I ask you.
Okay.
We'll take a 10-minute break. Come back at 1. Okay, we're back on the record at 2:23. We're going to jump in now Well, I guess to finish up the POA discussion, like to tee up this issue, and if it becomes too long, I just want to spend a second on it, we can always talk about this at the next meeting. And if you bring in the property code, or this is good here. So this language on the screen right now is out of the 1-to-4 family contract. And you can see this big long paragraph, some of it's bolded and underlined, and that's because of the statute on at the beginning. It cites that the property is subject to mandatory membership in a property owner association. Where's it? 512, yeah. So notified buyer under 5.012 of the Texas Property Code. And it gives this big long thing. That paragraph is not in our farm and ranch contract. We do in the farm and ranch have the addendum. If we look at the property code, 5.012.
Oh, you want to pull the.
Yeah, if you don't mind. This is the property code, and it says a seller of residential real property that is subject to membership in a property owner association that comprises not more than one dwelling unit in the state shall give this notice. And clearly it's lacking from the farm and ranch, but we give at least the implication because of the ability to attach the POA addendum that it can be used in this situation. And in fact, like little ranchettes and stuff that are becoming more and more common. I don't have a strong feeling of one way or the other, but I think we need to take action to prevent the error that we have. Either add that language from the 1-to-4 into the farm and ranch, which a lot of people screen because it make it longer. Farm ranch guys say we never use it. There's hardly any of the ranchettes. Or we can remove the addendum for the POA addendum as one of the paragraph 22 items. Because in any case, if you have a POA addendum attached to farm and ranch, you're not providing the right property, the right notice that's required. And what's scary is at the bottom of here, it gives the buyer a termination right up to 7 days after receiving the notice. So effectively, it's going to operate just like the PID. We just have always had it built in. You never had to think about it because it's built into 1-to-4. And I think it's just a gap by not really thinking about it and how it might be used in farm and ranch with the ranchette.
So are you suggesting to take it out of here and put it onto the addendum?
No, I'm thinking because the addendum, I think it's safer to either add it to the contract. And that's kind of where my light default lies is adding it because of knowing that some might want to use farm and ranch for the farm ranch accessories. But I still, Ron, I can easily be persuaded to just remove the citation to the addendum and do education that you shouldn't use this. Or that there's
paragraph 22.
Yeah, from paragraph 22. Yeah, I'm sorry. Remove the POA addendum from paragraph 22 and have education that you should not use this when you have what you think might be a farm ranch property if it's in a POA.
Yeah.
And
I like that. That's what I like.
Removing the HOA addendum
On farm and
farm and ranch, just farm and ranch, and it just is I think a gap that didn't realize. And I know we've talked about the farm and ranch having the POA addendum attached to it and it left it in, but never really addressing this issue. And it just came. I was doing some research for other topics, and this came up. But one of the big issues. So I would. It sounds like it's easier to take it out than it is to add it in.
Put that on our agenda for our subcommittee meeting. We're going to look at that. Paragraph 22 as well.
Okay, so we can
come over my cat. Don't we come over my subcommittee?
So we just decided to look at removing the POA addendum from the farm ranch. Not sure when. Amen. So we'll look at that. Any more on POAs before we move on? Okay, so we'll go to the next comment here from Alberto. He writes in about the 1031 exchange addendum and highlights that there's all 1031s aren't created equal, basically, that there's some that are riskier or more complex and they have different timelines than other 1031 exchanges. And he provides an example of a deferred exchange versus a reverse exchange. And he makes several suggestions along with this to either add to the form to identify the type of exchange being conducted, to clarify the obligations of each party in regard to the timing, disclosure, and risk allocation, and ensure consistency with the clause that closing will not be delayed as a result of the exchange. I think the basis behind this comment is giving more information to one party or the other on potential issues that might arise, or delays, or risk involved in a particular deal. We've drafted our addendum to be very simple, to address the thing of a notice issue to begin with. Before we had the addendum, parties never knew whether the other side was doing one. And it might weigh on their decision whether to go through with that particular contract. So we gave notice that, hey, this is a 1031. I always call it play nice in the sandbox provision, that parties will reasonably cooperate with each other. And then we have a statement that closing cannot be delayed because of it. Paraphrasing there, but it's very simple and short, and I think accomplishes some of the goals, except for his desire for the complexity to be kind of done at a more granular scale. And so I tee that up for everybody, but brokers. Are you seeing issues with this form? Are you seeing the need for any more clarity in transactions?
I'm just going to say, just from experience, and other brokers may have different experiences, prior to the 1031 exchange addendum, there would typically be a simple 1 or 2 line attorney language that would get inserted into special provisions. That would be the extent of it. There's not the complexity that was here.
No.
What I think occurs with the upfront notice, with the exchange addendum that we did simplistically, was it can prompt the seller or buyer. I mean, it can prompt the other party to ask more questions if they want to know more. So that's where I like the simplicity. And I think that offers the other party the opportunity to say, let me ask more questions around a 1031 exchange if I want that information or not. Those are my thoughts. Leave it simplistic.
Mm-hmm.
That's what I see us in. I mean, I'll tell people, they'll come back, can I do a 1031 exchange, or what is a 1031 exchange? But I've never gone into depth if it's a deferred or if it's any of that.
I fear a water district notice thing to properly explain it. Well, it's a good general thought, especially for those that do it, but I think, just like Chris, you said, you summed it up really nice. What we have spurs the conversation and get people ask.
And I think the exchange answers that anyway, and then we'll know.
The qualified intermediary.
Yeah. The person.
Yeah, and I think before you would get into the deal, he wants to kind of shove them to educate them more through the contract as opposed to.
I mean, I learned one thing in Idaho, the lawyers do it. The lawyers and the title company do all the 1031. It doesn't even go to an actual intermediary. They just did it.
Okay.
So every state's a little different.
States are definitely different in how they do their things.
Well, yeah, they were buying here, so I learned that.
So I'm going to go, I think the next one's the spreadsheet related to agenda item 7. And the first one from Denise brings up what I think is a pretty good point and simple one of reordering the receipts on the receipt page to have it start with contract receipt, and then second go to the option money receipt, and then the earnest money receipt. And I think we can look at this if we, depending on what we ultimately decide on the receipt for the additional option fee to restructure. But I thought that was a good comment. It makes sense to receipt the contract first, then the option money, then the earnest. And
that's fine.
Yeah, I like it.
Denise also writes in on paragraph 21, and Diane, I'll tee this one up for you too. I'd like to tee up this one to go ahead and maybe talk through it. She would like an extra space to list 2 email addresses, or it has 2 email addresses, but only 1 phone number for the buyer and seller. Wants to add additional space for a second buyer and seller phone number, and delete the parentheses for the telephone number. Kind of a formatting issue. As we think about that though too, and look at that particular form, Diane, if you want to tee up your paragraph 21 situation.
Probably half dozen years ago in Legal One, there was a long, I think it was 2020. It was just after the pandemic. And I remember Scott Kestner saying, are we really teaching this in Legal One, which was that a copy of any notice was to be sent, as our contract says in 21, to the buyer, the seller, buyer's agent, seller's agent, and a copy to the agent. And it was very strongly emphasized that this was the communication. And even if the code of ethics said that we're not supposed to go directly to the other person's client, the contract basically overrode the code of ethics. And then each year, that paragraph in Legal One gets smaller and smaller. Very recently, our company had an agent who provided the release of earnest money and the termination of contract directly to the seller's agent only. And it was then, that happened to be an attorney. Attorney said, fine, we'll terminate the contract. He's got every right to, but you didn't send a copy to me, the seller, you sent it only to my agent. And then we told the buyer went to the buyer's, their attorney, he agreed. Our company attorney agreed, so we paid $37.50. So the issue there is, according to 3 attorneys, this is what the notice says, which means our practice should be that way. And we should train all the agents that way. It's not happening. So if it doesn't happen until you get to the situation where you have to pay the earnest money because your agent didn't do it correctly, other companies will have the same thing. So the suggestion might be, does it need to be worded in such a fashion that does present that risk to a brokerage, that if their agent doesn't deliver it to the client directly, all notices, not just that termination. And if we're not teaching that way strongly enough in Legal One, that all agents who have to take it know that, then we're not doing our job somehow. And so because it became very real and it will hit others, I'd like it to be discussed.
I think in practice, nobody sends it to the other party. They always just send it agent to agent and expect it to be delivered to their client.
Because that's the way it's always been done.
And so when we made the change to add with copy to, and there's a big discussion there on, we want to get the agents out of the middle to go to, whether it's the seller or the buyer or whoever they designate in there, and the risk associated, with listing agents themselves, listing themselves in there. Because then they are in the middle of the chain for getting the notices. There are some, I think some law that we roughly discussed before on if it just goes to the agent, there's an argument that it's still received despite what's in here. But the clear intention of this paragraph is for it to be sent to whoever's listed up top and just copied with the copy to the agent listed below. I think it's a good educational item. I wouldn't want as a practice to change it up to have it go to the agent because of the risk and additional issues that can arise because of that. So I like how it's said. And if the agent wants to be in there after a discussion with their broker and their client, then they can list themselves in there. But I agree. I see that wrong time. It feels uncomfortable. It feels weird when you send a document over to the other side that it's not your client. If you represent the buyer and you're sending it to the seller, it feels weird, but it's the contractual requirement. And
I'm going to be the attorney who feels differently than the other 3 that you talked about there.
You want to pay the $37.50?
I think if a notice is received by somebody, I don't care if you gave it by pack mule, it's an effective notice. And paragraph 21 doesn't say anything to the contrary. So look at the way it's worded. All notices from one party to the other must be in writing. That's true. A notice must be in writing. And are effective when mailed to hand delivered or transmitted by fax or electronic commission. It's valid. It doesn't say are effective only when. So I look at the second, I look at this as 2 parts. It has to be in writing. And then the second part, what makes it effective? I think this is a safe harbor. And if anyone ever asks me, how should I give notice? I say, the first thing you do is you give notice in the manner provided in the contract. But does it anywhere say, if you gave the notice in by any other method, it's ineffective. No, as long as you give writing in notice, you give written notice and they receive it, it's effective. I look at this as just being a safe harbor that this gives you the protection. If you follow it, this method, you're okay. But if otherwise you are at risk, did they actually get the notice or not?
I'm curious
Bold, it
going,
says to buyer, to seller, period.
Well, and that's what's intended. And this is where the law creeps in that's written behind the language of it's clear. That's clear intention. That's absolutely what we want to do. But there's these fallbacks that they may say themselves despite not following the contract. And so, but why put yourself in that position? And absolutely education to do that.
Track coming down.
Yeah.
Because it's still blinked on a lot of contracts. There's no information, or it has the buyer's agent's information up there,
well, and
which is crazy, but it still happens.
I do agree that it does deem further discussion because if we have the agent and the client in there, which is what we teach, then when I'm reading that or when a party reads that and it says all notices from one party to the other must be in writing and effective when mailed to as follows, to me, that's everyone that's there. And if it's not, then at the end of the day, if we don't address it, it means attorneys have to get involved when there's disputes, period. Exactly what happened in your situation. We've had comments around that as well. And I tell our agents, that's what it says. I recommend you do everyone. And while it does feel funky, that's what it says.
And that's what we intend for it to be. And so as far as making changes, what I'm trying to think of what
I think what we need to look at is it clear? Because one, do people have an out saying, just like in your situation, that if we don't send the notice of termination and only send it to the agent, it's not really we haven't finished terminating. So what are we clarifying for agents and brokers and parties to the contract saying that everyone as follows? I mean, I don't know if it needs to be clarified that it's all notices to all parties below.
Beware the unintended consequences.
Yeah.
You know, it doesn't say anything about the seller's work address, but I know he works at the office down the street. And so I hand deliver him the notice down the street and put it in his hands. And then he says, well, after the time is expired for the termination, he says, you didn't deliver it to my home address, which is what was in the contract. And so I had my fingers crossed. You didn't really terminate the contract. And I'm going to say, I hope you have a better argument than that. Okay. Because you got the darn notice. So again, this is a safe harbor. It is wonderful to have it. Follow these rules. You have given an effective notice. But I think to say that that's the only method by which you give notice is not only wrong, but if we were to word it so that was the case, so you put the word only in, I think that would be dangerous. And I think you're going to get a lot more lawsuits and disputes if you were to say that.
You know, it's actually not the wording I'm disputing. Mm-hmm. It's the lack of education at a higher level to say this is the way it is. Nothing new. It's been this way ever since the form was changed. Mm-hmm. And we've got fabulous education coming out from Trek like we never really had before. And it just, in my opinion, needs to have articles saying this is what paragraph 21 means. This is what you should do. And if that is indeed the way it's supposed to be, then there's no reason why it wouldn't. And then we can point to that saying, this is new in our industry, as far as you may feel, but we need to do this in order to comply with the way the contract is written or needs to be enforced or whatever the reason.
Yeah. Now, what I have seen in commercial contract is all notices from one party to the other must be in writing, period. Notices will be deemed to be effective when given in the following manner. Notices blank. Notices given in any other manner will be deemed given when actually received.
Oh, that scares me. Okay, so this is
education.
Yep.
It's nice to have an article.
It's the
buyer's agent delivering it to the seller's agent. It is not happening.
This is an education issue based on this is an education issue based to trying to alleviate a feeling. Okay, so I would say what.
Is of realtors that are not allowed to go. I can't
Yeah, but
contact your
look at the
client.
contract. The contract requires the party to send it. You have no problem sending it. So the seller's not sending, the buyer's not sending, you're sending it, and you're sending it on their behalf. So to say that you shouldn't be able to receive it on their behalf is another question. But to avoid the question altogether, I think is you send it to everybody that's listed, as Christy said here, right? Anyone's email on there that's listed, you shoot it off to them.
Every which way you
Yeah,
can.
we educated, all of our agents do it, and then they hit the wall on the other side.
they
like,
do.
"What
Oh,
are
yeah. Why
doing?
did you reach
Send
out to my
something
client?"
my client, and that's because they're not getting educated on their
Right.
end,
We've had that.
because Texas Realtors need a truck, send anything down, and now you got this much in legal one. Excuse me, it was that much. It was like, be aware, this is the way it is. We need
What
support.
we're trying to do here is trying to keep the contract intact as
Yeah,
much as
so
possible.
I'm good with that.
And not to allow a party to get out on a technical issue related to notice. So if notice has been delivered, as Brian said, it's effective. Okay. Question is, I think that you shouldn't get too tied down on worrying on complying with this, except to the extent that you want to comply as closely as possible as you can, and then have a fallback if you need to.
Yeah, well, it wasn't our end, it was the three attorneys representing three.
I think that may have been a practical over legal potentially in that case where the fighting over 3,700 there could have been other circumstances that would make it clear that it would remove this ability for the catch-all. But I do think education is always key in this, and to the extent we can have this raised in a better way, and for all the Texas Realtor instructors that are on here, and for us as Trackham, it's something to go out. I think we're always looking for material for good stuff. This is definitely a good one.
Yeah,
Yeah.
good point too. And
Yeah,
okay,
so
when
we
you're
get-
yelling at me, not here.
Yeah.
Have a
Yeah,
different.
they did it on purpose because of how stale and stuff they typically get, so taught in a different way. But
you're
yeah.
more in the contract class than it would be in.
Yeah, and you had to take 3
Legal
hours of
one
contracts,
doesn't
right? So
really
this is
cover it
something
like
that
it
can be
did.
built in.
Look at it.
But we
it's
can-
nice.
So if
No
we go,
more red lines, right?
so to move it forward here on circling back to that. So if you're not looking to make any changes there, the phone and email, right? Because this ties into how to provide notice. They wanted the request in the comment was to add a second line for the phone numbers to buyer and seller.
Do we have room?
You can actually get 2 phone numbers in there. Now, I don't know if you can do that in the form filling software, but you can get 2 numbers in there.
The form filling for.
And that's where practically
You could write a text.
Why do we need a phone number at all?
Yeah, because the notices have to be in
It
writing.
has to be in writing. And I understand that they
You can text it, yeah.
Right.
Maybe.
Yeah.
text it.
Unfortunately, people text.
People do text those
People
things.
comment, there's no address in here. It doesn't say address. It just says to buyer at, and then lists these things. They kept saying, why don't you have address?
Oh, that's interesting.
To have more room to write the address on that one tiny line.
What if we get to where we're looking at kind of that receipt page / paragraph 22 / notice section for formatting in these clarity items that we're talking about here? Not so much rewording the language, but the phone number, email, and address type of clarity. Maybe we can have that look in between meetings to propose something next time.
Adding to our list.
It is, yeah. It fits all right in there together.
3 months.
We have paragraph 21 and
Yeah, which upgraded.
5A, okay.
Okay, 5A. This is I think a request we received in past sometimes. So Lacey Johnson writes in asking if we could change escrow. We'll start with 5A within 3 days. So this change escrow agent to escrow agency. And we're in both the areas because it implies an individual where agency implies the company itself. And an escrow agent can be an individual, it can be a company. And this goes a little bit to Brian's comment earlier. A lot of people confuse title company with the escrow agent. And so I think as stated, it's clear and fits both situations where if you did agency, it limits it to just companies and to the exclusion of individuals.
So we had agent because we couldn't put title company, right? Because there's lawyers out there that close.
Well, no, so title company is wholly different. They're the ones providing and underwriting the title policy. The escrow agent's the one that's handling the money and the
But we
escrow
always
side.
used to put, we put a title company rather than a human.
And everybody
I think
always.
the word agency is fine because I think it clarifies it more than putting,
I mean, the
you know,
escrow agent could be
Melissa
a lawyer.
down.
But I think the point is that what if I was just an escrow agent and I was going to hold the funds and then Brian's going to do the title policy, and I don't have a.
Can it be in the two sections? Because I've seen that happen with some big companies that they let the title company do one section and they have their escrow.
Mhm.
Instead of having,
It's not
they
always,
just have
it's
two
not
names.
always the same.
Right, it's not always the same.
And I think agency includes, or agent includes an agency where, but not the reverse where agency includes an individual agent.
Yeah.
And so I don't think we can make the change from a technical sense.
Person to create an entity, the agency is an entity, the person would have to create it. I kind of liked it because it said that that was a bricks and mortar something. It wasn't a person. And that's always been an issue.
Well, we don't want it to be the escrow officer.
Right.
That's,
That was the
We're
problem.
thinking agent means officer and it doesn't.
Yeah.
I think they're just thinking agent means person and it doesn't, agent doesn't have to be in person.
Yeah.
And I think that's what that is. And I think it may just be also education pieces on people understanding.
40 years, you can't get people to stop putting their favorite closer in there.
I thought the
I
word
think we
agency
go-
was good, but okay.
Yeah, and so we've circled around that one. I think we know it's causing confusion, but has it caused problems? And
But that was a good idea.
let's see, Richard Ortiz. This is my country, structure and intelligence, property restrictions. So this is one where he wants clarity in instance where the agent may not have covered in 1506 with clients, and consider adding to paragraph 60 the title notices. Is this related to the new?
Yeah, I think it's
Yeah.
Related to it?
SB 17 regarding certain foreign individuals.
okay.
That, or some specifically named
Okay.
countries, some that can be designated just in the future by the governor. And so this kind of ties in with FinCEN in the somewhat the language there roughly. It's different reporting and stuff. But any thoughts on adding this now, or is this something that is subject to the lawsuits and where we're too early to?
This is the different issue. This is the new law Texas passed, subchapter H of chapter 5 of the property code. It says if you are from a designated country, and that's Iran, Russia, North Korea, and what's the fourth one? China. You are not allowed, you are prohibited from acquiring property in Texas. With some exceptions, but that's the general statement. The governor also has the right to
Add it in any country, yeah.
other countries or terrorist organizations, but basically those 4 countries. Now, there's a safe harbor in the statute. It says the fact that one of these people acquire or entities acquire property does not invalidate the sale.
Yeah.
Okay. It's just that it's a criminal act for you to acquire property. You can be fined, and the attorney general can file suit to have a receiver appointed to divest you of the property. But the sale itself is not invalidated.
Right.
Now, having said that, most every title company puts in its title commitments now a statement saying with this general warning and basically saying we don't want to participate in any transaction that is unlawful, whether it invalidates the deal or not. So there's nothing harmful in this. I don't know that it belongs in a contract. A contract is an agreement between parties. The TXR forms, that has to do with advising your client, right?
Right.
I also think it's less than 5% that it's going to apply to.
Yeah. I don't think it's necessary in a contract.
In our title notice sections, generally notices that are required by statute as opposed to helpful to prevent issues, unless there's a termination right or something attached to it. Any strong feelings about including that? So we'll keep an eye on that one. Let's see. Kirsten, her comment is she would like to see lots of issues at the end of new home builds and would like to have an option period at the end of a new build to be able to conduct inspections at that time. I don't see a way we could build that in a way that's so many different contingencies and issues and if you need something like that, I think it definitely should be drafted specifically for a deal and by an attorney on that one.
And as far as a lot of the new construction we do, most builders in our area use their own forms. They're not using promulgated forms for this at all. So even if we spent time doing this, that's for the most part, builders are not using. They're using their.
It's only for really small.
Many years ago, experienced people on this committee might remember, we used to have a provision and nobody understood it. And everyone violated it and everyone was out of the timelines. And it was awful. And one day somebody said, hey, let's make it easy. Let's just give an unrestricted right to terminate for a specified period of time and the people can work it out themselves.
Mm-hmm. They can negotiate it.
Is that wrong? That sounds like
I wasn't the first one on the option. That goes back to Guy Chipman days.
All right, so we'll go forward to the next one. Dan Wood, we've already addressed this about HOA fees. We'll add a section for other fees charged by some HOAs. We've addressed that. Kathy writes in about the mineral rights reservation, and it's about formatting and thinking that she thinks that it does and does not need to be formatted better to avoid any chance of misinterpretation of intent. The spacing is awkward. And let's just pull that up real quick.
I remember this call. This was all last year.
We made a change not too long ago that kind of reversed what the default was to get with the natural, what happens automatically if you don't say anything. And I'm looking at there, the spacing doesn't strike me as odd.
I'm in the wrong.
Like he's pulling that at the next comment from Melissa. Did y'all take that as the Texas Realtor Sellers Disclosure Notice as well? That's how I read.
The same issue where the columns flow down.
She's saying does or not.
Yeah, I think what she's saying here, I don't see it's a big problem because the thing that's pretty obvious is this right here. So she'd want the does closer to this box and does not a little closer to this box where it looks like it's
a space.
Yeah, and in little spaces. Sometimes what you see is like a couple spaces after seller and a couple spaces after after not over here, so that these are little.
So you know which checkbox goes with which option better.
Yeah, but I don't know if it's a big deal. That doesn't look too bad to
me.
And
I think just in general, and correct me if I'm wrong, that these are drafted in Publisher, which is not being serviced anymore. And so a whole conversion is going to have to be done pretty soon, which is going to change everything kind of slightly anyways. So I don't envy or wouldn't want to have that task in front of
Now,
us, but it's kind of odd how everything's a publisher.
I don't know if you made it clearer, but instead of the first of, say, waves, seller waves, does not waive.
Not sure we're going to go down that road. Diana?
For later consideration of this, so I bring it to the committee. I've had a request to have us consider two different areas. One in the contract where we are seeing buyers taking advantage of the 3 days to deposit their earnest money and option fee to have inspections. And then maybe they put the option money down so that they could terminate. And is there some way that the wording could be such that the seller, that inspections cannot be conducted until earnest money and option fee have been paid?
Yeah,
That
those
was the comment there.
Yeah, we've had that request a lot, and every time it's come up, we've decided not to go down that road, and that the contract means it's reasonable times in the corollaries delivering of the earnest money. Oh, you haven't delivered the earnest money, so you can't terminate already, or you have to deliver it. And I think the intent is reasonable times and not to have that built into you have to deliver this first, at least as what we want in the contract as a committee. I'm not sure that's changed, but that request is one that's a frustrating one, especially in certain
Because it
markets.
happens repeatedly, and there are no funds there other than maybe the option money. And in other occasions, as recently as last week, is that they had no funds because paragraph 7 says the buyer's agent has right to enter for inspections at reasonable time. The contract started, so they had the right to do that. And they said, well, should we contact our attorney? We just said, let's see what happens. And maybe that's a 5% situation, and our market has become more so. Why all of a sudden? I don't know. I don't know if others are experiencing the same problem. And maybe that's human nature, and nothing's going to change that. So,
Well, if they haven't performed, when they dropped off the contract with the money, the escrow money, then I'd be like, no, you don't get to, I don't care what it says, you don't get to come in the house and start doing inspection if you ever performed. Drop off your earnest money so we know that this thing is good.
so that's one attorney's opinion.
Well, and I have clients. Well, I think he's not saying that from a legal sense, as opposed to a practical. I'm not letting you in.
Can a seller say that when the contract says that they've got a right to make an appointment to come in at reasonable times?
Yeah, I'd say after the earnest money and option fee have been delivered.
At least after the option, yeah.
But can you say that if they've got 3 days to do it and they're still within their right to do
You
it?
execute on a
and
Friday
go
night
on,
and they
I'd
have
say,
an
oh, it's that important for
Saturday.
you to do your inspections immediately? Well, it's that important for me for you to pay the earnest.
Well, if you really want to split legal hairs, if you want to be reasonable about it, like reasonably, we can open the door in 4 days for your
That's
inspector.
reasonable for us.
It's reasonable. In 4 days, we'll have it available.
It's a conundrum in our world.
Yeah, and especially in your market, I have clients in right around, and they do that all the time as a business practice. It's especially when they're coming into it's.
So maybe next time
But
we.
it's.
And the only other one was a request for a form that would allow a contract to be reinstated the next day after the buyer and seller said, we're not going to close, and they love each other the very next day. And there's no way of really doing that without totally rewriting the documents, leaving more room for agents to make error, or go to an attorney to create a contract. So it is being presented to Texas Realtors as well to come up with a form, and I've been asked to bring it here. Is that something that we can do or not?
I've seen remarks in this area saying inspections or nothing can be done until option and earnest is deposited.
I moved on to a second.
Yeah.
So
You're saying that they terminated and they want to fall back in love again.
Yes,
Okay.
we've had that happen a couple times and had to rewrite.
So on that issue, just to throw something out for consideration, when we come back to talk about that. There is one state that has a form agreement to revive a contract. That's in Colorado.
Awesome.
I have a fear on that though. I don't like the idea of having a form because I think it creates so many snowball issues. And
Yeah, snowball.
There you go. That's maybe the. I want to go look at
Been a
more
long
Colorado
day.
rules of, and how it ties into some of their other contracts, because this situation comes up in a couple of scenarios that we see. A closing date's missed, and everybody all of a sudden says, hey, the contract's terminated and dead, which isn't the case. So they're missing a closing date. It's not time is of the essence. Doesn't mean that it's chopped off right then. And so then some are requiring, we need to revive it. Or some, if you revive it and then move the closing date or do something else, the deadlines are impacted. So let's look at the deadlines in two scenarios. One, if you have a truly terminated contract, we're not dealing with this. Okay, we're going to revive it. And if we put out another closing date of a week out, most of the time those parties are only intending to revive it, not give any additional rights. We're just moving the closing date. Well, all of a sudden, moving it a week out, you now have another right to terminate as a buyer under third-party financing, paragraph 2B. Yet look at all the deadlines that are based upon the closing date. It's all these things that they don't think about that are now new rights. And in a situation where it truly hasn't terminated, when closing's missed and they think they need to revive it versus, they can amend the closing date, it's all the same kind of general concerns that I fear. Having Colorado's form is super simple. It has one or two blanks to fill in, but all it does is literally say the contract terminated on blanks. They acknowledge something that may not have really happened here. That they desire to revive it. And that's it. It's just revived in essence. So it's so simplistic that how it would be used in the most common scenario that I've seen in Texas wouldn't work. It would cause more problems than it would help. But at the same time, it is a common request. I just have a lot of fear.
But is the most common scenario that they're terminating because they're missing a closing date, or are they terminating because we're at the end of the option period and it's 4:59 and I can't get them to answer my stinking question and I can't find the other agent? So you know what? We're just going to terminate. And then the next day, everybody's like, oh, yeah, we would agree to that.
Those are
And now you're like, oh, I got to rewrite the whole thing instead of revive it. Because I think that's where I see it more frequently.
You
Is
can't
there.
fix that. That's just human behavior that they're not paying attention.
Yeah.
That comes to my office constantly. What do? I'm like, you're just gonna have to terminate.
Yeah.
I can't
And
get the
then
agent
start
to
over.
answer. I'm like, you're just gonna have to terminate.
Yeah.
If you're not happy, you gotta get out. This is so stupid that I can't help it.
Right. But I think that's
in Colorado's.
that's the more likely timeline as opposed to we didn't make it to closing.
Right.
I do think that's true,
Because the
but
documents aren't ready and the seller doesn't want to extend the closing date and he's fed up. But the next day, he thinks, oh, I don't want to do this all over again. Can't we just amend the closing date? And here's what's happening. They close anyway. And nobody stops them. Title company doesn't say anything. They just show up and they close.
To go one layer on, and we can get this to the next meeting, is I think it's improper for title companies and for lenders to require the amendment of the closing date just because the closing date has been missed, because then it's changing the party's legal rights. The contract isn't truly dead. I think it's highly inappropriate and to not do it, to say we have to have our records match up, and people don't realize when they do that it's potentially
they all
open.
sign all the time.
Is there a solution?
In the middle of.
What's that?
Is there a solution?
Yeah, maybe for next meeting we come with ideas and put that on the we'll put that on the list for the next one. And so going back, I think we have a subcommittee now for the paragraph 21, 22 and receipt page.
Oh, we got receipt.
I'd say let's-
I only signed up for one of those paragraphs. Okay.
Vincent? Vincent, you think so? Okay. Ron, are you okay with that? A subcommittee for the Vincent?
Yeah, we can do that, but sure. Oh, you don't want to do it now?
Well, Brian suggested it, and so.
Yeah.
And let's circle back to tee up Vincent again so we can see what to do with the subcommittee or here. We were talking about doing, well, I'll let you, who wants to tee it up? Brian, it's your
Go ahead.
expertise. So having the fence in, whether it's an addendum or part of the contract, drafting that language that we had up on the screen, you want to pull that back up?
Sure.
Yeah, I'd suggest that people, if you have any concerns or misgivings on what TLTA proposed, let us hear it, and then we'll have a subcommittee that will
Yeah, I'd like to tighten up some of the language that we talked about before.
Let's give some, I guess, some initial comments. I do have some, we can see how far that goes, or if we like it. So this is in agenda item 6, TLTA's letter on the second page. There's some draft language that was suggested to be added to the federal requirements portion of the contract, which is paragraph 20.
It's page 101 of the PDF, the TLTA letter.
And I'll tell you, there was
Oh, right. The
concern
wording is on 102.
about putting in a definite deadline, or just saying promptly upon request, so as not to prevent or delay closing. Do you want to be more specific or not?
I think we have to be.
I mean, the thought was, whenever you put in deadlines, you're giving people the opportunity to stub their toe and be in breach of contract.
Well, do you want to be at closing and they still haven't turned anything in?
That's not promptly upon request, so as not to prevent or delay closing.
I actually, in my comments here, thought to take it out, to make it more like our 1031. We're giving notice. We need to allocate cost, but there's so much unknown right now on how long it will take and all these periods where if we have in there at least the requirement to provide the information promptly upon request, it gives them the requirement to do it. If we say so as not to prevent or delay closing, what does that mean? Right? What is that? How do we interpret that? Instead of, what if we use the language from the 1031 that in some other way that's not as ambiguous, tied to the ambiguous deadline there? And I didn't like the last one about seller and buyer are aware that closing will not occur, may be delayed if FinCEN reporting is required. That last sentence to me.
That's a statement of fact as opposed to an agreement of performance.
Yeah, it is. Yeah, and so if you take those out, you have, okay, they're agreeing to promptly require. You give them notice what it is, that they agree to promptly provide anything upon request, and then you allocate the cost.
So you want to take out the phrase "so as not to prevent or delay closing."
Right.
Just say promptly upon request.
And if we needed to have some kind of delay of closing language, use something more 1031-ish.
So let's here. Got this.
And we don't need the last sentence. That will be educational on the part of track to agents.
Well, that's a.
Where are you thinking about putting this? In the title notices section?
Paragraph 20, federal.
Oh, under the federal requirements, statute.
Agricultural.
You know where?
Paragraph 20, under, with the first step.
Copy this again. Copy if we need it. So can you back up, because I needed to catch up here. So we're saying that in the first sentence, we're okay if the sale is subject to the U.S. Department. Reporting requirements, seller buyer will provide to escrow agent documents and information requested by escrow to comply with FinCEN requirements promptly upon request.
He said, John is saying, take out "so as not to prevent."
Okay. That's good. That's a good change.
Even the next sentence and take out the last one. That's what, for my mind.
Take this out. So, yeah. So the only vague question we have is promptly, right? But I don't know how you get, I don't know how to,
You should say with
Tighten that up.
5 days of request.
Yeah, so,
You know, it may take longer.
right, as I think y'all had mentioned before, you've got a last minute change on the day before closing that you're moving into.
LLC or something.
Yeah, somebody's changing the.
So do we need an extension of time for that to occur? Like we have in paragraph, the closing document. So we have, what do we have here in 20, paragraph,
What is the thought if the seller doesn't want to do this? Is there an out? I mean, who's getting the earnest money back if the seller says, nope, I'm not doing it?
Well, then they're in breach of contract.
You just sit.
But if they don't know that, like, or if it's a last minute flip to an LLC and they weren't aware.
But they have to agree to the name change on the contract unless it was an and/or sign.
They're not, unless, it would be right for them to automatically be forced in breaches. Let's say they don't want to disclose, like, you know what, then I'm just not selling my place. I mean, y'all didn't want to use the wins. You wanted to make it more like a 1031 so far in your suggestions. Well, then that's not binding them to it necessarily. You didn't want to do deadlines.
I'm just wondering if it should be a checkbox of this sale is subject to, so that the seller is acknowledging it up front and is aware of the situation.
Y'all won't necessarily know that till y'all turn it into
But you won't
title.
know it.
I mean, we won't know until we get to closing because the buyer changes it so often on us on the cash transactions.
Yes.
Day of closing, they say it.
What was that?
Go with my LLC.
But can the buy on a cash
Drawing blank. What's
change the name?
Aaron?
Okay.
Aaron
The seller.
Aaron Day.
Yeah, Aaron said that 80% of the people don't even know this, what's going to happen. Y'all were talking about that too. You were, Brian, about the title companies. And so what if you get all the way to the end and let's assume I guess they'd have to be cartel or what, but maybe they just don't want to give up their info. What if you pop up on them like a week before? We want this. We need this. We just realized that we didn't even know it the last 40 days we've been sitting in the contract because as most scenarios when they're financing, title companies don't even bother to look at anything until 5 days before when the bank's giving their information. But we won't go down that road. So you'll start looking at it and go, oh my God, we need this paperwork too. The escrow agent, not title company. Escrow agent says, oh, we need this. You know what? I'm not selling it. No, you're in breach. Buyer's suing you because you won't comply. I think they need more notice if you're the seller to know if you're going to be part of this deal, if you're going to have to disclose it at all, instead of just blindly signing off on that. If the title companies don't know what that is, and the brokers don't know what that is, and the sellers don't know what it is, we just going to educate the whole state all of a sudden, all the way down to the consumers?
I didn't know I had to comply with that federal regulation. I choose not to participate.
Well, then you get sued for breach because you just said it'd be a breach. And I don't even know why we have to put it in there to make you title companies make it easier on y'all's life anyway. Just because there's a lobby, or escrow agents. Why do we have to put
Putting
that
it in here so that you litigation attorneys will have it easier on your lawsuits.
And I appreciate the fees.
No, I mean,
It sounds like we're just trying to help
Sorry,
the
I didn't mean to
TLT.
open a can of worms. I'm just thinking though, like
I-
a normal
well,
seller, they're not going to
yeah.
have any idea.
TLTA
what's going
is
on.
wanting to make efficient closings. And we see a locomotive coming down the track that nobody knows about that is going to create a massive bureaucracy that we don't have an option to opt out of.
Let's go down another path real quick
And-
though. Go ahead.
So the buyer and seller, I mean, if the buyer and seller want to say, let's fly into it blind, and have a closing surprise rather than have a closing celebration, that's fine. But it seems to me that it makes a lot of sense that people should know that if this transaction is going to fall into this category, it is mandatory. It is not optional. It is mandatory that the seller and the buyer are going to have to provide information so that the transaction will be reported. Because if the transaction is not reported, the title company is not going to close the deal.
That is actually not exactly what he said. the duties are imposed upon you or any lawyers that close a transaction. A straw person.
It is a cascade.
It is, but it doesn't go, the duties, and as he was sitting next to me, I'm like, I could go buy this for cash with my trust and we can transact the deal and no one will care. Like two people show up, cash, buy it, trade it. And as long as it doesn't process to the title company, there's no reporting and no one's violating anything because it's not a lawyer or a title company. So the cascade stopped. Like I
can't tell you all the ways in which it cascades down.
I'm just saying, like, I'm not saying I'm being devil's advocate. I'm not saying I'm against putting it in there, but I'm saying we're putting it in there to really make y'all's life easier, not because it's necessary.
Well, let's say it's not in there and two parties go in blind, buyer and seller.
Okay.
And then pick either side says, I don't want to provide that information. Are they in breach for holding it up?
They're not in breach of the contract because it didn't require them to do it at all.
So it doesn't close.
It creates a predicament for you. Which means go back to Ron's idea. Why don't the escrow agents?
Me as who? Who am I in this scenario?
Escrow.
Okay.
Like Ron's idea, why don't y'all have your form as soon as it's dropped off that says we're going to need this? Or maybe they did assigns. It started out as two individuals and then they assign it to a trust 2 weeks into it. Then you pop up, here's our form. We can't go forward for y'all unless you do this.
But so you say it's our problem, escrow, right? Playing the escrow agent. You brought us the contract. And let's say the company's already in it and the requirement is already there when you brought it to us.
Sure.
You should know the law just as much as we know the law, right? You brought us to there and now all of a sudden you don't want to provide the information.
I think that all the brokers out there should know law just as much as lawyers and title companies.
Well, no, I mean, you've already executed the contract. You haven't talked to the title company in advance.
Correct.
And so they're not involved at that point.
All you gotta do is say, we don't close this transaction unless you bring us this info.
Okay, so we don't receive the contract. Hey, before you give us this contract, but it's already signed though. You're already obligated. So the only instance in our contract require to close with a title policy. So you have to go to title. We're forcing parties to go to title. And so if you're going to be going to every title company, you're going to say, no. And you're going to have to close it on your own, but you can't do that because you have to get a title policy.
I agree with you, but I litigated that in Houston for 4 years. And the law was when on specific performance contract, by the way, I won my $400,000 fees. The judge said, nope, because the title company refused to close for other reasons. The judge said, nope, the contract says you provide money and you provide deed and y'all should have closed. You should have gone somewhere else, should have gone on the street, should have gone found a dog to close it, should have found a lawyer, whatever, and found the contract to be good. And it does not always have to be closed.
If the title company is not a party to the contract.
Yeah. So having that, acknowledgement coming in, it's already built into the contract. It causes controversy. How do we then, I agree with your step back, right? Pushing back, but I agree with it stepping back of the seller should be aware of what they're getting into and have a right to say, I don't want to do that. And so if we were looking at this language, do we then build in that a notice period or something for them to say, once I figure out I have to give this, then I get a chance to look at it. And so I agree with that thought, but pushing out, I do think the parties are setting themselves up for failure before it gets to them.
Look,
that causes a controversy.
I think it ought to be in there, but I think the seller needs an out.
Yeah.
I think it should something, anything this significant that's, if it is coming down the pipe, since it technically hasn't been ruled on yet.
Yeah.
I think it needs to be in there. We just need to get the seller an out when he realizes, oh, are you kidding me?
Yeah. So it makes it a little more complex to draft on just this.
If seller realizes that
seller gets
consent applies,
he has 3 days.
He has 3 days to terminate the contract.
Like new agency, 2-year apprenticeship.
I think that's complicating things, but it doesn't.
Anyone can write it.
It doesn't.
Indeed.
Well, what's the most similar concept we have right now, language-wise, in the contract to provide after the seller gets notice of something?
Right. So considering that there's a possibility you come right up to closing on this, which seems to be somewhat common, I'd recommend that you have a provision that, which TLTA has done, is both parties are obligated to provide the information requested, and that they have, I don't care, 7 days, pick a days, number of days, in order to provide the information upon request. And closing will be extended daily if necessary to allow that to happen. And then after that, you're out of closing.
I don't like that because then all of a sudden a buyer who assigns it to their entity can force a seller not to delay closing because now we have to go get this report. It kind of gives them too much unilateral power to.
Yeah, but he's got to know that he's subject to FinCEN and he's using it for that purpose. So you've got less than 5% of the transactions that you're thinking this is affecting. And then of that many, how many are really going to pull the last minute audible to happen? And I don't care. It doesn't have to be 7 days. It could be 3 days.
Buyer will not assign this contract if it would result in FinCEN reporting unless seller consents.
Well, then you get into is or is not subject to FinCEN, right? Who's making that decision?
Well,
That's my concern still, is that the general
I think you should keep it simple.
agent on the ground, they're not going to have a clue
Oh,
who,
no.
who this relates to. And so how can they properly tell their client what to do?
I don't think a 2 or 3 day or 5 day, whatever numbers of days you want of extension of closing is going to be that troublesome in most of these transactions because you're pulling a last minute audible. So that's got to happen.
And I'm just thinking about so many ways I can offensively use that. And once that's out there, my client was out of closing. I'm going to assign it over to this new entity, a new report, and I also bought some time.
Well, the title. Well, are you going to do that for 3 to 5 days of closing?
Yeah, if my client needs it. Pretty easy to.
Don't underestimate the evil.
It's in the rules. It's allowed by the contract. I'm all about fighting fair. That's fair. It's contractually allowed.
And considering that this is not a time of the essence clause, I'll leave that one for another discussion.
Do we have to put it in the contract? I mean, I keep hearing this 5%, 5%, and that used to always be our rule and the complexity of it. Are we creating more problems than good unless there's something that says we have to put it in the contract?
Let me take this position first on the extension of closing. And I'm not, if you don't want to do the extension closing, I'd have no problem with that. And so we just simply says that they have to do it, period.
And maybe get all the information not less than
And if it's
5
past
days before.
If it's past close link.
Backing into the closing date. Must happen within 5 days.
Okay, so it's a request from the escrow agent. You can request it all the way up until 1 day before closing and maybe get it done, right? If someone can respond that fast. So why are you tying the escrow agent to a time limit? You can't do that anyway. He's not a party to the contract. So if the escrow agent asks for it, then you got to give it. If he asks for it before closing, great. You've got that much time to get it.
And, maybe we just say promptly.
Well, just you have to provide it, period, within 3 days after the request or closing, which is ever earlier. Right. So now you're not moving the closing date 5 days after request because you're tying it to the request by the escrow agent. Because the escrow agent is the one that's obligated to report. So they're trying to get the information so they can report. The other alternative is go into paragraph 9 and say that you have to provide all these documents requested by the escrow agent to get this thing closed, including any requirements by FinCEN.
I see two distinct issues to address. One is the situation where the seller is willing to provide the information in on the buyer side, whether it's because the title company didn't ask early enough, whether they assigned it late in the deal. Everybody's on board. It just delays closing because of things outside their control.
Right.
And then the other situation where sellers don't want to provide the information and they're the ones holding it up. I see that almost as two different boxes when we're talking about these concerns in drafting.
So if you look at, pull this back up, if you look at TLTA's initial suggestion, they just simply basically go off and say, if the escrow agent asks for it, you got to provide it. So here it is. If this sale is subject to FinCEN, seller and buyer shall provide to escrow agent documents and information requested by escrow agent to comply with the FinCEN requirements. And then you could stop right there. Or you can say within 3 days after the request, receipt of the request. Or the closing date, whichever's earlier. Well, we can change it up. Should be the earlier of, but it's okay. So I don't know necessarily about this charge because the buyer's picking up the full cost, even if the seller has to provide it. So.
And the comment I wrote down there, and this is definitely a 5%er, but what if the fees are very expensive to get the info from the seller side, right? That the buyer may not know how complicated their information is. And it sounds like it's going to be minimal. I'll be shocked if it's 500 at the end of the day for some of these, but just a 5% concern to throw out in the universe.
So then that's the question. If we're at 5%, do we actually put this in?
Well, I think the allocation we need to. This was just if the concern, because the buyer absolutely has to pay everything here. And if for some reason the sellers has some complicated history that costs thousands of dollars for the title company to go track down to get the information, there's no contingency to say, buyer, you don't have
What
to
kind
pay
of
it.
information are they going to request of the seller?
That's what I'm trying to find out right
He said there's 104 blanks.
Well, not for the seller. So he said the seller, he didn't know exactly. He said it'd be minimal, but he didn't have an exact, know exactly what will be
Who
required.
did they investigate? The buyer or the seller or both?
Anyone with that kind of
So
entity.
mostly the buyer, but the seller to the extent is what he's saying is to make sure they're not connected somehow to the buyer, or Brian speculated.
I mean, eventually they'd have to start investigating the sellers because if it's a faux cartel company buying something, to hide money, they're gonna have to liquidate their money. So eventually, in the chain of events,
They're gonna
Real
resell
Criminal mind over there.
they gotta move it around. But they're just, as that joked with that guy, they're gonna use straw people anyways. They're just gonna get, Joe Blow, they're gonna skip this whole thing and it's just an exercise on all of us for nothing.
Well, so on this expense, I would think that the buyer shall pay for any expense or charge incurred by the escrow agent, right?
Would that include seller costs if their closing was delayed 2 weeks for their PTI, principal, interest, taxes and insurance on their home, and they were due to schedule a closing, and now because of all this stuff, it goes 2 more weeks.
Well, we're not extending out the closing here.
So my
version here.
concern there, it may not be practical to provide it if the title company only asked for it on the closing date. And say whichever is earlier, so then you have to provide it, you could have to provide it the same day.
Well, that's what I'm saying. If you don't want to extend the closing out. If we want to just say, no, you got until the closing date. If you throw a last minute audible the day before and there's just no reasonable way to get the information, well, then you either have to agree to extend, the parties have to agree to extend, or seller can terminate.
After the 102 or 104 questions are answered, it sounds like the title or the title company or escrow agent is the one that's making the decision based upon that information and saying, I'm comfortable that I'm meeting the requirements of FinCEN, or is it like you take that and then you go do more research?
There's additional steps behind it. It's more like a reporting function than verifying and authenticating that the information's accurate. So what we don't know is how long any of that's going to take yet.
So you're saying that the seller could be like all excited, they're first time home buyers, getting everything ready. They've already found their other house. It's not a contingency contract. And they get 3 days before and not trying to be too technical. The escrow agent wakes up, it's like, hey, we're going to need this info. And they're like, what am I supposed to do now? You mean I can't sell my house? I'm going to have to exit and this is going to blow the closing. And then now I'm stuck after I've been sitting around for 45 days. We've already done 3 amendments. We already figured out the curtains. I already got the plumbing repaired. I already fixed that gas.
And the seller's moved out already, to the next house.
Good
And
point. I've already moved out.
Yeah.
Now you're telling me, can we work in a requirement? Title company's not a party, escrow agent. Did y'all tell us within the first couple of days if you should have known?
And it's almost like we have to have a block.
I get to make that. I get to make that statement once to that agent because I'm never going to see that agent again.
So
I mean that's part of the market.
Yeah,
Will correct.
sure.
activities like that.
Buyer's agents, you should know eventually this is something to get ready for.
Yeah.
So here's another thing we can do to make it even shorter. In this provision, you expand this and say that you have to provide any documentation here reasonably required for the closing of the sale, the issuance of the title policy, and any reporting requirements by law.
Is that
It makes
the same?
it easy.
Sure
Yeah.
does.
It's going to come up a lot in farm and ranch because somebody's always buying
The
a
only
trust
thing
or
that,
partnership.
the only thing that it doesn't cover is I think part of what the gentleman was speaking to is we need to have a provision on who's going to cover the cost when in those circumstances that it does come up so that we already know who it's allocated to. That was the other piece
We
to
could
it.
put that in 12, probably as another little tagline, seller shall pay.
Yeah, you can, any FinCEN recording requirements.
Or buyer, yeah. Yeah, buyers may just add to that long paragraph that we already
FinCEN
have.
reporting.
Yeah.
Fees.
Yeah, almost like.
You could do that
So
there. So
you're saying break it up into hiding it in different parts. Of the
Well,
contract.
because the next time around, it's going to be SINFI reporting requirements.
This may never be. This may never become a problem. And if we highlight it so starkly, and I really fear, offensive use in the very small number of cases. I fear delaying closing, just in any case, because of these things people might not expect. Hopefully title gets it together in general to bring it to the forefront. By doing this, at least we handle the allocation of fees and we give the obligation to provide the information. It sounds like the rest of the stuff, to use the word, we are really speculative. We don't know at the end what the process is going to be. I would hope and think it would figure itself out pretty quick because it's going to have to happen. This law doesn't go away, it's will have to be worked in. And so I don't know on that, but I think that makes it clean and simple.
So paste this over here and then we can put in some language. I like this only because it doesn't really change too much. And if FinCEN doesn't take effect, well then it doesn't hurt otherwise. Or it gets stopped somehow or another.
It could make the contracts not become stale just because this law goes away or changes, and it could address any future laws that may replace it or.
No statement, certificates, releases, transfer any warranties, and other documents or information reasonably required for the closing of the sale, issuance of the title policy, reporting requirements to governmental agencies. That broad enough? That'll take care of the first deal, and then we can add to the expense item. Add, what do we add to the buyers? Add to buyers' expenses. What is it that we're adding? FinCEN requirements.
I like where we're going.
What is it? FinCEN filings, reporting. What did we say? Cost
reporting requirements.
I say cost.
The way they wrote it in their letter was any charge for the cost of gathering information and preparing and filing the report will be a buyer expense.
Something like this. It's costs or charges or whatever it might be, right? So if we look at FinCEN reporting costs or charges, let me pull up the contract again and see, because
FinCEN is going to be confusing to everybody, which by then means the United States Department of Treasury Financial Crimes Enforcement Network.
Hopefully it'll be like the agricultural district when you have to tell, which never existed. It was in contracts for 10 years to put the agricultural district.
Longer we tossed it. I think that goes back to the 1980s.
And then Texas never made an agricultural.
so you would just add it right here. You could say, if you want to call it FinCEN reporting costs and charges or governmental
Can you just say federal
If
reporting?
we make it more timeless by not saying maybe FinCEN
Right,
correctly
if
in
something
there.
else comes up, yeah.
Overreaching governmental actions report.
That'd probably get voted through.
Well, and again, this, let's see, do we have reporting requirements by sellers, right? To foreign sellers and stuff like that, right? Do we not?
In 20?
The FERPTA. Oh, it's in 20.
Well, you could say governmental reporting charges incurred by escrow agent. Or something like that. Are there, do y'all have reporting requirements based on sellers?
No, and I think incurred by is going to be difficult because every escrow company is going to do something different. You know, some will have a third party servicer, some are going to create their own thing. Some will just try to charge staffing expenses like that. It's going to be everywhere.
Okay. So do you want to get all that back, or do you want to limit that to like third party charges?
I don't think we're far enough into it yet to have a scope on it.
See too, because it's either like the tax certificate, that's third party, a lot of times still the same company in effect, but then you have the escrow fee, which is set, to cover whatever amount. And it could be that it ends up a flat fee for people. The escrow agent takes the risk of they're going to make some money if you look at the actual hard cost and administrative costs on some and lose on others to bounce out. That's probably going to be a business sales decision then.
So, but it is charges to one way or another to the escrow agent, right?
No, it could be internal, right? Because they could do it all internally. It sounds like, and just make a report.
Yeah, we're gonna have a department.
Can you just say reporting costs or charges related to filings to governmental agencies?
Well, I mean,
Gathering and reporting information.
yeah, but by who? I mean, that's the problem.
You don't have to say
The buyer's not going to pay it if we just put it. If the escrow agent is the one that's saying, I want money from you for this, then I think you have to say this is an escrow agent fee for. I mean, that's the way to say.
escrow agent or third party fee for gathering and reporting information necessary for FinCEN compliance.
Or any additional, kind of like a tack on to the escrow fee, almost like any additional charge by escrow agent related to fees or charges related to. Yeah, so fees and charges being a fee that could be charged by an escrow agent or a charge that is passed through by a third party.
I'm writing this down real quickly and then go take you back to that.
How he does this so fast.
Okay, so let me put this back over here. So add to buyer's expenses. Escrow agent and third-party fees related to governmental reporting requirements, or I think it should be actually be charges, right?
For gathering and reporting. To comply with government requirements.
What do you think? This would be noon 9. Is it 9B or 9A? 9B3.
Nine B three is seller and buyer shall execute and deliver the notices. So yeah.
What's novation mean?
New. To create a new, to replace with a whole new.
You know, I hadn't used that since law school.
Yeah.
It was also the time I got rejected for my second date.
It's got to go in the BLC records.
And recording. At the end of 9B3, when I say in government reporting requirements.
I thought the working group was gonna do this.
Isn't that what it says? Reporting requirements to governmental agencies?
I think they would have already been gone for the day if we were here for so.
This is one that we're.
John likes a large working group. An hour ago, it was like, we're gonna separate the working group, and Ron's like, no, we're doing this right now. I'm just gonna ignore everything. We're gonna knock this out right here.
Should we just look forward to explaining this?
I think it'll be easier to explain it the way it's broken up like this.
I like it too.
Than this, but we'll still have to give a little background on exactly what it means.
We could have our agents have them contact their.
I like that.
The word attorneys.
Just if you're not doing anything shady, you're really trying.
9B3,
Okay.
and that
Well,
is
we can't make determinations. if it's
9B
shady or
starts with
not.
at close.
No, that's not true.
Oh, you're not an attorney? The video's going.
You're correct. You're correct.
Yeah.
Monkey wrenching things.
Well, you know what? Because the transfer warranties and things like that, should we change? That's a good point. Should we change that to at or before closing?
Where at?
And the title of 9B for the intro says at closing right now. We're talking about adding this requirement to where it says at closing, they shall do this. And it needs to be
at
done
or
in
before
advance.
closing.
I mean,
Let's look at the rest of it.
I've signed closing statements and deeds before closing.
Well, I think we'll fit in. Let's see if I can answer.
I mean, I'd suggest you just have a general statement in paragraph 20.
And have it in 9B and have it
Pull it out of
in.
9, put it in 20.
put
Say
it in-
promptly upon
What
request.
would be an issue?
Okay. So,
I think sleeping on it would be helpful. And come back with fresh brains and a subcommittee coming back to the rest of the committee.
I second that motion.
I pulled up the same
Everyone's
thing.
fresher.
Yeah. We're circling. Let's get through this last one here. and then
Let's go through it again.
The one thing I noticed as we're doing this in buyer's expenses, we're missing a colon right now in our current contract. And then it begins with the capital.
Is it going to the legal cases today?
I hope not.
Yeah, so there's only, I wanted to preview one that's important and then the other one we can, so I think this impacts a lot of us. Yeah, the other one could be homework. While he's doing that, I'll go ahead and preview that to get it out of the way. So from our recent cases, we'll jump to the end like Ron is typing here. It's and by the way, these cases are largely sent in by Ron. It's fantastic. He monitors when he's able to pull out with his searches cases that he sends along the way. And if I can find my actual case. It was a case involving the construction of a declaration in a situation, here it is. It's the prior legacy properties versus ranches at Over Hills Property Owners Association.
Tiny houses.
Yeah, it's out of Court of Appeals in San Antonio, Fourth Court of Appeals, September 24th, 2025. It was a case that a buyer was interested in buying a lot in a neighborhood to put a quote unquote smart cottage on. And the buyer wanted to make sure, because the neighborhood had a mobile home restriction. You can't put mobile homes on the lots. So he went to the manufacturer of the smart cottage and said, "Hey, is this a modular home? Is it a mobile home? I'm going into this neighborhood. I want to make sure that I can build with this." And they said, "Yeah, it's a modular home. It's not a mobile home. You're okay." The buyer even went further. It's crazy how far the buyer went. The buyer went to the HOA in advance of putting in the contract. Said, "Hey, HOA, I want to build this. Can you tell me up front whether I can build it or not?" And the HOA said, sure, you can build it. Well, that's great. Put in the contract, went all the way through, closed on it. He put the smart cottage on there, and then it doesn't say why, but all of a sudden the HOA said, you got to remove it. It's a mobile home, and mobile homes are restricted. So there's a couple different parts of the case. Is one to throw out later on is whether the HOA was a stop from saying you can't do it because they already said you could. That is fighting. That's going to continue to be fought on. Court didn't rule on that. What it did rule on is saying just because it says mobile home in the declarations, it wasn't defined in any particular way. And what the buyer was saying is you have to look to the governmental regulations. And if you look at the code, it says a mobile home is something that would include or not include the smart cottage, meaning I'm good. Statutory definition. Like our legal holiday, right? We didn't have it pointing to the government code saying legal holiday is this. We assumed, that is the government code that would apply. The HOA said, no, you have to look to the plain and ordinary meaning. These declarations didn't point you to any code or anything. And the court agreed with the HOA, saying, no, we're not going to apply a governmental definition or government definition found in some code. You could have done that if we pointed to, the declaration pointed to it. Instead, we're going to give the plain and ordinary meaning to that term, unless it's clear from the surrounding context that it's meant to be done in some specific or not scientific, but technical way. And they didn't find that in this case. So they did not look to the statutory definition of mobile home at the end to interpret the declaration language preventing mobile homes from being built.
So what was the definition of mobile home? Anything you hook up to your truck and drag around?
Yeah, so about being mobile and it kind of gave out
Built in like the 70s. They quit making mobile homes along. Now that's what they call it.
Yeah. So it was an interesting case that for us, I think it's a good change regardless for legal holiday, but if the legal holiday was challenged, what would it actually be?
So we need to make the change, or we need to cite to the exact code?
We need to make the change. And we're citing to the exact code in the change that we're making.
Right.
But we don't need to change what we've already done.
Right.
Yeah. So, interesting case but it highlights too, and I was talking with Diane about this, about insurance and other issues that might come up, can it be insured, and looking at that up front and how these restrictions in general are interpreted. It's a good case to read. We get perfect language. We can.
Yeah. So the other thing I don't have here is a time limit if you want to specify a time limit. But here's the seller and buyer shall execute and deliver any notices, statements, documents, and information requested by escrow agent reasonably required for governmental reporting requirements. Buyer shall pay any escrow agent or third-party charges for gathering and reporting the information to comply with the governmental reporting requirements. That may be repetitive. Could just stop at information. Instead of the information, it's just reporting to, for gathering information and reporting to is what it should say.
People self-inflicted. They still call them mobile homes or manufactured. Instead, what do? They call other people. They want to make that was it mobile or versus manufactured?
So
I'm not sure.
regarding government agencies.
We can't sell mobile homes.
I think we'd look at this language, get some comments. I'm not sure, Ron, let me get the side eye from Ron here. I don't think we're gonna be able to come up with something to actually push there, because we just have to address the 9B language, the lead in.
Oh, no, right here, we're adding this into,
20.
so now we're taking it out of there and just adding it to 20.
And then you're gonna
Do
do
you want to
paragraph
time
20
limit, or
with
you
a
just leave it like that?
I mean, is it B?
So you're gonna need to do it before closing, whatever it is.
What is statement meaning, like what you put in an application?
Well, it's just like for any kind of statement that you might have to
20A or 20B?
compose.
It's clicking their notices.
It's 20 is just on FERPA.
Right, 20 is currently on FERPA, but it would be 20A.
I don't know if notices or
And 20B would be
statements, documents, affidavits. I don't know if you,
I wonder what it's called.
a statement to an governmental agency is usually what you get. You want to take notices out or leave notices?
I think probably can be taken out of that
Take it out.
context. You can imagine what notice would be.
Would you divide this though between the FERPA and this, having it two different? 20A and 20B?
Yeah.
It would have to be.
And in Farm and Ranch, it would be we already have two, so it'd be a third
Let's
one.
see, yeah.
Buyers.
So are you only doing the top paragraph and not the bottom paragraph?
Yeah.
Yes.
Okay, so top paragraph, let's add information will be provided within 3 days after, just cut and paste that within 3 days after receiving the request or the closing date, whichever is earlier.
That's where I don't necessarily agree with that
The
language.
three, I mean,
That's a,
3 is a
but
placeholder.
What happens if they don't?
yeah, because then it's allowing the escrow agent on the day of closing, no matter how many days you put in there, to throw a monkey wrench in things. They wake up and say, we need it. And then it can't be done by whatever party.
You know, we have in paragraph 14, if we can't fix a casualty, then you have
So many days.
you have up to 15 days. Those days will be extended as necessary.
Yeah, but that's kind of the casualty being
Yeah.
an act of God as opposed to human error.
Not
The
answering
title
other
company,
people's
not.
questions.
Yeah.
Or getting the
Changing their
request
mind
coming
at
in.
the last
They may
minute
be
to
willing
move
to,
it to
but
an LLC.
title forgets it.
Yeah.
Well, we could just say, not later than the closing date. And then you're not extending closing.
But do we even need to go there until we know it's an issue in terms of providing? We said they have to reasonably provide it. There's already a deadline that, paragraph 9, closing date.
Right.
And so
You want to just take it out, is what you're saying.
I think so. I mean,
Well, and
because
if we make this a part that the buyer has to do this, there's still the default paragraph that says if the buyer fails to comply with the contract, they're in default.
yeah.
That's simple, Brian. What do you think? We'll just add promptly. Shall
Can I have one promptly?
I do like I actually like having some qualifier to say you have to do it.
And then that last word, information, just goes away. Why is there the word information after governmental?
It's a leftover.
Oh, I'm sorry. Yeah.
This will be the first promptly we have in our contracts. I don't know. All right, I know we're all getting tired, so everybody think of that.
Third-party charges for gathering and reporting information to government agencies.
I mean, I'm okay with it.
I'm okay. I'm questioning reasonably. I know If it's required, it's required, and the buyer and seller don't get to reasonably object with something that's required.
Mhm.
I'm just curious.
That's good. I'm with you on that. I mean, I think we just don't know enough, but what is reasonably?
Gives me an option to say that's not reasonable.
Like they want 10 things and then the escrow officer wants like 4 more, or because it helps, like what is?
To play the devil's advocate on that, I like somewhat of a qualifier. I'm fine with taking it out here in this context, but I've seen some to use that. It doesn't have qualifier reasonably I can get it 5 different ways, and I'm going to ask you for the most intrusive way to get it, to get information, and whether it's for in different contexts of getting it for a competitor or somebody that's, behind the scenes, and they may be trying to use it intentionally to ask for something more than what would be reasonable in those circumstances. Yeah, but I'm fine with it here. I don't think that will become a problem to make it it's 5% rule, but generally I like reasonably. And so when somebody else who's not a party to it can force you to do something and they potentially can put a thumb on a scale to impact a transaction, I like limitations for that purpose, but I don't anticipate that be a problem in this context.
What's the wording that's going in paragraph 9 again?
We're not doing anything now.
Yeah. Okay.
The problem we have there is because it said at closing. This has to be done
For the
Before.
cost of preparing and filing the report.
So this is all we're putting in is just as a notice
Right.
under federal requirements.
So this bottom paragraph, we're not looking at.
Oh,
only
yeah.
the top one?
This is coming out.
Oh, yeah, I think that's where you started from.
And this again will make it an evergreen type of clause where something else evergreen's not the right word, but if something changes or different law, we can leave this in as a catch-all.
Does this go in every paragraph 20, all the contracts?
Oh, that's what I heard, right?
Yeah, I think so.
It's not just residential, right?
Well, I think it was just residential was one of the boxes that he checked.
It was residential cash and an entity,
But it can also end up being
farm and ranch.
It was, and also a lot, vacant lot.
What's the definition of residential in this context? That would be
I think he said 1 to 4. Didn't he say 1 to 4?
1 to 4.
is there an intent? This is where if we need that, I wouldn't want to look at specifically what it says, because it could be intent behind it or it could be some use without knowing the actual law. It's hard to
You're unimproved.
say don't put it in.
Yeah.
It's only gonna end up being residential if there's contemplated construction.
Right.
Alone.
Does that satisfy the title?
But if you're giving the notice,
President?
I don't think it falls.
yeah, because if you give them the notice and then they don't need it, they had the notice anyway.
Right. I like it though.
And so then in the paragraphs or the contracts that only have no subsections now, it would be A and B. And at least I know the farm ranch has A and B already, so this would be C.
Yes, that provides for the future.
All right, we're gonna go with that and see how that looks.
And this gives us an opportunity, knowing we did this at the end of the day and stuff. I think we came up with a good solution, but we will be back before this gets pushed forward. So we can all be a subcommittee of 13, subcommittees of 1 to think about this before the next time when we come in. There's a better.
So nothing will be proposed till February.
Correct. We're pulling back except for the floodplain notice and the lease plan.
So we're talking about proposal in February.
Releases.
At the earliest, yeah.
Huh?
At the earliest.
At the earliest, okay. So does that mean our January meeting is gonna be longer, like 2 days?
And that's our last agenda item, is to look at that. And I think it would make sense to block out 2 days, not with that we have to go 2 days. But to at least block it out because of the number of changes that we have here. Currently, we have January 9th. So that's a Friday, so it would be the 8th and 9th. Is that okay facilities wise?
That would prevent it. Sometimes Amber will chat me frantically during the portion of the meeting, but I haven't gotten anything yet.
What day are we talking about?
Looks open.
January.
January 8th.
So we're not meeting in November.
No, that would be
Okay.
agreed to push. That'd be too quick to turn that around.
A 2-day. If we need it, right?
If we need it. So we definitely on the 8th. And do we, just thinking this through, standard start time of 9 to do, and that way if we can't keep it in one day, I guess it'd be hard to just think of logistically hotel rooms and such that we won't know until the afternoon. So we're kind of booked in for the second day for those that are booking hotel rooms.
I have a conflict in the morning on the 8th, but
It'll be dark and driving.
Book us
Conflict
in the
Wednesday and Thursday nights.
Wednesday?
Yeah.
Okay.
8th.
8th and the 9th of January.
You could also do midday Thursday.
That's what I was
Coming
kind of
early.
thinking that through to then we drive in. That way, you only have one hotel room
That would work.
regardless,
Start at 1.
and that would almost push us to second day for sure. And I'm fine with that. I think that way we limit expenses and
So come in on Thursday when? At 1?
think that through. I think that'd be good. So we had the afternoon and the day set. I guess that, you think that's okay, or you start?
We can go all night.
Well, if you drive in Thursday morning, how effective are we gonna be Thursday afternoon after driving 4 hours? Or flying in, I don't know. It's not better to plan.
Ask me my experience.
Not make it 8-10 hour day. I don't, I mean, whatever Jimmy decides, fine.
Any strong opinions on it?
Then do a half day and then a
So
long
let's
day.
plan on let's just do that. Let's do an all day Thursday, and then if we have to go home and it's the expense of a hotel room for a night that we're incurring, it's okay. Okay, so we'll
So 8 o'clock, 9 o'clock Thursday.
9 o'clock. Let's do 9 o'clock Thursday, and then we knock it out. Yeah, it's good. And this is someone who filling it out, and it's what's reasonable and works. And I didn't look online. Darlene and Kristen, does that work for you? Good. Okay.
Yes.
All right. The minutes.
And read them carefully.
Do y'all read those or do you need?
Yes.
Is that how Kristen spells her? Kristen, it's
Oh, A.
No.
It's
I think I called it a Rello, so that's right.
Yeah, Arello. No, I
Kristen
shouldn't.
is E-N.
Ian.
And then on my last name, it should be M-A-N-N, Lynn's with it.
M,
Yeah,
like a man?
yes, sir.
Okay.
And you have to correct him up at the top paragraph too.
Oh, up here, yeah.
And am I pronouncing that correctly? Lynn's Lund?
Without the U's.
Okay.
Is it vowel or vowels?
Oh, no, most people, yeah.
Is vowel
Hi.
just LL or with an S?
VALL is all it shows on the Trek website. Assuming Trek is correct. And I would assume they're correct.
We just copied it from the appointment.
There we go.
So student of state bar is correct.
Let me know when you're
There
doing
we go.
Good.
Ryan's gonna let us put whatever we want in the minutes, so that's great. Let's make changes quickly.
Did you fix Candy's name in the first paragraph too?
Yes.
Two places.
Yes. Oh, on the correction, let me check.
Do we add the subcommittee later on the
For where?
So I think with the three things we have on the subcommittees, paragraph 21, paragraph 22, and the backup addendum, possible earnest money receipt page, or where to put that.
Okay, so paragraph 22, committee referred it to the task to a working group. I didn't put who was on the working group.
But I think what he's saying is maybe to put that under B as well, because the backup addendum and the receipt would also go under that same working group.
Right. Yeah. So we have three things under that working group.
Okay. I didn't.
On C, Ron, on
Mhm.
C, should it say the committee decided to defer paragraph 8B for review at its next meeting rather than delete?
I think we.
I think we
Or do we decide to just delete it?
Yeah,
We decided to delete it.
Got it. Okay.
Now that we made that after the deciding that we're going to wait on the contracts, push them through. So
Have we said that yet? Or somewhere along the line in our minutes?
not yet.
Okay.
Let's see.
Oh, we already got an invite.
She's incredible.
She's fast.
Wow.
Should it say that the committee deferred the task to the same working group? It sounds like there's two working groups.
Yeah.
And we're doing 21 and 22?
Mm-hmm.
And anything else they decide before 5 o'clock?
No. I haven't even got started on sub agency yet, so he's gonna. So we have until about 9 o'clock. Right?
Wait. No, go back up.
Yeah, you gotta
Go.
discuss that.
Go back where you were. I think we messed that one up. The committee decided to defer
No.
consideration of reorganization of paragraph 22.
And that's to the same working group that was doing what? The backup.
The backup addendum. And then we're also going to do paragraph 21, which I don't know that you have that farther down. You might, I don't know.
Okay, so then let's go see. So is this one an referring group or we just deferred on the lease?
Mm-hmm.
Well, I think on F, it's not a separate addendum, but maybe adding that to the
To make it
existing one.
addendum for sale or lease of other property.
Creating or modifying addendum.
For buyer to also to sell or lease another property.
Well, it's either create or modify.
Well, but committee deferred discussions about creating or modifying an addendum for a contingency for buyer to lease another property owned by,
The buyer.
or is it lease or sell? Talking about the existing, what we're modifying, what there's an existing create or modify, whatever. I don't care right now.
Our energy wanes in the afternoon.
Yeah.
Oh my gosh, and then with a 3.5 hour drive ahead. Jeez. I'm spoiled. My cousin's usually in town.
Oh, that's right. You're not staying over.
No. I'm telling her how much I appreciate her.
I like that. That C is good. That fees and deposits. I think that was really good for us today.
Oh, definitely, I agree. Going through that.
They decided not to expand.
Well, that's actually part of the, I think, in the subcommittee as far as the receipts.
The receipts, okay.
So we did decide to expand the 1031 tax exchange addendum?
No, it's
Not-
a, it's not.
Not to not.
Okay, I need to get closer to the screen.
That's why I sit next to Ron.
Are you going to go this way?
I'm a smart girl.
Oh, I can read over your shoulder all day long. Yeah.
Um, Proper for innovation really wouldn't be the right term there, right? So they're trying to revive. It wouldn't be innovation if it was.
Reinstate.
Which I think is innovation.
Innovation's all it is.
I know. I have to go back to my old case law. Look.
Dust off the property book. The contracts.
I'll send you the ovation case right now.
Do we need to say as a new, just generally a new subparagraph, since we're adding it to all the contracts? It won't always be 20B.
Yes.
Yeah, I usually just refer to the 1 to 4 when I'm referring to these forms. But I think it's 20 in all the forms, isn't it?
It's 20 in all the forms, and we have but farm and ranch would be C instead of B.
Okay.
And what?
There we go.
Yeah, that's perfect.
Yeah, that takes care of the issue.
So this is a little bit out, but it was a separate agenda item, number 5. So it is kind of out of order. If you want me to go chronologically, I can.
I think it's.
This makes things easier to follow. This is good.
We need to add the brief case law discussion we had.
The
And we're meeting at 9 a.m. on January.
9
You're
a.m.
obviously better in the morning.
My favorite was the signing electronically, and you don't know what you're signing.
Oh, that case was, I thought that's one we were going to discuss about the whole release of earnest money thing.
Yeah.
It was very interesting.
Yeah,
The parts I understood about, yeah,
we can bring
That
that
it
up
was
at
a
the next
mistake.
meeting to go through that.
that it was a
$35,000 mistake.
and the 60,000 in attorney fee.
Imagine being around the family table after that.
Oh, I know. 'Cause that was
Mhm.
their
Their
Son,
son
yeah, son.
was their agent.
yes.
Eighth and ninth, beginning of ninth.
Parents would have fired me.
Okay,
That'll be a
and
fun Thanksgiving day.
yeah, I'll reserve comment after the meeting on that. I'm fine with anybody else, any other changes? Get a motion to approve.
So moved.
It's 418.
Second.
And with 418, we'll adjourn today's meeting.
Thank you.
Ron.
When do we want to?